they are attacked and they even run a risk of being killed. Now that also minimizes the capacity of the state to fight corruption. What additional measures do you think can be put in place to ensure the protection of the whistleblowers, which will in hindsight then also assist by getting a lot of them to come into the fold and expose corruption when it's done?
Okay. Honorable, if you have to look at my questionnaire, it's one of the issues that I raised in that case. More instances, there has been situations where at the time when I was at the office, we were able to protect the whistleblowers in terms of losing their jobs. For instance, we had a case, a SASA case, where an employee was dismissed, but he got her job back. I can count about 3 or 4 instances where the office intervened and it lost. Then it comes to the question that you have mentioned in terms of protection of the whistleblowers, in terms of their lives, because we are a violent country. But I feel that we should change our laws and strengthen our laws relating to the protection of whistleblowers. I'm not a fan of the United States, but in the United States, they have a very, very strong laws in terms of the protection of the whistleblowers. We have an instance where, because it's a vast country, they can move these people to a number of states, but the most important thing, they can change the identity, the name, the ID number, and everything of a whistleblower just to protect the whistleblower, of which we're still far from getting to it. So making those changes in our country, in fact, you will see that the most important cases on whistleblowing or on fighting corruption is when the wife is the whistleblower or a certain employee is the whistleblower. Then we have been able to win and fight corruption in that instances. But there is a price to pay. So the protection of whistleblower is very critical in terms of being able even to change the identity of the whistleblower. In fact, we have seen, because of the corruption we have in the police, that sometimes even the safe houses has not worked. Some of the whistleblowers have been killed in the safe houses because somehow our law enforcement has been involved in some of these instances. So we have to change the laws and strengthen those aspects. Thank you, Honorable.
Still have 15 seconds. Okay. No, thanks. You know, when I was laughing is because you are saying you are not a fan of the United States. Yes, you mentioned it twice now already. Of course, you were trying to make your point, which is acceptable. Now, you are in the interview not for the public protector, but for the deputy public protector.
Yes.
We have spoken about how the public protector has been able to make the office to be visible, of course, working with the team and so forth. Do you think that the deputy public protector should have the direct responsibilities which are also aimed at assisting the work of the office? And what do you think can be the impact of that if it's to be considered as the situation, as the intervention?
I would not like to have such intervention because, to use the term that has been, we may have a situation where we unintentionally create 2 centers of power. The deputy public protector reports to the public protector, and at the end, the public protector is still like an executive authority. So definitely, I think the situation as it stands should remain as it is, that the deputy reports to the public protector and will have the powers delegated to him or her by the public protector at the end. So basically, as I mentioned earlier on about this office growing its own timbers, that in terms of succession planning, it will be very critical for this committee to ensure that the deputy public protector is groomed at least for the next, based on what have happened previously in terms of Section 184. Now the office seems to be stabilized because of the fact that the public protector is the deputy and has then getting your timber from the bush to make him the public protector. So I believe that in terms of good succession planning, it's very critical that the committee gets somebody as a public protector is being groomed to be the next public protector in line with the best entities in this world. There's proper succession planning in that. So.
It's 2 minutes. I mean, my 2 seconds. I did 13 seconds ago. Now, in that regard, that which you have just mentioned now, on grooming a succession, obviously, when you deal with questions of a succession, age becomes a matter because you still have to get people who are energetic enough to attend to their responsibilities. Do you think that argument supports the fact that you must be appointed as a deputy public protector?
Yes, I'll definitely believe that in terms of the wisdom that I have now and the fact that I have so much wisdom that I've carried over the years that can be able to put up the question of the of succession in that. I will be able to.
Thank you.
Yes.
You see, Honorable Nomvalo, what you did. You started looting minutes yesterday, and Honorable Tsotes is doing the same now. It's a legacy, Chief, of looting. Honorable Watau.
Thanks, Chair. Good morning, Chair. Good morning, members. Good morning, Mr. Mtetwa.
Good morning, Honorable.
Mr. Mtetwa, in your view, looking at the mandate of the public protector, is there possibility for overlapping of functions with other state institutions such as Public Service Commission and Special Investigating Unit? If so, how can this be avoided?
Okay.
My second question will be, what is your understanding of what it means to be an anti-corruption champion?
Yes, definitely there has been a number of, I'll say, overlaps in terms of the mandate of the public protector, more so with the Human Rights Commission, with the anti-corruption mandate that it have, and of course with the asset forfeiture units and or even the Hawks as it is called now. Even now at the military ombud, because of this remedial action of the public protector, we had instances where we had investigated the issues brought to us by the soldiers in terms of the mandate of the military ombuds. And we make a recommendation of which we give it to the minister for the implementation. And the minister does not implement. And the soldier will then go to the public protector because they believe that the public protector's remedial action is enforceable. And then that creates a problem. To solve that situation, we have negotiated with the public protector an MOU, which I think they can also have that type of a memorandum of understanding with other entities as well, to ensure that how they handle cases that they overlap in their mandate. For instance, we had an issue currently at Enoch and Kichima municipality relating to Ndlovukazi Stadium, where both the public protector and the Hawks have been investigating this case. Although the public protector has completed, but they have not issued the report, or they are reluctant to issue the report until the Hawks have issued their own. But if there has been a clear memorandum of understanding in terms of how they joined forces in terms of sorting out this type of instances. Like for instance, with the military ombud, we have agreed, we still have to, we had the previous MOU that has expired. We're negotiating with the current public protector, the new MOU, whereby when the soldiers go to them, of course, even before coming out, they say, by the way, they refer them to us as the military ombud. So the MOU and the negotiation and joining forces is very critical in terms of overlapping of mandates of this nature, Honorable. What was the second one? Being an anti-corruption buster. I'll say the drafters of the Constitution wanted to cast the net wide in terms of cutting corruption, that they even gave the public protector these anti-corruption measures as seen in the Prevention and Combating of Corrupt Activities Act, in terms of what the public protector is expected to do. But again, I will say the MOU, because it's not only the public protector, it also gives the Hawks the powers to investigate as well. So the MOU between these parties are very, very critical.
In your view, Mr. Mthethwa, what can you identify as challenges or risks that are facing the current office of the public protector? Okay. And what are your suggestions to mitigate those?
The major risk, of course, was the unintended consequences of the EFFDA against the Speaker of the National Assembly judgment in the Constitutional Court, where the court ruled that of the binding effect of the remedial action of the public protector. It's a major risk in the sense that every government department, every entity that is being ordered will takes the office or takes the report on review, because the court has ruled that this should be the remedial action is binding unless set aside by the court of law. So each and every person or entity takes the public protector and review, and the cost, the legal cost, has so much skyrocketed. I definitely believe that what should be we should look at the amendment of the State Attorneys Act, which created the office of the Solicitor General. In the meantime, that any state entity in all spheres of government should use the state attorney. I've seen that the audit, the Solicitor General has done so much. So we have seen some of the bad state attorneys being moved away, and then to ensure that the costs are reduced, somehow we rely on the state attorney to defend those actions, and we create within the office, more so in the Pretoria office of the state attorney, we create a specialized unit, constitutional unit within the office of the state attorney, which of course this house, this committee can be able to ask the Solicitor General if he presents to create that. Sometimes the public protector will definitely brief one counsel every time because they think he's a constitutional expert in that particular case. But in the case of the public protector, they have come up with a list of attorneys and advocates that they present them. But if we're to run the state attorney, we have people employed by the state to protect the office and to ensure that we rely on them. If I may mention another thing, I know we have not counted these questions, but at the time when I feel that I should, okay.
Okay, I'm not cutting you. I'm trying to save my 2 seconds that is left. My last question will be, how can
Where did
the
you get
public
these 2
protector...
minutes you're saying it's left?
Oh, okay. My time is finished.
Okay, now you can proceed. Take the last question.
All right. Thanks, Chair. How can the Public Protector South Africa work more proactive to ensure that good governance is implemented or enforced through the public service?
I believe that the good governance through the public purposes should rest around the current government initiative of professionalizing the public service. If you look at, I'll mention our former colonial powers, like in the United Kingdom, they've professionalized the public services, whether it's the Conservative Party that is in power, the Labour Party, the public service remains intact because they are regarded as public servants. Here, when there's been a change of government, the first thing that people want, that the political parties, is to remove the DG to put their own. Definitely that, or sometimes the DG knows that in a year's time, I will definitely be out of work. And then what happens is that there's corruption going on because the public service is not professionalized. So the most important is that the Office of the Public Auditor in its report should ensure that the professionalization of the public services in this country gets paramount. That will ensure that at least you have public servants who are career public servants, that will definitely not depend on their political powers. So that's very, very critical. In America, it's different because the economy in that country, and I've already said I'm not the fan, but the economy in that country can adopt to find that when the Democratic takes over from the Republican, they can change the entire legal services, including the Chief Justice at will, because of course the economy can absorb. But I still believe that the UK system for us is more critical. They always say that a public servant in that country belongs to the crown, is an employee of the crown, so it's untouchable. So we should learn from that and professionalize the public service to ensure good governance.
Thank you.
Good morning, Mr. Mtetwa.
Good morning.
How are you doing, Yambos?
Oh, I'm doing well. Thank you so
I'm
much.
doing good
Honorable.
as well.
Yes.
Are you an objective, impartial, and independent person?
Yes, very much so. I'll say
Okay.
very much so.
What would you do in the event where the public protector engages in a conduct which is in conflict with the Constitution, or where she makes findings which are not in line with the Constitution? What will be your immediate reaction?
My immediate reaction is to eventually remind the public protector about the vision and mission of the office. In fact, you're asking me the question of which I have been there as the CEO of the public protector. When I was the CEO of the public protector at the time, I will not mention the name of the public protector, at the end of the term, because the terms and conditions of the public protector are similar to the judge of the appeal court. So among the terms and conditions of the public protector is that during the term, she or he must take a sabbatical leave of which is paid for at the time. So if the terms and conditions at the time, I'm not sure by now, also stipulated that if the public protector does not take the sabbatical leave, he cannot claim to be paid for it at the end of her term in the gratuity. So as the public protector at the time, that public protector at the end of his term wanted me to sign and authorize the payment of that sabbatical leave pay, of which I refused. I knew that it will invite consequences.
Just keep your answers short because
Sure, yeah.
I've got a couple of questions,
Okay,
and
so-
there's time limitation.
Okay.
Now, in the event where the public protector, and my question is mostly related to the investigations and reports,
Okay.
not on operational issues.
Okay.
Now, in the event where the public protector is adamant, even after she has received your advice, and continues to engage, continues to be in conflict with the Constitution, ipso facto, what will be your reaction?
Okay, what is good now is that currently we had what they call the think tank of the public protector. In fact, they've taken it further, that they have what they call it the full bench. So the report of the public protector are not the individual reports of the public protector. They get presented to the full bench, which comprises of the executive managers and the provincial of the office of the public protector. Definitely they vote in terms of saying this is the case. So if I'm part of that full bench, I will definitely raise my objection, or even coming up with a minority judgment in terms of my objection, get it recorded as such.
All right. I just want, as a person who have been there, you have been there, so you've got some experience.
Yes.
Now, the public protector writes a report about an issue which is in the public domain and which is of public interest. That there was no wrongdoing in the Pala matter. There were dollars under mattress to which the president, considered. And the report is that no, there's no wrongdoing. The president must sleep a peaceful night. So what is your take on that in terms of the legal position? Was the public protector in line with the existing legislations which relate to that effect?
Okay, I'll definitely, that's good because that's contemporary. Out there, people think that that was the report, but that report was not the public protector sitting in her own corner and writing that report. It was a report that went through various quality measures from the think tank up to the full bench.
No. Wait.
Yes.
I understand the processes.
Okay.
What I'm asking here is the findings. What is your reaction? What is your take on the findings that there is no wrongdoing on the Pala matter? Not the processes. I understand that. Don't tell me something that I know.
Okay. So definitely, my take will be that if the issue of corruption, my view is that the police are investigating that particular case in terms of whether there has been wrongdoing in terms of the dollars that were found in the office of the public protector.
No, Dr. Mtetu, you are not doing justice to my question. I'm not asking about the police. I'm asking about the findings which were made by the public protector, that there is no wrongdoing on the Pala's issue. What is your take on? Are you scared of being objective?
No, I am being objective. I'm saying that obviously the complaint that the public protector looked at was the issue of any wrongdoing on the part of the president. But what happened was that the police reported the matter, and then there's been issues where the people have been charged in terms of that robbery.
Well, I think we're not making any progress on this one.
Yeah,
And my
and your
conclusion
time
is
is
that
up.
we are being evasive. Then the last question, I see in your interview that you were once the chief executive officer in the public protector's office.
Yes.
How many investigations were assigned to you?
In fact, as the chief executive officer, I'm involved more on the operational aspect of the office in terms of the PFMA and everything. But I will definitely sit in some of the investigation and the think tanks and to show this.
So you've never conducted any investigation?
Personal, not myself, but in terms of the quality assurance, yes.
So
Maybe you
it's
should
never
explain.
conducted
Sorry,
any-
sorry, Mr. Nomvalo, your time is up. You've been abusing this time thing. Maybe it's important that you explain that are CEOs involved in net investigations? Just to be fair to the question of Honorable Nomvalo. Mr. Mteto.
Thank you, Honorable, for protection. Basically, what's the mandate of the public, of the chief executive is in line with the PFMA to ensure that there is a clean audit report and that the resources are provided to the office. But with my background as an attorney and everything, I'll definitely sit in some of the quality assurances of the reports to see to it that is it in line with the mandate of the office? Is the investigator not going astray in terms of not following the mandate in there?
Okay, thank you.
All right, thank you very much.
Thank you, Mr. Nomvalo. Let's go to the quality assurance
Yes.
part. Let's go back to Palapal. I want us to go back to Palapal.
Yes.
Does the Public Protector South Africa have jurisdiction over private matters?
It depends. For instance, if the complaint, for instance, in terms of the Members Ethics Act, relates to the members of the assembly, and then a member of the assembly has complained to the public protector in terms of the code of conduct of the members, in terms of the declaration, for instance, the public protector has authority to look in those. In that instances, yes, if there's been a complaint by a member of the National Assembly in terms of the code that there were this man that was not declared in Parliament by executive, yes, the public protector has the mandate in terms of those matters.
So it is your submission that the report of the public protector in relation to the Palapala matter is a matter not related to fraud, corruption, money laundering and stuff, but it's a matter relating to the Executive Ethics Act.
Yes.
Is that your submission?
Yes, if it was a complaint by
Okay.
a member in this to the office, yes, it falls within the line of the members' executive ethics.
Thank you. Honorable Engelberg.
Thank you, Mr. Chair. Good morning, Mr. Mtetwa.
Good morning, Honorable Engelbrecht.
So I don't have a lot of questions. I just have a single long question. I want to refer you to the time that you served as CEO at the Public Protector. Now, from media reports that we could gather, there was a complaint dated 19 December 2011 from Public Protector of South Africa employees, but for all intents and purposes, it should probably be regarded as an anonymous complaint because there's no name attached to this. On the 15th of March 2012, in the erstwhile New Age newspaper, an article appeared highlighting this complaint, the contents of this complaint, and there was some very, very serious allegations made there. So serious that the Public Protector made a statement which is available on the Public Protector website to this day, and she had, I believe, a media conference on the same day, on the 15th of March 2012. Now, this was followed by an article that was published on the South African Press Association website on the 19th of March 2012. Now, according to the media reports, this complaint consists of mainly 4 areas. As you, in the previous question, alluded to what is expected of a CEO. This is firstly governance issues, labor issues, criminal matters, and financial management, this complaint. So, not going into details of the content of the media reports, because obviously we are not privy to the actual complaint. I don't know, I couldn't find that. But please tell me, given all of these things and allegations that were made, which I'm sure you know exactly what they were, why you should be considered by this interview panel as a fit and proper individual to occupy the position of Deputy Public Protector.
Okay.
Thanks.
Thank you, Honorable Engelbrecht. When I was appointed at the Office of the Public Protector, we had a situation where the office had received a bad audit report. I had to, as the CEO, I had to come and before SCOPA of this parliament to explain what I will do. That audit report was not as a result of me, but it was the previous operational or whatever the case. But because of the unpleasant situation in the appearance of the public protector, I indicated to them that I have a plan. It related to the asset register that the auditor found that were not in place. So I made sure that within a year of me having been appointed, that I clear, and I made it quite clear that I made it sure that we don't get that qualification again, of which we didn't. By the time I presented to the office of my annual report here, we had got an unqualified audit, of which it was the case going forward. And when I had left, eventually, the public protector eventually got a clean audit. I understand now that it has regressed again, of which pains me, having started the situation of making sure that because the public protector should lead by an example in terms of ensuring that we have good, clean corporate governance. Now that is regressing. It pains me again. So as I was preparing the example, I had to find out again, what is it that has caused it to regret? And I came to the conclusion that the issue of the appointment of attorneys is an issue that has made it to regress again. Hence, I came here and said that the issue of the Solicitor General and the use of the state attorney is what we should in fact look at it, instead of keeping our own and keep on briefing same attorneys time and again. And I say to Honorable Engelbrecht, because of the background I have on the public protector, then I should be able to be appointed to this position. I'm not sure about the press reports you've mentioned.
You are running away from the mic now.
I cannot answer those unless I know what were the allegations. If they relate to me, I can answer them. But if they're general, I can't remember what were those.
Thank you.
It's 2012, I think. Yes.
Honorable Glover.
Thank you, Chairperson, and good day, Mr. Mtetwa. Hope you're well. Mr. Mtetwa, to understand good governance and exemplary judgments and just of character for this position that you're applying for, I do want to ask a few questions. It's going to be quite voluminous, so just if you can just maybe make a note. In 2013 to 2014, you made decisions to employ certain individuals from Crisco Skills Development to assist the CFO at that time. You didn't follow CSM procedures, and it resulted in 212,000 odd irregular expenditure. I would like to just know your reasoning behind this, as you said you are well versed in the PMFA. At the same time, the PPSA was engaged in trying to reduce the backlog of critical cases and so forth. And a large amount of money was made available by the Treasurer at that time. I think it was 10 million. Out of that, I don't think it led anywhere. There was not a single case that was able to be used, if I understand it correctly. You also then appointed Crisco Skills Development yet again. Now, I would like to know, did they qualify to be on this panel? And if not, can you explain it? I would like to go further and to understand that there was also written off debt of 13.6 million. Nambiti Technologies that created software and that never met the PPSA standards, and that money was written off. So I just want to understand your reasoning in the appointments and so forth. The last two questions I have, I'd just like to understand something, because I did read through your application and also reading through media reports and so forth and doing our investigation. You were placed under investigation by Salgo, if I understand correctly, and correct me if I'm wrong. You were also then suspended, according to the same media reports from the PPSA, under Lawrence, I think. I'm not sure why you didn't disclose this in this. And maybe, as I said, maybe I do understand it incorrectly, and you can correct me. And then I would just like to know, lastly, why your contract as Ombudsman was terminated at UKZN. If you could just explain that to me. Thank you very much.
Okay. With regard to the question that you raised at the public protector, you mentioned Lawrence Mushwana. At the time, in my case here, I mentioned the issue of the Honorable Gloper of the sabbatical leave, of which I mentioned that in terms of the public protector payments, in terms of the, I would say it's the terms and conditions of the appointment of the public protector, that the public protector has to take the sabbatical leave. In that case, Lawrence Mshwana had not taken that leave, and he wanted me to sign for him to be paid for that leave, of which I refused. In terms of the PFA as an accounting officer, if you face with such a situation, you have to ask the executive authority to give that instruction in writing, and then I have to give it to the Auditor General before I act, of which it did not happen. And what eventually happened, he suspended me and appointed somebody to act, to actually sign that, that payment. I think it was one day, and the new public protector came in and reinstated me. And the reason I did not disclose that is because you suspend a person with a view of ensuring that there's a disciplinary action. There was no disciplinary action. The new public protector reinstated me within that day. And more important for this house, that sabbatical leave payment that was paid back was paid to that public protector you just mentioned, was actually deducted by the Auditor General, and the money was paid back to the fiscus. I actually, by being independent and impartial, and even putting my job on the line in order to do the best, I did that without fear, favor, or prejudice, because I had confidence in the legal system of this country. I didn't have to go to court. It took the new public protector to see that I had to be reinstated, and nothing was, I then finished my term at the office of the public protector. You also asked about the UKZN. I actually resigned from the UKZN because at the time there was COVID. In fact, the reason I applied for that job, I felt that Judge Yakub, Judge Paslanga were there. But when I was in there, it was, you had to bill the university in terms of the work that you have done. And then during COVID, there was no work that was coming through. Then I formally resigned at the university, and then took over and came to the military ombuds.
Thank you.
Do I have time? I don't know.
You can do the last one.
I just want to find, are you saying that you were not investigated by Salgo?
At Salga, again, I resigned in that instances when I had, because I had to got a job from the, I think it was the Department of Minerals and Energy in that particular instance.
So you're saying no?
Yeah, no, yes.
Thank you.
Thank you. A quick follow-up.
Yes,
You resigned from UKZN,
yes,
you resigned from SALGA,
yes.
you resigned from the Public Protector South Africa.
Public Process South Africa, I completed my 5-year term.
You didn't resign.
No.
Okay. Did you make your research when come here?
Beg your pardon, Honorable.
Did you research?
The what?
Did you research?
Did I research?
In your way of preparing for the interviews, did you research?
Yes, I did. I did.
Okay. What is the budget of the Public Protector South Africa in the financial year 2024-2025?
Yes.
What is the budget? We want the exact amount.
I did research, but I didn't look at the budget now, but I looked at the regression in terms of, of qualification, not on the money.
Let's leave the audit opinion.
Yes.
We're
audit
talking about the
opinion.
budget
Yes.
that is passed by Parliament.
Yes.
So let's take it that you don't know the budget of the Public Protector South Africa for the financial year 2024-2025. Let's go to the second question.
Okay.
What is your understanding of the fit and the proper person? And why do you think that you are a fit and a proper person?
My understanding of the fit and the proper person is that it's a person that is beyond reproach. And Honorable Mwala, I think I am that person, that I'm fit and proper in terms of being a deputy public protector.
Okay. What is your understanding of the rule of law?
Of the
rule of law.
The role of
Rule of law.
law.
Law, umthetho,
Oh, the
nyambosi.
rule of law. Okay.
Yeah.
Okay.
The rule of law.
Okay.
What is your understanding of the concept, the rule of law?
The concept of the rule of law relates to the following of the law as it stands. We have had instances in this country where the rule of law has not been observed. I'll give examples. In the 1950s, we had what is called the constitutional crisis, when the National Party has taken over in 1948, and it removed the people from the Cape, the so-called colored people from the voters' roll. In fact, that voters' roll was entrenched in the South African Act of 1910, which was the law of the United Kingdom. Now, the National Party at the time felt that to have the colored vote in the voters' roll will create problems. It will swing their vote for the United Party, and they unilaterally remove that from the voters' roll without having get the majority, in terms of like a 2/3 majority. So that was against the rule of law, because they had to do that in order to achieve the political.
It's fine, Yamos.
Okay,
I
sure.
see you're going to UK, you're going to the voters' roll.
Okay.
I was looking for the supremacy
Yeah.
of law, but it's fine.
Okay.
What is your understanding of the principle of legality? And what is the dialectical relationship between the principle of legality and the rule of law?
In a way, sometimes it's used interrelated, because legality is that everything has to be legal, should be done within the confines of the law. That's basically what it means, Honorable.
Okay.
The rule of legality.
You say you were a CEO
Yes,
during the tenure of Professor Thuli Madonza.
yes,
And that is the period where the enforceability of the remedial actions was actually a key thing. Can you take us through that? Yesterday we had the Human Rights Commission,
Yes.
and we have made an example of the Public Protector of South Africa and enforceability of its remedial actions and how it came about. Can you take us through that?
Yes, let me take you through that. First of all, let's go through to the issue of the ombudsmanship, where it started roundabout in Sweden. It's a term that came from the Scandinavian countries in Sweden. Normally, what has been the case has been that the issue of the ombudsman is a Swedish term, which means the defender of the people. What has happened in those countries was that the ombudsman normally is a person of great stature, sometimes a former minister. The issue there is that the ombuds use persuasive powers for its recommendations not to be enforceable. And then the government or any institution will definitely agree with what the ombudsman has recommended. And just because of the way it has been. That has always been the case through and through. So during that term, my view was different. I know that the public protector at that time felt that the office, the decision is binding. And my view, based on the way that we have looked at the ombudsmanship, where it originated in Sweden, was that basically it's a wise man who is persuasive, who comes and persuade the government to actually take in the recommendation. And we even look at closer to home. Among the vendor-speaking people in South Africa, we had the issue of Makadzi. Makadzi was like an advisor to the king, who will definitely advise and tell the king that your people are not happy with this and this and this, so please correct this, which was being the case. But then I will then go back to the issue of the certification, Honorable Ngoma. In the certification, the certification of the Constitution, that's when the court ruled that we call it the public protector for a reason. It's not an ombudsman, it's not an advocate general as it was the case before. And it dealt deeply on the issue of the remedial action. And then it goes to the issue of the enforceability of the remedial action. In fact, even now, as we look at the African Ombudsman and mediation, they are more interested to know how come is the ombuds decision in South Africa binding in terms of its decision. But the issue is that our constitution is captured differently from any other in terms of that remedial action. The court, the majority judgment in that court was of the view that the remedial action is in fact binding until
Which case was that, Nyembos?
that I'm
At least you are coming back now.
Yeah,
I heard you were in Sweden, you went to UK.
I don't want to
Which case was that?
I don't
That
want to-
cemented
I don't
the
want-
enforceability
I
of
don't-
the remedial actions.
Yes,
Which
Honorable-
case is it?
I don't want to refer to as Nkandla case, although
It
in
is.
the it's called Nkandla case,
Okay,
but it's basically
fine, Nyembos, let's leave it there.
Okay,
That's
thank
where
you.
I wanted
Yes,
you to go, to the
Yes.
Ngandla judgment.
yes,
You went to Sweden, went to UK. I think you're an internationalist. But it's good to benchmark. It's good.
Yes,
It's quite good to benchmark. I'm going to ask you 3 questions as a last question.
okay,
We're going to answer them at once.
okay.
The public protector issued okay, let me start this way. The country today has got a crisis of gender-based violence and femicide. The public protector issued a report on what they term systematic investigation into administrative deficiencies relating to GBV within the South African justice system. What do you make of that report? And how do you think that the Public Protector South Africa as an institution should contribute to the fight against gender-based violence?
Yes.
How do you think that we need to enhance access to the office of the Public Protector and the institution of the Public Protector? How do you think that the Public Protector South Africa should deal with case backlogs and improve investigations?
Okay. Thanks. I'll definitely start with this one in particular, because I mentioned in the questionnaire that the chair sent to me as one of the issues that is problematic in this country. But soon after having sent my thing, the South African Science Research Commission released the study that almost 3 women in South Africa have been part of gender-based violence. It is a problem in the country. And then my view is that the Public Protector, working with another Chapter 9 institution, the Commission of Gender Equality, should ensure that, in fact, we work hand in hand in ensuring that we get rid of this gender-based violence by educating young men and women in terms of parity, and to avoid gender-based, which is basically more masculinity than anything else, to ensure that we deal with the issues of gender-based violence. We have found that in some instances, the doctors that treat the women that have been injured during home-based gender violence, and the women don't even go and report that. And I've said that we should amend the legislation that even at the treatment at hospital or at clinics, the medical practitioners should be forced to report to the police the gender-based violence that comes to the hospital in order to deal with this. So the Public Protector definitely has to make recommendation in terms of the legislation to counter gender-based violence going forward. We had an instances where a neighbor, there was a duty even on the neighbor to report the issue of gender-based violence that he hears happening on the site, but that has not been being followed. So I raised the issue of reporting gender-based violence in that instances. In my questionnaire, Honorable Ngola, I even mentioned that we have instances where it happens at home, and you find out that eventually the victim of gender-based goes and withdraws that case, although we have done so much in terms of protection orders, but between those closed doors, the police are not there. It happens. And then you find out that the cases are withdrawn. I've made a suggestion that one of the things is the amendment of the law to ensure that once a gender-based case has been opened, the victim should not be able to withdraw the case except with the permission of the National Director of Public Prosecution. And it's one of the things that the Public Protector needs to recommend and show on the amendments to deal with it, because that's what we see in there. And of course, to get the police force trained, I know we have run away from specialization in terms, at some stage we had a children protection unit, of which we dealt with. When you go to the police station, sometimes you see a desk written gender-based desk to report, but there's nobody sitting there, or there's no trained officer that is able to deal with that particular instances. That's how I see the Public Protector playing a major role, because it's something that is causing pain to the country. More so that if you look at the report that has been released by the Human Sciences Research Council, I think it was yesterday, it deals with this when you say that if I look at the committee here, basically the majority of the committees are women. Basically, if I will say 3 of the women probably in here have been victims of gender-based violence. So
I think you have made a point on that GBV issue.
Thank you. Thank you,
Yeah.
Honorable Ngola.
Thank you very much.
Thank you.
I think you emphasized more on GBV and really did not go to issues of access, to issues of case backlogs, and to issues of enhancing and empowering investigations. But it's fine. We are out of time now.
Okay,
We wish to thank you
okay, thank you.
very much for coming and availing yourself to come and do interviews. But want to thank you as the committee, particularly on you wanting to come and contribute towards the operations of the Public Protector South Africa. You would have been there before. You want to come and help. You have been able to detail the challenges faced, so you want to come and help. So the committee will have its own meeting and deliberate amongst committee members on the interviews of all candidates. We'll let you know. Thank you very much, Mr. Mtetwa, and we wish you a safe travel back home.
Thank you so much, Honorable Ngola and the honorable members. This is to be called in. It's not something I take for granted. I want to say I thank the committee for having confidence to call me and to engage them in this, and I thank you them so much. Thank you.
Thank you very much,
Appreciate the opportunity.
and goodbye.
Thank you.
Let's get the next candidate. Honorable Mvalo.
No, Chair, I just want to raise one issue. The issue of time, your inconsistency. Yourself and Honorable Tsotesi seem to be enjoying more privileges in this interview. You are more dominant. And with us, we are very strict. Like yesterday, during the first interview, you can go to YouTube. You had interrupted, you had stopped me when I'd spent 4 minutes, 50 seconds. It's there. And Honorable Tsotesi would ask question for 10 minutes. So please be consistent and treat all members of the committee equally, please.
You are not the one who's supposed to complain.
No, but
You know, the
you are
people
very
who
quick
can
to cut
complain
me.
here is Honorable Dena, Honorable Motaung, and Honorable Klopper. Yourself, you have been looting minutes right through since we started. But it's fine. Point taken, Mr. Noval. Yeah, and that one of Tsotesi is following you on the looting arrangement. Okay, let's get back at 10:30. Committee Secretary, can we get the next candidate? Can we get the next candidate? Raja, just bring the next candidate. Leave the committee secretary. We'll proceed. Bye. Oh, is it? Good morning, Advocate Tebiele. Am I pronouncing your name correctly?
Tebeila.
Tebeila.
Yes.
Okay. How are you?
Good morning, honorable member and honorable members. I'm fine, thanks.
Okay. Today we'll be having a conversation with you. Feel free and relax. It's a conversation about the institution of the public protector. There's water next to you if you happen to need some.
Thank you.
Are you the one who made the declarations in the questionnaire we sent you?
Yes,
Do you confirm that whatever you declared there is true?
yes, I confirm.
Is there anything else you want to declare?
No.
There's nothing else you want to declare. Now, tell us about yourself and why you believe you're the best candidate to fill the vacancy of the Deputy Public Protector. You have 5 minutes to do that.
Okay, Shadrach was born in a rural area in Anchabeling in the Limpopo province to a family of 6 children. And unfortunately, when 2 weeks after my 3rd birthday, we lost our mom to cancer. And then my twin brother and I had to be relocated to be under the care of my maternal aunt. And then 4 of my other siblings went to stay with my grandmother. And then I joined my siblings later, 8 years later. And then this may seem irrelevant, but it will be apparent why I'm raising these things. So, as I grew up in poverty, I experienced so much prejudice during my high school and my primary school. And the last year I owned school shoes was when I was in grade 5. And after that, I never owned school shoes and I never had a proper school uniform. So I was always at staff rooms and principal's offices on issues of school uniform, and that I felt is a prejudice to me, because I thought maybe there was a need for protection of my circumstances. And having grew up under those circumstances, I chose to study law so that I can use law as a tool to protect the underprivileged, as I was during my school days. So I enrolled for LLB degree at the University of Limpopo, and then I graduated in 2012, and after which I worked at the Constitutional Court for a year, and then I left to United States to study for Master of Laws on public interest law and policy, because that is where my interest is, public interest law. That is my interest. So, and then after I completed my LLM, I came back to South Africa, and then I started working as an advocate since 2014. And from 2014, I've been involved in public interest litigation and cases involving maladministration in government departments. For instance, unlawful appointment of educators and principals, and I litigated in such cases in the High Court, and some of the matters went to the Constitutional Court. So I'm confident that I'm the right candidate because of not only my experience as an advocate in public interest litigation, but also my passion for access to justice. Because I can disclose that in most of my cases, I've done pro bono work because of realization that access to justice is very expensive in South Africa. So I'm an honest person, and I have integrity, and I demonstrated integrity in the sense that I represented the most indigent members of the community who cannot afford legal services, and I don't have any impediment or legal impediment to stop me from practicing as a lawyer. So, and I'm an impartial person and also independent person.
Thank you. Honorable Klopper, we'll start with you this time. Then we'll give Honorable Engelberg, we'll give Honorable Nomvalo, Honorable Mutaung, Honorable Tsotetsi, Honorable Matafa, and Honorable Dena. You can come.
Thank you, Chairperson, and good morning, Advocate Tabela. I would just first like to show appreciation for you sharing your story with us this morning. It's heartwarming, and it's great to see where you are today and giving back to the community in the way that you are. I'd just like to ask you a couple of questions, not many. First of all, do you agree that the delays on these child maintenance issues, those who are responsible for causing those delays should be held directly accountable? Is this something that you would pursue? I know you mentioned it, your child maintenance issues in your application, so is it something that you would pursue?
Yes, and other than that, I think as a form of intervention, I'm thinking that magistrate at some point they should be given powers at least to grant interim orders pending any investigation in cases where maybe there is no dispute on paternity, for instance, where maybe the only issue is the amount and not something which is prejudicial. So I think interim orders may also serve as a form of intervention to assist these kids to have access to.
Wonderful. You've also mentioned education and teachers that are absent from classrooms, and it's obviously taking away time from our children. What specific change would you effect in making sure that those teachers are in class and giving the fair chance to our children to learn the lessons that they need to and what they're entitled to learn?
I think technologically we must advance to a situation where these educators, when they report to duty, that is done electronically, not a physical signature like is done in schools. Maybe if there could be an electronic way of reporting to duty to say at 7 a.m. Maybe you tap something, and then when you leave, you must tap. I think that could somehow contribute to reducing this problem.
Thank you. Honorable Engelberg.
Thank you, Mr. Chair. Good morning, sir.
Morning, Honourable Member.
In your opinion, how would you describe the role of a deputy public protector as opposed to the public protector? What's the dynamics of that relationship, according to your understanding? And then connected to that, how would you act in a situation where there is a fundamental difference of opinion between yourself as the Deputy Public Protector and the Public Protector?
Okay. I think let's start with Section 25(3) of the Public Protector Act, which provides that the Deputy Public Protector has the powers as assigned to by the Public Protector, meaning the Deputy Public Protector will perform functions as designated by the Public Protector. And then it's only in terms of Section 25(4) where the Deputy Public Protector will perform the duties of Public Protector in the absence of the Public Protector. So, as in for where there is a conflict between the Deputy Public Protector and the Public Protector, I think the most viable way is to uphold or use collegiality. Remember, in workplaces, there will always be difference in terms of opinions. So, and everyone will have his or her own opinion. So I think I will sit down with the Public Protector and then we discuss the issue. And if we don't meet minds, there is always a decision maker. And if that is within her jurisdiction to decide, and then she will decide that. But that should be done after having a conversation, a deep conversation on the issues, and outline my views, and then the Public Protector will also advance his or her views, and then the decision at the end of the day must be taken.
Thank you very much. Then just my last question. How do you see the Public Protector's role as an institution? Would you describe it as a passive adjudicator between citizens and the state, or would you have it see it as a more investigative role requiring pro-action in certain circumstances? And please tell us why you see it as that, and how do you think either of the two should be embarked upon?
I think proactive role should be a way, because of the nature of the office, and more importantly, the nature of the complaints which are resolved in that office. So there should be a proactive role to ensure that, most importantly, that investigations are done in accordance with the law, and all the parties involved are given an opportunity to give their views. And that will be also in line with the decision in the matter of Mill and Guardian, where there were discrepancies in relation to the investigations. And then the court was of the view that there was no proper investigations of the evidence presented before by the Public Protector.
Thank you, Honorable Nomvalo.
Good morning, Advocate.
Morning, Honorable Member.
Yeah, maybe as a compliment, what is fascinating to me is the experience that you have acquired so far while we are still very young.
Thank you.
I think that is the most interesting part for me. Now, the question that I have for you is one: do you believe that the Public Protector can be politically influenced?
If there is 700%, I'll say 700%, I believe that it can be influenced by politics, because we have politics everywhere.
Yeah, maybe my question should be like this: in terms of the appointment of the Public Protector and the Deputy Public Protector, in terms of Section 2A of the Public Protector Act, the appointment is done by the President.
Yes,
And the Constitution dictates that the Public Protector must be independent and impartial.
correct.
Is the current order of appointment not a threat to independency and impartiality, in your own view?
No. Okay, the most important part which we must not overlook is the fact that the whole process of appointment is done in public. Everyone is watching the process. And I personally applaud the part of State Security Agency, the vetting process, which candidates must go through. And then the fact that interviews are conducted in open space where members of media are present, for candidates to openly give their views and for everyone to watch.
Okay. The section or the part that talks about the public protector in the Constitution only has 2 clauses. You agree with me, right?
Section
Are you
one-
aware of that?
Section
That it only has
182.
2 clauses.
Section 182.
Yes.
Yes.
In terms of section of that clause, which powers are conferred, to the President in terms of investigating the organs of state? Can you elaborate on that? Are conferred by the Constitution to the Public Protector.
To the public protector.
Yes, in terms of investigating the organs of state and so on.
Okay. What I know is that the public protector is accountable, okay, has a mandate to investigate any conduct within the government departments or public administration, which conduct may pose a threat to or may result in impropriety. And then the most important duty on the public protector is that after investigating the matter, there must be an action, remedial action in the form of remedial action maybe, and then a report to Parliament also on their functions.
All right. Now, let's say one day, because the Act says in the absence of the public protector, let's say you are appointed as the deputy. Now, in her absence, you assume her responsibilities
Yes, in terms of section 25(4).
of the public protector.
Yes.
Now, in the event where she's unfit, for whatever purpose, and then you wake up to news that out of 257 municipalities in South Africa, only 27 have received clean audit. What would be your reaction, and what action would you take as the public protector in that regard?
Okay. Remember, in execution of your duties as the deputy public protector, or even as the public protector, you must act in accordance with the law. So, and you can't just abruptly take decisions. You must be guided by the law. I'll have to apply the law under those circumstances. I can't just give directions or directives without following the proper processes of engagement.
Does the public protector have powers to initiate investigations, having not received any complaint?
In terms of
Can on her own initiate
yes,
investigations?
section 6 gives powers on the public protector to initiate investigations or in the
That-
absence of any complaint.
Okay, the last question is that the scourge of corruption is rife in South Africa. in the presence of these Chapter 9 institutions, which were established, one, to strengthen democracy, but two, to fight corruption, like the Public Protector, Public Protector's Office. Now, where are we getting it wrong? Because we've got all the support, system in terms of the institutions, like this one, the Public Protector's Office. Crime is growing on a day, corruption is growing at the expense of the poor and the taxpayers. It's growing on a day-to-day basis. Where are we getting it wrong? What is your view?
Okay, I think we should not only look at the corruption part of the whole thing. Other factors which play a major role in collapsing of institutions include incompetent appointments, which must also be looked at. I think we should have systems in place to ensure that we appoint competent people in positions of power, and proper trainings also of the appointed, because you may be appointed and then 3 years later there are developments, maybe technological developments, which you must adjust to. Then I think trainings are also important. And the corruption part of it is, I think the way to resolve that is to enhance laws to deal harshly with those who are on the wrong part of the law.
Thank you, Chair.
Thank you, Honorable Mutau.
Thank you, Chair. Good morning, Advocate Sekhame.
Good morning, Honorable Member. Wow, I'm impressed. You pronounce my name the way it is.
Okay, no, thank you
Thank
so
you.
much. Yes. Advocate, in your view, looking at the mandate of the Public Protector, is there possibility for overlapping of functions with other state institutions such as Public Service Commission and SIU? If so, how can this be avoided? And then my second question will be, what do you understand by the meaning of the anti-corruption champion?
Okay.
Yes.
The issue of overlap, I'll just answer that question with reference to South African Human Rights Commission, because it's the most relevant institution which there is a little confusion as to what are the powers and what is the distinction between the public protector, the kind of the cases. So I would say there is not necessarily an overlap between the Office of the Public Protector and the South African Human Rights Commission, but there is a relationship, or there is interrelation in terms of the functions, and I'll explain why. Because there are certain cases which, on the face of them, they fall under the powers or the jurisdiction of the Public Protector, but they have the consequences of involving human rights. For instance, a case of where a municipality is failing to deliver adequate water to the members of the community. That may fall within the domain or the powers of the Public Protector, in the sense that if there is any conduct on the part of the officials which led to the situation, which is unlawful conduct, that should be investigated by the Public Protector. But the lack of access part of it should be referred to the South African Human Rights Commission, because lack of access to water is a violation of a human right. So there is interrelation. So I think the best way is that with the example I've given, if a case of that nature comes to the attention of the public protector, the public protector must also advise that the part of the human rights violation be referred to the Human Rights Commission, because the Human Rights Commission may give a directive that the water be restored immediately without much investigations. But the issue of a conduct should be investigated.
Okay. In your view, or part of your research before you take a decision to apply for this position, what do you think are the challenges or risks that are facing the Office of the Public Protector South Africa? In those challenges, please give us some solutions that you think can assist the office to function more better.
The first challenge is a delay in finalization of the cases. And that is very, very, very important to be resolved, because justice must be done as soon as possible. So my proposal is that in order to ensure that cases are finalized in time, there should be case management. And the case management should not only be at the national or at the head office of the public protector. It should go to the provinces and the regions, where maybe provincial managers and regional managers should serve as case managers and come up with a strategy on how to ensure that investigations are done in time and which cases are old cases, and give turnaround times as to when should the matters be finalized. And another challenge, which may not be necessarily a challenge within the Office of the Public Protector, is access. In the village I come from, not many people know the functions of the public protector, know the mandate. So I think we should extend awareness to the members of public to be aware, and that can be done through radio stations, including public radio stations and community radio stations. I'm mentioning community radio stations because I know there is a slot there, free slot. I've been involved in radio stations where, in cases where they invited me maybe to deal with certain legal questions. And then I can assure you there is a slot there. So if the Office of the Public Protector can make use of radio stations just to make the members of community to be aware of the existence of that office and the work of that office and how to access that office.
Thank you, Honorable Sotetsu.
Thanks. Thanks, and good morning.
Good morning, Honorable Sotetsu.
Sharp. You advocate, you appear to be very young and someone that can assist us to build in terms of succession of the Public Protector's Office. Now, in your view, what do you think would be some innovative initiatives that could assist the Office of the Public Protector to better deliver in its mandate?
So the question again?
I'm saying, in your view, what do you think could be the innovative initiatives that could assist the Office of the Public Protector to better deliver in its mandate?
Yes, I think part of it I did with the most important is that office cannot execute public protector must take advantage of that position.
Now, there is a serious outcry on the part of the whistleblowers in South Africa. There are people who wouldn't participate in whistleblowing activity even if they know the truth. And this is as a result of what they decry as lack of protection and being exposed to dangerous consequence as a result of having blown whistles. What do you think has to be done to improve on the protection of whistleblowers and ensuring that people are at free will to come forth to the office of the public protector to give them, to give out whatever information that they know?
I must, Honorable Member, I must be honest with you. The first time I read Protected Disclosure Act, I got frustrated. What frustrated me is I couldn't find a provision in that act wherein a person, a whistleblower, is allowed to report an incident without disclosing his or her identity. I think that is where we must start. So my view is there should be amendment of Protected Disclosure Act to include a provision where if you want to report an incident as an employee, you can do that without identifying yourself. I think that is major to avoid prejudice on the part of the employees who are willing to report certain incidents. So my view is there should be an amendment of Protected Disclosure Act to include a provision where you can report without revealing your identity as form of protection.
Now, the amendment of the law takes some time. Do you think that in the meantime, nobody must blow a whistle?
No, I'm not saying that, but it is unfortunate the law as it is not adequately protecting the whistleblowers. That is the challenge. And my view is the amendment would be the best approach. Because in the absence of any other law, we are obliged to operate in terms of the present law.
Thank you, Honorable Matafa.
Thank you, Honorable Chair. Advocate Debele Dumelang once again.
Tolerant.
I just have 3 questions, but the first one relates to what Honorable Nomvalo raised about Section 182. The provision that I'm more interested in is on the one of accessibility. You touched on it, but now, given the current situation where budget constraints are a reality, you did indicate about advocacy through radio stations.
Yes.
And maybe also taking advantage of their public mandate obligations that you can use free platforms.
Yes, yes.
I'm just interested to find out what other measures can you implement innovatively to ensure that budget constraints are not a hindrance to the effective functioning of the Public Protector Office. I'll follow up with the other 2. Thank you very much, Chair.
Okay. A very interesting question. I think we should also, that office should also consider alternative dispute resolution method or mechanism in terms of which maybe the office should avoid lengthy investigations which are costly, of course. And maybe in a case of a complaint, they call both parties. Instead of taking the longest route, the matter is mediated, and then and resolved without the lengthy process of investigations. And I believe there are certain cases which can be resolved through mediation instead of the longest route. So mediation may be one of the mechanism to cut costs in terms of investigation part of that office.
Thank you very much for that response. Have you ever been involved in a alternative dispute resolution case? And if you have, can you just share your experience and how you approached it, or how you influenced the process to end at that stage? Thank you, Chair.
It was not a matter of formally being appointed as mediator, but in my practice as an advocate, there are certain cases wherein I was briefed, and I was of the view that this kind of cases should not be resolved through court processes, and mediation should be the best way. I'll give you an example of, I think 4 years ago, there was a case wherein the two families, the deceased was a man with 2 wives, but the other one was married in terms of the customary marriage after the civil marriage. And that marriage automatically, in terms of the recognition of civil customary marriage, is unlawful and invalid. So, but my view was, we have this woman with kids, and the family knows about her. Everyone knows this woman as the wife to the deceased. So they wanted to litigate that matter in court, and I advised them to say, no, this is not a case where I can get instructions or brief to litigate the matter in court and exaggerate or maybe make things worse between the families. So I requested mediation, and then we had a roundtable meeting with both parties, and then it was resolved that all of them must participate in the funeral arrangements, and the matter was resolved. Because I believe that if we litigate this matter, we may make things worse between the families, and there were kids involved.
Thank you for the response. My last one, Chair, is on the basis of the response that Advocate Debiele did some research, and it has to do with the Public Audit Amendment Act, number 5 of 2018, and some of the responsibilities it places on the Office of the Public Protector. My question is whether you believe that the office is thoroughly capacitated to be able to execute these particular responsibilities.
Which office?
The Office of the Public Protector. The Auditor General
Yes.
does some audits,
Yes.
and then on finding certain things, then they do require the role of the Public Protector to be activated.
Oh,
Yeah.
I get the
Do you
question.
think that you are sufficiently capacitated to be able to execute that? When I mean you, I mean if you are appointed and based on your research. Thank you, Chair.
In my view is, I don't think at this stage that office is capacitated to deal with such matters, because they require special skill. And an Office of the Public Protector is not an office dealing with corporate issues and commercial issues. So my view is not capacitated to deal with that. But it's not something which cannot be doable. If specialized people are appointed, then that can be
No, but the
executed.
question is, do you think you are capacitated to fill the vacancy?
Myself. Yes, because the role of the public protector is not necessarily to make investigations himself or herself, or work alone as a team. If the right people are on the board, that can be done.
Okay, thank you.
Thank you, Chair.
Thank you. Honorable Dana.
Thank you, Chair. Advocate Tebile, good morning.
Good morning, Honorable Member.
You have an impressive CV, and given the background that you gave us, I have great respect for you. And what I also have great respect for is I searched, I did research on all of the candidates, and I couldn't find any controversies linked to your name, so that's quite impressive. What I'd like to know, my first question is, have you ever been involved with any controversial cases, very difficult cases? If we would liken that to the Office of the Public Protector, the matter where the Public Protector had to investigate the Pala Pala matter, that type of difficult or controversial cases. Have you ever been involved in anything like that? If you have, can you just give us the background? Otherwise, if you've not, how would you handle such a case if you were to be appointed?
I'll give examples, and the committee will decide if the examples are relevant. I did a case in Limpopo, I think 3 years ago, where a grade 12 learner was refused to sit for an examination, final examination, by a school principal who believed that that learner will not sit for examination until he brings his parents to explain why he missed extra lessons. And he missed the examination, and then there is a community member who knows the kind of the cases I do. And then he approached some attorney, and then he asked the attorney to appoint me as an advocate in that matter. And then we went to High Court in Polokwane. And what we wanted, or the relief we sought there, was for the learner to be given opportunity to write examination. And the view of the department was, we can't give this learner an opportunity to write an examination after he missed examination. He must wait for a supplementary examination. And then we went to the High Court. Unfortunately, the High Court threw the case out on the basis of lack of agency. And then we approached the Constitutional Court. And there were two issues in the Constitutional Court. The first one was whether the Constitutional Court can give us direct access and on agent basis. And fortunately, we succeeded with the matter. And the learner was given opportunity to write that paper before the release of the general matric results. So he said for the paper, I think it was on the 15th day of January 2021. And he made it.
Can I have another 7 seconds? Thank you. There's a general opinion.
Most importantly is that case was done pro bono. And in the Constitutional Court, there was a debate on whether the applicant should be awarded costs or not. And the Constitutional Court was decided in our favor to say, even if the legal team was acting pro bono, they must be awarded costs, because the Constitutional Court was of the view that this kind of exercise must be promoted to have access to justice.
So you're not afraid to take on difficult cases?
No.
Okay. There's a general perception amongst the public that government is unethical, does unethical things, is not reliable, etc. How would you promote, if you were appointed Deputy Public Protector, how would you promote, first of all, an ethical culture within the organization? And how do you think the organization of the Public Protector can contribute to promoting an ethical culture within government? Thank you.
The most important part is people must know that they are accountable to the law. In the absence of accountability, we find ourselves in a crisis. So there should be policies in place to ensure that officials or public officials are held accountable to their misconducts or unlawful activities. So my view is people must be held accountable and must be made aware of the importance of good governance. And in some instances, as I indicated before, it's a matter of incompetence and lack of trainings. So there should be trainings to ensure that people are up to standard. You may be appointed today, and in the next 5 years, things have changed, and you may need further training. So sometimes it's about lack of training on certain aspects.
Thank you. Advocate Tebele, Honorable Dana asks you a question of whether or not have you ever been involved in a controversial case. You mentioned, yes, one, of a person, exams and stuff. But do you think that the case you were involved in on pro bono basis, representing the former public protector, Busisiwe Mkhwebane, in the African Human and People's Rights Court, something like that, do you not consider it as a controversial case? Because I would have thought that at least you'd mention that, particularly because we are doing interviews for a deputy public protector.
Honestly, Honorable Member, when the question was posed, that was the first case which came to my mind. But my challenge was ethically, I should not be discussing matters which are pending before certain forums. So I thought I should avoid discussing that case in a platform of this nature, because my view may be prejudicial to the whole case. So it was definitely the first case, but I was ethics. I must abide by the ethics and avoid discussing, especially that the opponent may not be have an opportunity to.
No, look, there's nothing wrong representing anyone.
Yes.
The question that was posed is your involvement in such kind of cases.
Yes.
What is ethically wrong on mentioning a case you are doing on pro bono basis, particularly when you declared in this interview that you do a lot of pro bono work?
Oh yes. Okay. The ethical part was to discuss the merits. The merits of the matter, but I'm not. I avoided to raise it because I would be required maybe to deal with the merits, because when you say this is the most controversial case, you must get into the facts, like I did when I disclosed the facts of the matter, the previous matter I mentioned. Yes, but.
But did you understand the question from Honorable Dana that it had nothing to do with the merits?
Of course.
It had something to do with your involvement in a case.
To that extent, it forms part of the most controversial cases I've done.
Okay. Would you consider it an unethical practice to just mention that you're involved on pro bono basis, as you mentioned before?
Not at all.
Okay.
Not at all.
Fine.
Yes.
For financial year 2024-2025, what is the budget of the Office of the Public Protector?
The report I had sight of was 370 million, but 370 million. But to my surprise, there was a cut of about 37.4 million in the last report I read.
Okay. Have you followed the first and the second certification cases in the Constitutional Court? The ones that actually established the institution of the public protector.
Not fully.
Not fully.
Yes.
So-
I must be.
Would we
honest.
take it that if you didn't follow the certification cases that establishes the institution of the public protector, you don't know the objects of the institution? Because that's where the
I-
objectives of the establishment are.
I know the
What are they?
The mandate of the office, as
The objectives.
Yes, as the per constitution and the act.
Advocate Tebele, the objectives of why do we establish this office?
To promote democracy and to protect sin.
Okay. What is your understanding of the rule of law and the principle of legality? And what is the dialectical relationship between the rule of law and the principle of legality?
Okay. Both speaks or both are stamped on the principle that everyone is subject to the law and everyone must act in accordance with the law. So people are accountable to the law, and in decision making, their decisions must be done within the prescripts of law.
Okay. The Public Protector South Africa is turning 30 years of existence in 2025. And not every time that the remedial actions of the Public Protector were enforceable and binding. Can you take us through what period and what happened for the remedial actions of the Public Protector to be enforceable and binding?
We have the Ngandla matter, which is the most important case or the most important decision, which gave life, I would say it gave life to the work of the public protector and the issue of remedial action, because the Constitutional Court held that remedial actions are binding and must be enforced. Just to take the matter further.
No, don't take it further. If you take us to the Ngandla judgment, then you are done.
Oh, yes. Okay.
Yeah, don't take it further. Oh, I'm going to ask you 3 questions that you're going to answer at once. The Public Protector, in October, I think, issued a report and reported to Parliament, a report they termed Systematic Investigation into Administrative Deficiencies Relating to GBV within the South African justice system. You'd understand that GBV is a rife matter in society now. Do you understand what that report says? And how do you think the Office of the Public Protector must contribute towards the fight against GBV? I would ask you about access, but I think earlier on you did answer about access, the issue of radio stations. But I think let's go now to how do you think is a best mechanism, or what do you think is a best mechanism to be employed to deal with case and complaints backlog and to enhance and improve investigations in the Office of the Public Protector?
Of course, on the issue of methods which can be used to enhance proper investigations by investigators. I think if not mistaken, I mentioned the fact that there is a need for proper training of investigators. You know, time moves. And I indicated earlier on that you appoint a person today in a particular position, and then the developments of technology and other things may be impediment for that person to carry out the mandate. So I think investigators must be well trained in terms of also technology, because there are certain crimes now which are done technologically. So there should be proper training of investigators, and they must have timelines put into place as to finalization of these cases and follow-ups on how far are you with this matter, including old matters and new matters. And the issue of GBV, is a serious challenge. And my submission is, as part of trying to resolve this, I think we should come up with strategies on how best we can equip police officers on investigations of this kind of cases. And we should...
No. The question is on a report issued by the public protector, and what should be the contribution of the public protector towards helping the state and society to deal with gender-based violence.
Or the contribution of the Office of the Public Protector. Oh.
Okay, we can pass it. Let's go straight to dealing mechanisms to deal with case backlogs and complaints backlogs, and
Finalization.
help improve investigations.
Yes, which I think I touched on that one, to say there should be case management of in terms of investigations, and have turnaround times on these investigations, to say you must report, investigators must report on specific dates as to how far they are with the investigations. I think that is what I dealt with before.
Advocate Tebele, that marks the end of our interview with you. We call it a conversation, because we don't want you to be anxious and things. It's a conversation. But I think we wish to thank you for availing yourself. Of course, this is the second time you are coming for the interviews of the Deputy Public Protector. We wish to thank you for coming. We wish to thank you for voluntarily wanting to be part of the solution towards capacitating the Office of the Public Protector. The committee will have its own meeting for deliberations. Then we will let you know. Is there anything you want to say?
I think I'm tempted to say this was a conversation. And it was helpful, because when you think about an interview, you go anxious, and I can tell you it was a conversation.
Yeah. Thank you very much.
And thank you so much.
We wish you a safe travel back home. Thank you.
Thank you so much.
Committee Secretary, can we get another candidate?
Can I just give these guys some, maybe 2 minutes to bring the records?
Or that manual arrangement of yours?
Yeah.
I see Honorable Klopper is happy now.
So can I just push this? Oh, so this is
Next to the shop.
right there.
There's a shop opposite the buildings. The buses go in. Abazokwazi ukuza apha because yes again. So when ngicela usondele uze shop ezantsi ne-investment trust. Siyaphuma ngoku. Lo siyaphuma ngoku. That's what enye phaya for aba bantu bangapha jonga izoblowa kanje at least but since iplug yala there's nothing I can do.
This thing can be here because there's a person here. Why do we give
Thank you.
closer to the mic? Yeah.
Dr. Majage, good morning.
Good morning, Chairperson, and good morning to members of the Portfolio Committee.
How are you today?
I'm very well, thank you, and thank you for inviting me for this interview.
Okay. We are going to have a conversation with you. We deliberately call it a conversation, so that you're able to relax and take water. Is there water there? Can you help there? Yeah, that's your water in case you need it.
Thank you, Chair.
Yes. Can you confirm if you are the one who did the disclosures in the questionnaire we sent you?
Yes.
Is there anything else you wish to declare?
Not that I can think of.
Okay. Now, we're giving you 5 minutes to tell us about yourself and why do you think you are a suitable candidate for the position of the Deputy Public Protector.
Thank you, Chair. I think already you know my name. I'm Kana Bilane Majake. I have too many names. Some of them I don't use. My title is doctor, not medical doctor, but doctor of philosophy. I'm sure you've seen my qualifications, which is partly what actually makes me to feel confident that I am ready for this position. I have a doctor of philosophy, and I'm continuing to do my legal studies now. At some stage, I did an MBA that is incomplete. So when it comes to academic qualifications, I think there's a lot of work that I've actually done in accordance with the questionnaire that has actually been submitted. Throughout my whole life, I've been somebody that has been very much interested in social justice. If you look at my early days of working as a lecturer, both for University of the North, now University of Limpopo, and University of Natal, I did a lot of work that was just about social justice, that connected to social work, which was my junior degree. And besides that, I then went on to work also as a funder. Maybe before that, I was in an organization that was about human rights and mainly focused on the rights of children. And then I worked as a funder for funding human rights organizations and advice offices in South Africa to cultivate the culture of human rights in South Africa. That was around 98 to 2002. The same program is the program that is actually funded by the EU, funds it through the Department of Justice. So the Department of Justice has all the years been in the position to manage to fund advice offices that's just about mainly what you can actually call street law, that is actually operated by paralegals. We funded that. We funded even Chapter 9 institutions, the Commission on Gender Equality, Public Protector, Commission on Cultural, Religious and Linguistic Rights, the IEC, Auditor General, all of those were actually funding. Then I moved on to become the CEO of the Commission on Gender Equality because of the work that I did in terms of the rights of women. I was part of the contingency that was sent by Tata Mandela to Beijing, China in 1995, when the women of the world converged in Beijing, China to actually craft an agenda of what to do with the rights of women. And then came back and we had the Convention on the Rights of, the Convention on Elimination of All Forms of Discrimination Against Women ratified which was a motivation that we gave, and the document, which was the outcome of that process in Beijing, was actually then adopted by the country. So throughout my life at the Commission on Gender Equality as a CEO, I've really developed enough skills around human resources, financial management, information technology. We had a legal division that was actually also reporting to me, that was actually doing cases, including monitoring through submissions to Parliament, legislation in Parliament, so that when legislation is passed in Parliament, it has issues of women infused in it. We did a lot of work, and including really having precedent-setting kind of cases that would actually radicalize the lives of women, like the whole issue of inheritance, where we had a groundbreaking judgment with the Constitutional Court on the primogeniture rule that actually was the outcome that managed to override the rule that a senior male in the family is supposed to inherit. And a whole lot more other cases we participated in as a Commission on Gender Equality, also as amicus. And then from the Commission on Gender Equality, I became a member of Parliament. And for a long time, I was attached to the Portfolio Committee on Justice and Constitutional Development. I'm looking around to see if members that I've served with are still here. And as a lawmaker, you really get exposed to so much, if you are somebody that's interested in social justice, to so much that actually tells you now you are in the forefront of actually making total change to the lives of people. Besides the fact that as Parliament, we play that oversight role to see if institutions out there that has been established to actually promote access to justice are really doing the work in terms of the legislation that actually guides them. It has been a very good and pleasant journey, and today I'm here because of the position that is vacant at the Public Protector. When I was in the Portfolio Committee on Justice, the Public Protector was actually reporting to us here. At the time, it was Advocate Wilima Donsela, and we really saw the office growing, and with the introduction of the position of the Deputy Public Protector, it actually helped to bring about the necessary support that the Public Protector requires, because as a Deputy Public Protector, the main responsibility is to support the Public Protector in accordance with the delegations that the Public Protector will actually afford you as the Deputy Public Protector.
Thank you. Honorable Dana, Honorable Matafa, Honorable Tsotezi, Honorable Mutawong, Honorable Mvalo, Honorable Engelberg, and Honorable Globa, in that order.
Thank you, Chair. Dr. Pilani Majake, good morning.
Good morning.
Are you well?
I'm very well, thank you.
That's good.
Member.
Doctor, I have just two questions. The first one is, you mentioned your involvement at the Commission for Gender Equality as CEO. And in 2006, you were investigated by the Public Protector's Office. Now, you were largely cleared of the allegations against you, as far as I could gather. But still, you were suspended in, I think, 2007, if I'm right, because of staff complaints. Can you just maybe give us the background of the allegations against you and the staff complaints, and just sketch for us the situation around that? It's not to put you on the spot or anything, it's just to even out some questions that we may have. Thank you.
Thank you very much. The 2006 investigation was based on an anonymous complaint, so which means it was a faceless complaint, or something that actually turns out not to have any substance. And I'm sure you've seen the report of the Public Protector, which is things that we need to actually consider ourselves as lawmakers as we continue to strengthen whistleblowing, because sometimes it's abused. I remember when we were deliberating on the Protected Disclosures Bill here in Parliament, my inputs was to say we need to criminalize false reporting. Because false reporting is about destroying people's lives. And, you know, something that has to do with the anonymous complaint that actually boiled down to nothing, has to do with false disclosure. And then in 2007, about the suspension, I'm sure you've seen in the questionnaire I wrote about it, to say that there came a new chairperson at the end of term of the chairperson I was actually working with from 2002. And just at the beginning when the chairperson came in, requests were made, and those were requests that were not regular. And as the accounting officer, because when you're a CEO, you're at the accounting office of the organization, I've refused to actually give approvals. And that actually created some animosity. That's when all hell broke loose, because remember, as a CEO, you then report to the commission that's headed by the chair. And if the chair declares war against you and create a case against you, then naturally it means, in terms of labor relations, other things will actually have to come into play, because then she has the right to actually suspend you. But what was interesting was that the charges that she was actually putting forward couldn't actually be backed up by anything that has got legal ground. And this is why they actually spent a lot of money trying to actually make this case to have some weight, and it just didn't work. Like I've indicated, I think they spent something like almost 500,000 trying to actually deal with me utilizing the lawyers. But when all failed, that's when they actually then requested for a settlement. And I've written in the questionnaire that the settlement agreement is available per request, so that it can actually validate this that I'm actually saying now.
Thank you, Doctor. It's not everyone that gets the right of reply, so thank you very much for clearing that up for us. Excuse me. You're quite a prominent member of the ANC, and we're all informed by our ideologies and our backgrounds and our frames of reference. We are all politicians, so we all act on what we believe. And there is the perception that you may not act unbiasedly. And so I would like to know, how will you go about ensuring that, well, first of all, that you will not act with your frame of reference or ideology of the ANC in mind, but act unbiasedly, and also ensure that there is no perception of bias amongst the public if you were to be appointed Deputy Public Protector?
Thank you very much. I think where it begins is to really also remember that we as South Africans have really managed to get a peaceful transition that was ANC-led. And it was peaceful because it was inclusive, it wasn't exclusive. It was based on human rights and the rule of law, which is something that's really closely connected to policies of the African National Congress. But if I've got to enter into this office, I have to actually be outside the African National Congress and become a South African citizen. In the questionnaire, I've actually written that we are a diverse society. And as a diverse society, it actually gives us diverse perceptions, diverse society with diverse ideologies, which is something that we need to accept in a constitutional democracy. We can't think the same way, we can't see things the same way, but what is important at the end of the day is us really managing to find the middle ground, because what matters is peace and social justice for all South Africans. And if I have to get into that office of the Deputy Public Protector, this is the approach that I will actually use. Every South African is important. And I think this is also in line with the provisions of the Act of the Public Protector, to say that the Public Protector must actually work closer to communities.
Can I have 7 more seconds? Thank you. Doctor, the Public Protector has had to make very controversial findings, difficult findings, like for instance in the Pala Pala matter. So I'd like to know from you, how would you go about handling difficult matters where, for instance, the president of your organization and the president of the country may be involved? We don't know if there's going to be anything else that comes out. How would you handle something like that? And how would you go about ensuring that the that the country continues to have faith in the organization of the public protector?
I think the rule of law is the rule of law, and a judicial interpretation must be the same, regardless of who it has got to do with. If we have to convince ourselves that we are actually running a just society. So whether it's about the president or it's about a colleague from a political organization that I know and belong to or used to belong to, because when I get into this office, it means I must put politics behind me. The status quo must remain. People must be treated equally in terms of the clause 9 of the Constitution, section 1 and 2. That actually puts equality of the people of South Africa before everything else.
Thank you. Honorable Matafa.
Thank you very much, Chair. Doctor, how are you?
I'm good, thank you, Honorable Member.
Thank you so much. Chair, I only have 3 questions, and all my questions will be based on the fact that the doctor once headed the PSA. So my first one would be, what more do you think should be done to promote an ethical culture in government? Maybe you can respond to that. I'll ask the other ones because the second one is a bit long.
Is it what more should be done to promote the legal culture?
Ethical
culture
in government. And I'm raising this because if you look at most of the issues the public protector deals with emanate from government. And yesterday we agreed when we did the interview of the Human Rights Commission that most violations happens at a municipal level, which is another sphere of government. So it's just only on that one, on the ethical culture in government. Thank you.
The mandate of the public service administration is to really promote effective and efficient public service that actually manages to provide service delivery that meets the needs of South Africans in a way that is satisfactory. And for us to be in the position to give that effective and efficient service delivery, there needs to be basic values and principles that are actually followed. We are talking about the norms and standards of public service that connect directly to the mandate of the public protector. Because when you look at the mandate of the public protector, it says the public protector shall investigate improprieties in the public sector and maladministration in government. And that maladministration will be emanating from administrative action in government. And of course, there will be a number of pieces of legislation that are actually utilized. But from the public service administration perspective, what has been done up to now, we have public service rules, which are enabling rules that actually interpret and the implementation of the Public Service Act. The Public Service Act that has got the mandate, as I've articulated, backed by Batubili principles. And Batubili principles is to really say, at the center of it all, it's South Africans. And it's South Africans that must be served. And this is why we emphasize the fact that all the public service workers should understand that they are servants. That's why we talk about public servants, so that they must come and serve in order for them to actually manage to provide the service. And then we have the norms and standards, and we've got the Office of Standard Compliance that actually pull together all these norms and standards, which are values and principles that are supposed to actually help public service to manage to be implemented in a way that promotes the ethical conduct that you are actually alluding to. And one thing that is actually also important is to note that public service has got the implementation of public service mandate also has in the background resources, which is about monies that government needs to actually administer. We sometimes also create a problem because if those monies are not actually properly administered in accordance with the Public Finance and Management Act, then that becomes problematic. You find that the money that's supposed to actually then take care of the needs of South Africans go somewhere else. And this is why we actually also deal with issues of corruption in public service and administration. We deal with corruption by having disclosures for members of the public service. All the public service employees are supposed to actually provide disclosures so that we actually understand what business interests they have, if any. And then also we do public administration. I will say we do because I forget I'm out there already. Public service and administration does lifestyle audits so that lifestyle audits can actually manage to explain, to give meaning to unexplained wealth. Because where there is unexplained wealth, that's where you find that there is corruption. And I'm sure you know also that we work closely with the Public Service Commission, and from within the Public Service Commission, there is a national anti-corruption hotline that is actually used in public service. Besides the fact that the Public Service Commission itself has got that role of monitoring us and all this that of monitoring the public administration, of all this that I'm actually putting forward, and even making suggestions as to where we can actually make it better. And then there is a unit within Public Service Commission, within the Public Service and Administration, is called the Ethics, Integrity, Disciplinary Technical Assistant Unit. It's the one that consolidates work within public service that has got to do with corruption and build capacity around it, because what is also important for us to have ethical public administration, we must have even the necessary capacity to do the work, because in certain instances you find that people are not served well. There will be undue delays as articulated in the Act of the Public Protector, because people are not well capacitated. So the intention of public service is to build ethical, capable, and developmental public administration that actually manages to bring change in the lives of people of South Africa.
Thank you, Doctor, for that comprehensive response. Now, in the event that you are appointed to the Office of the Deputy Public Protector, you will agree with me that the most reported transgressions relates to violation of all those mechanisms that you have explained that come to the Office of the Public Protector. So in the event that you are assigned that responsibility, how would you go about to ensuring that there is correction and there is meaningful impact that is felt by society of the Office of the Public Protector?
Thank you very much. In the event that there are problems, they will come to the Office of the Public Protector in a form of complaints. But also the Public Protector can investigate on their own accord, on their own initiative. They don't have to wait for complaints. Where they come to know that there is wrong, then it's within their competency to actually investigate. And the Public Protector will, like I've indicated, investigate the public sector. Public sector includes even state-owned institutions or state-owned enterprises where there are improprieties and maladministration in public service. And the Public Protector will then also do the reports on these investigations and come up with recommendations. And the recommendations, by the way, that are binding in terms of the case law that we know that's connected to that EFF and versus the Speaker of Parliament case that had to do with the Nkandla matter. And then also, when the Public Protector has to make interventions, the Public Protector must convince themselves that local remedies have been exhausted. I've actually indicated how public administration is handled. We have our own systems and procedures that are there to actually ensure that the ethical practices are promoted, like the public service rules. So before the public protector can make an intervention, the public protector must have convinced him or herself that all those local remedies have been exhausted before an intervention from the Office of the Public Protector can actually be made. But also, what we need to understand also is that should the matter have to be an outcome of the court, the public protector cannot investigate outcomes of the court.
Last one, Chair. Thank you for the response. Can you just share with the committee what is your understanding of the Chapter 9 institutions' role within our constitutional architecture? Thank you.
Thank you. Chapter 9 institutions, the Public Protector, Auditor General, Commission for Gender Equality, Commission for Cultural, Religious and Linguistic Rights, the Independent Electoral Commission, Auditor General, those are Chapter 9 institutions. These are institutions that have been created to protect the democracy as enshrined in the Constitution, and that's why we call them institutions supporting democracy. They have their own special committee connected to an office in Parliament here that is helping to coordinate the work that they do, because by them coming together, it actually also helps to coordinate and galvanize the work that they are doing. And sometimes they even share the challenges that they've got, and they come up with ideas as to how these challenges can actually be dealt with. But these are very important and independent institutions. Even if they do get their votes via government departments like the Department of Justice, Home Affairs, they are independent. It's just a conjoint kind of a relationship so that money can be in the position to flow out of Parliament. And they've been made to be independent so that they can manage to have enough teeth to referee when there is need to.
Thank you very much, Chair.
Thank you, Honorable Tsotitsi.
Thank you, Chair. Thank you, Chair. Ke tsa gore le siame maizo.
Ke itumetse rra, ke a leboga.
Ke lebogile. Now, in your own assessment, what are the areas that you think that the Public Protector's Office has been able to fulfill its mandate? And then which, do you think that there is a room for improvement?
If I had the question correctly, it's about the areas the public protector can be able to fulfill the mandate.
I can rephrase. I can.
The referrals, yes.
Repeat the question in your own assessment.
Yeah.
What are the areas do you think the public protector has been able to fulfill its mandate? And the second is that, do you think there is any room for improvement? And obviously you can then articulate that room for improvement.
Thank you very much. I think the one thing that we all know, or the one aspect of the work of the public protector that became major and really had the focus and attention of the entire country was the state capture report. And it goes hand in hand with the competency of the mandate of the public protector, that the public protector on his or her own initiative can actually do investigations. And this is why we had this state capture report. A state capture report that really managed to zoom into corruption across government, and not only in government offices, but in state-owned enterprises. And it's a process in motion. I'm sure from the public we hear people saying, but the Zondo Commission, which was a process that followed the Public Protector's report, the Zondo Commission recommendations are there. We don't see action being taken. So, and this is why I'm saying it's a process in motion that we are actually hoping that it will actually help to deal in a way with corruption that will help to reduce corruption. And like I've indicated, that one thing about corruption is that it eats up into state resources. It's up the monies of the people who are desperate out there, who are supposed to be utilizing the resources of government. Where to improve, I think the Office of the Public Protector, as part of its mandate, is to work closely to communities. And I think that aspect, needs to be sharpened so that whatever the Office of the Public Protector is doing should be looked at as something that actually is representative of the voice of the people. This is when you wouldn't hear people saying, there could be bias here and there, because where people are not actually directly or actively involved, there might be instances where it becomes difficult for them to associate themselves with the very processes that are there for their own good. And I think maybe this could actually also happen in certain cases when there could be friends of the courts that actually support the public protector. This is just from just my wild imagination, but I'm sure it's possible.
Now, I'm sure you know that all public entities operate from a very constrained physical position. How do you think that the Public Protector's Office can ensure that with all those physical constraints, it's still able to discharge on its mandate, but more further, even increase on its impact particularly to reach the poorest of the poor? And how do you think it can improve on its impact with this constrained physical position?
It's a very broad question, because these state enterprises are so many. And when I'm just thinking of them and I'm trying to pick one of them in my head to say, maybe, for example, SAA, you could look at the state in which it is now, and the question is, how does the public protector assist if they've got a constraint in terms of the funding? For that kind of conclusion to be reached, it means there's got to be work that actually gets into this enterprise.
No.
To go in.
No. Now, what I'm saying is, all entities generally are operating from the budget of every entity in the country is shrinking. It has been shrinking for some time, including that of the Public Protector's Office. Now, with that consideration, that reality, how do we ensure that the Office of the Public Protector still has a greater impact in in society? It doesn't compromise much in its own mandate. How do you think the smarter ways in which it can be able to execute its responsibilities? What do you think? My question is exactly that.
The Office of the Public Protector will continue when it comes to state enterprises to investigate where there is improprieties. So when we talk about resources within the state institutions, I think every cent matters and how every cent is actually utilized. And when it comes to the attention of the public protector, that there has been improprieties in terms of rolling out the mandate, in terms of the kind of contracts that are actually given out, then the public protector must make the necessary interventions. But also, the public protector on her own initiative, if he or she gets to know of a problem that exists in one area of a state enterprise, the public protector can make necessary intervention.
Maybe let's follow it up in this fashion. What do you think, can you identify some innovative initiatives which could assist the public protector to better deliver on its mandate?
Like I've indicated, that maybe there's got to be that involvement of the communities, working closer to the public protector. That's the one area that I think if we've got to actually help to grow the office of the public protector to make it stronger, we need to actually manage to work closer to the communities. When you look at the recommendations of the public protector, most of them are followed by action plan. I think where I'm sitting, I'm thinking that there needs to be a system that is actually developed that makes follow-up on those action plans, so that we don't have report after report and the action plan after action plan, and sometimes you find that little is actually being done.
Thank you, Honorable Mutaung.
Thanks, Chair, for the opportunity. Is it still the morning? Good morning, Dr. Mazaki. And how are you?
Afternoon.
Good morning, honorable member.
Thank you. Doctor, the bulk public protectors investigations and interventions relate to service delivery failures, which significantly impact the lives of people of South Africa. Do you believe that the Public Protector South Africa could do more to address recurring and systematic service delivery weakness, which organs of state? If yes, how do you think you can do it when we can give you an opportunity to be a public protector, deputy public protector? That is the first question. The second one is, what do you see as the most pressing governance issue in South Africa today? And how will you go about to address it if we can be given an opportunity to be a deputy public protector?
Thank you very much. I think in terms of question number one, what is important is really for, should I be appointed in the office of the public protector, supporting the public protector, is to follow these mechanisms that are actually put into the Act as competencies of the public protector in accordance with Section 6 of the Public Protectors Act. They're very clear and straightforward as to what needs to happen, how it needs to happen. It's like when there is a complaint, then that complaint must be investigated. And there must be proper format and procedure that is actually determined to actually address that complaint. And then also, what is important is to look at the powers that have been given to the Office of the Public Protector, in the sense that the Office of the Public Protector has got the ability to subpoena. And this ability to subpoena also is actually accompanied by the right to actually give the people who are supposed to testify to do an oath. And in the event that there is no compliance, then it's possible that people can actually then be found to be having an offense by contempt of the Office of the Public Protector. And there's also fines and that have actually been worked into the legislation, what the type of fines that can actually be paid. These are measures that actually strengthen the Office of the Public Protector, including the power to do the search and seizures, because in some cases, you find that you could have an office like the Office of the Public Protector, but find that it then becomes a little bit difficult for the office to implement its mandate because of the kind of resistance that the office might actually get. So with the warrants that are actually issued by magistrates or judges, then it actually gives the Office of the Public Protector the power, the necessary power to actually execute its mandate, which is the kind of mandate that I will actually be supporting once I'm appointed as the Deputy Public Protector. The second one about what are the challenges, the governance challenges that we are experiencing. Number one, I would actually say that governance in South Africa is mostly disturbed by corrupt practices. So we need to actually continue through the various structures that have been established through the Constitution, through different legislative framework, to build an ethical, capable, developmental state. This will actually then manage to help us to deal with the main challenges that we've got. Challenges of poverty, challenges of the health system that is oversaturated, because we understand in terms of the Sustainable Development Goals what our targets are as a country. We have targets, for example, of maternal and infant mortality rate that we really need to bring down. But if we don't get these institutions to be at the right level, it might actually become problematic. We have an education system that today we're still questioning whether the quality of education is correct. Policing in South Africa also is a challenge. And sometimes when I talk about policing also, with the same breath I talk about the population explosion that South Africa is actually experiencing, because also that is a challenge with our porous borders. The people are too many for policing. What do we do? What strategies are we coming up with? Is the current policing system really managing to do what it's supposed to do before we can actually even consider the challenges and decide what to do with the challenges? And lately we see the zamazamas also there when it comes to...
Okay, Doctor. Let's say you are given an opportunity to be a Deputy Public Protector in a situation where organs of state ignores or refuse to implement remedial action. What is it that you can do as a new public protector to try and assist PP?
When the organs of state refuse, and when you say organs of state in terms of issues of governance, you look at where they are actually reporting to, because it will be the president, it will be a parliament in the form of the National Assembly and the NCOP, because the public protector must submit reports to the NA, to the NCOP, besides the fact that the public protector must also understand the cycle of parliament, because at different points, there's reports that are supposed to come from the Office of the Public Protector to parliament for different purposes, like the APP, BRRR, the way we call them. The Public Protector's Office must actually manage to know and understand those processes. But when it comes to cases that are contentious, also Parliament may make necessary intervention. Besides the fact that if it's a minister, then the Public Protector should report to the President within the executive.
Lastly, Doctor, what is the budget of the Public Protector's Office?
I think I haven't really checked it now. The last time I knew about it was about something like 480 million, could be more.
Thank you, Honorable Nomvalo.
Thank you very much. Good day, Dr. Machage.
Good day, Honorable Member.
How are you doing today?
I'm very well, thank you.
I'm doing well. Also. Are you still a member? Are you still a member of the ANC?
I am a member of the ANC, but not in the structures of the ANC. And I've indicated, should I be appointed in the position of the Deputy Public Protector, it means I must actually relinquish my membership so that I can be impartial and apolitical in the office that I'm going to be occupying.
My understanding is that you joined the ANC because you believe in its policies and you believe to it as an organization. Is that correct? And that is why you are still a member of the ANC.
Earlier, there's a member that asked the same question. And the worry is that with this particular ideology, wouldn't it compromise other ideologies? And I said, remember, it's the same ANC that has actually led the peaceful transition of South Africa. No bloodshed, nothing, which is what the ANC and its policies is about. Peace is what the ANC policies promote, regardless of our diversity, how we perceive the world in a different way. At the end of the day, we have to know how to manage to live together in order for us to get to have what I'm sure we are calling it even today, the Rainbow Nation. And we say Rainbow Nation because we acknowledge the diversity of South Africa.
Yeah, I can see that you have very rich credentials. You've been deployed in various areas. And you were deployed by the ANC, that is correct. For instance, as a deputy minister.
In Parliament, as a
yes.
member.
Yes.
I'm sure even yourself, it's through a political party.
So
yes.
you were accounting to the ANC. You've been accounting to the ANC as a deployee.
When you are in Parliament and you come into Parliament through a political party, you actually deal with Parliament business according to the mandate of your political party or ideologies of your own political party. But like I said, understanding this position, and I'm happy for now, I'm not in the structures of the African National Congress, and this is why I thought this might be a good time for me to actually look into a position of this nature, because by not being in the structures, it means that it actually opens me up to participation in offices and work, like the work of the Office of the Public Protector. And I've actually also indicated that once I'm a member, then it means even the membership will actually be relinquished in order for me.
So if you are not appointed, then we are not going to withdraw your membership from the ANC. You'll continue to be a member of the ANC.
I think maybe let's not talk about possibilities. Let's look at what the situation at hand provides for us. Because for now, what you want to understand from me is that you have a background of the African National Congress. Do you want to get into that office to go and promote the African National Congress? And in no uncertain terms, I've said I am coming in there in order to represent South Africans.
Okay, now let's go to another one. Do you know the investigation methodology that the public protector adheres to when they conduct investigations?
Can you repeat the question?
The investigation methodology that they adhere to when they conduct investigations. Do you know it?
Investigative technology.
Methodology.
Oh, methodology, okay. Methodology, it's actually in accordance with the provisions of the Public Protector Act number 23 of 1994. If you look at clause 6, section 6 of that piece of legislation, it actually takes you through all of the steps that needs to actually take place. And some of them have actually already articulated, like investigation of improprieties in the public sector, maladministration in public service, also being sure that local remedies have been exhausted, and also with the investigations, to also manage to apply mediation, manage to negotiate, manage to advise, and doing reports, putting reports together, and those reports are supposed to be published.
Sorry, I'm sorry to interrupt you.
Yes.
I think you are a bit peripheral. This is not what I was looking for, but because of time, I will move to another one. Because the follow-up question from that question was going to be, in that methodology, do you spot any deficiencies which might lead to a possible success when the matter is taken on review? When the report is taken on review, are there any deficiencies that you spot from the investigation methodology which make the review applications against the public protector's reports to succeed? Will you be able to answer that question?
I think there will only be review where there is discontent. And then the matter or the outcome of a process will then be taken for review by the court. Because public protector reports can only be challenged in a court of law.
No, again, you are not answering my question. Let's move to another one. With regards to the time frames which are prescribed by the project plans, which are drafted by the investigators and approved by the senior investigators, there are time frames which are outlined in terms of when investigations must be completed. Are you aware of that?
Yes, I am.
Can you tell me of two time frames? For instance, with regards to matters that involve corruption, what is the time frame?
Normally, the time frames are part of the annual performance plan of the public protector. So, which means this is the information that we will find in the annual performance plans of the public protector, depending on when the matter was reported and the calculation of when the conclusion of the matter will actually have to take place.
Okay, then the last question. Even though I know that there is no way that you can be objective on this one, because you have told us that you are a member of the ANC. With regards to the Palapala matter, and the president of South Africa is your president. Now, with regards to the Palapala matter, the public protector makes a finding that there is no wrongdoing. When foreign currency was hidden under mattress, and then they say there is no wrongdoing. What is your take on that?
Like I've indicated earlier, recommendations of the public protector should be regarded as binding, and that is based on case law.
No. You are giving me a principled position. That is not what I'm looking for. Here I'm talking about the findings and your take on the findings. Agiri, you have a legal background and you have some legal knowledge. So you can make your own, you can dissect in terms of your own understanding of the law, that this is where the report got it wrong, and this is where the report got it right. Now the question is, in relation to the findings, not to a principle of what must happen, what is your position in terms of your legal knowledge and in terms of your legal understanding? Was the public protector correct by saying, when she said the money that the president was correct by putting the money under mattress?
Thank you. For now, you're saying
But that's not what the report is saying. But I'm sure you get the question. The report
I
is
get the
not saying the
question.
president was
I get the
correct.
question, Chair.
It's not the context, but I think you get what he's trying to answer. Okay.
Yes.
You can
I
switch
get
off
what
the
he's
mic,
trying to
Mr.
answer,
Mvalo.
which actually opposes me putting forward a principled position, and what is being demanded is my personal opinion on a matter I have not investigated. Because if I had investigated the matter, I would actually have my own personal opinion. For now, I think what we need to do is just to understand the competency of the Office of the Public Protector and the fact that these are independent Chapter 9 institutions in terms of the mandate as given by the Constitution. And this is why, therefore, there is no way in which personally I can just be in the position to interfere in the outcome of a process.
No
Thank you.
further questions, Chair. Thank you.
Thank you. Honorable Engelberg.
Thank you, Mr. Chair. Good afternoon, Doctor.
Good afternoon, sir.
I only have two questions. Firstly, given that currently the scope of public protector investigations and recommendations are limited by the specifics contained in the complaint received. In other words, the public protector can't investigate or make recommendations on things not specifically complained about. And that we know that recurring and systemic failures in organs of state, be it municipalities or SEOs, is what the public protector investigate for the most part. How do you think the public protector could address these recurring and systemic failures that seems to be a range of things in many municipalities, in many SEOs, but it is the same problem? How do you think the public protector could address these failures given the current set of limitations within the law?
Thank you very much. I think one thing from public service administration that we need to consider is that there has been an attempt to actually build legislation to the extent that it manages to allow us to have one public service, because these are the challenges in terms of governance that we have. And that's why you'll find that in the provincial and national sphere of government, certain things are happening this way, and maybe certain things have been properly controlled, and then you go to local government, you find that some of the things are just not properly attended to. So the Department of Public Service and Administration is still continuing to work towards establishment of one public service, which will actually, to some extent, be in the position to deal with the scope, this big scope that you're talking about, Honorable Member, in a way that will actually become finally effective. But also, what is important looking at the work of the public protector and looking at the state capture report is that it tried in one report to try and pull together what was a big scope of what is a challenge. And maybe even at local government level, something like that is required, so that then there could be a process that actually zooms into these problems in order for those problems to be dealt with.
Thank you. Then my last question. In recent years, the legitimacy of the public protector came under fire for a range of reasons. Now, I'm sure you as a former politician and we as current politicians knows very well that legitimacy and public confidence are directly linked to one another. Should you be appointed, what would you do towards fully restoring legitimacy and, by extension, public confidence in the office of the public protector?
Thanks, Honorable Member. I think it's very important, like we talk about public confidence, that we continue to actually promote programs within the Office of the Public Protector that will make the Office of the Public Protector to work closer to communities. In that way, communities will have an opportunity to participate in the processes within the Office of the Public Protector. Earlier I talked about maybe in certain cases when you find that, where you could find that organized groupings of communities could actually act as the friend of the court when there are matters before the court that have got to do with the Public Protector. In that way, it doesn't really become just the Office of the Public Protector, it becomes the office of the people, because the Public Protector operates closer to the people. But also, there's issues of competency and capacity within the Office of the Public Protector that also needs to be looked at, so that when somebody is appointed as a public protector, as a deputy public protector, how do we ensure that the necessary competency and capacity is there?
Thank you. Honorable Klopper.
Thank you, Chairperson. Good day, Doctor. You've
Good
indicated...
day, Honorable Member.
You have thoroughly indicated that you understand the separation of party and state through various questions that were asked, and that you would be completely unbiased in exercising your duty. Am I correct? Am I correct?
Yes, Honorable Member.
Thank you. Doctor, during your tenure in Parliament, corruption was possibly perceived as being at its peak, with the state capture reports coming in at that time and so forth. Were you aware of any activities or decisions that indicated corruption or maladministration linked to state capture? And if so, what was your understanding of the impact of governance and that of public resources?
Mike.
If I understand the question very well, it's about the impact that the state capture report has had
Yes, and
in
were you
terms of
aware of any
governance
of it?
and public resources.
Correct. And were you aware of anything?
Yes. State capture report was actually adopted when I was still a member of parliament, and the recommendation thereof was that there should be establishment of the commission to investigate issues that were actually raised in the state capture report, and the Zondo Commission was actually established and it concluded its work. And the Zondo Commission itself has got recommendations that are now before the NPA.
Thank you, Doctor. What specific steps did you take, if any, to address or prevent corrupt practices? If you can provide anything that you did specifically as a member of Parliament at that time?
As a member of parliament, we belong to committees in parliament, and committees actually is a vehicle for us as members of parliament to actually exercise our oversight role. So our oversight role would be in a form of reports that are actually brought before us. And the kind of recommendations ourselves we give once we've received these reports. So just through oversight, once you are a member of parliament, through oversight, you are in the position to actually then manage to deal with matters of that nature.
Doctor, are you saying that you spoke against the state capture? Did you verbalize that when I asked you earlier, you said you were aware of the state capture at that time. Did you verbalize it to those who might have been implicated, rumors that you maybe heard around the passages? We're obviously receiving voluminous reports of many things. Did you ever vocalize your stand against state capture?
As a member of parliament, when a report is actually brought before you, like I've indicated with the Office of the Public Protector, there will be matters of public interest where you find that reports are actually brought to parliament. And of course, I'm sure we understand the process of bringing reports to parliament. If it's about the public protector, it will come to the Portfolio Committee on Justice and Constitutional Development, and it will be deliberated here and adopted here before it's actually sent to the National Assembly. And then there should be actually then adoption by the National Assembly through votes, which are in a form of political parties.
Chairperson, my last question, do I have time? Chairperson, I just wondered, looking back... Pardon me?
3 seconds.
Right. Looking back, do you think you could have done more to prevent and expose it? I mean, you were a minister, you were in the executive. I mean, this was maybe after the report, but I mean, corruption's not new and it's not ending. Do you think in your tenure you could have done more, looking back, to try and prevent it, expose it? Because it affects the people of this country. It's the taxpayers' money. It's service delivery that gets halted because they aren't getting money because it's been stolen. And I think we all in Parliament need to take an active role in that, and those in the executive have to take a particular role to that, and the application that you have put in as a Deputy Public Protector has to champion this at all costs, even if it causes interpersonal relationships between you and people you might know. If you could just, what would you have done differently and what could you have done more? Thank you very much.
I think at a personal level, as the member of the executive, there's a lot through my portfolio of public service and administration that has been done. Luckily, it's a competency of public service and administration. So a lot of work has gone into building systems and mechanisms of ensuring that corruption is dealt with decisively. And I've actually mentioned some of the establishments or measures that were actually created, like the ethics, integrity, interdisciplinary technical assistant unit that manages to help consolidate and build capacity around the work that government is doing on corruption. I talked about the Office of Standards Compliance, which actually is an office that entrenches public service norms and standards across government to ensure that the values and principles that have to actually prevent corruption are actually entrenched within the system. Not only that has been done, even the lifestyle audits that I talked about. The policy document was developed during my tenure. It was implemented during my tenure. We haven't actually managed to, by now, implement it across government, but there is a certain section of government where it has actually already been rolled out, where we actually look at unexplained wealth in order for us to be in the position to inform ourselves. And there's also a system that is used by Treasury. It's a system that interrogates what is called CSD, Central Supplier Database, where the procurements that have been made for a month are looked at and who are the owners. And this is compared to the IDs that we've got on PESA. And that's how, as government, we manage to identify public servants that are actually doing business with government. And a lot of public servants have actually been dismissed for doing business with government. We have participated in a number of forums at BRICS level on corruption. We are part of the United Nations Convention Against Corruption. We've hosted a number of meetings here where many countries would come, because also what is important is always to be in the position to engage other players outside South Africa for good and best practice. We have been in the position to, and we were the only country, by the way, that was for a long time a member of OECD, Organization of Economic Development. It also looks at issues of corruption because it's about economic development, but also it looks at how to counter corruption. At AU level, similarly, SADC level, there are processes. So we are a government that is, I work for a government that was really serious about building systems that will actually deal with corruption, because we want to build the confidence of South Africans in government in order for us to be in the position to govern together.
Thank you. I think we are happy to learn that we are part of the erstwhile landmark judgment on the principle of male primogeniture. I think some of us would have learned about it when we were doing LLB in university, but I think it has contributed much in the development of the jurisprudence in the country. So I think it's part of the things that we pride ourselves on. Of course, it's an equality related matter. So I'm not sure if you follow the certification cases that would have cemented the establishment of the institution of the public protector? And if you do, what do you think were the objectives of the establishment of the Office of the Public Protector in South Africa?
Thank you, Chairperson. I think the question is whether I do follow certification
The certification cases.
cases.
Yes, you have two of them.
Okay.
They are called the certification cases.
Yes, certification
They
cases.
actually directed and cemented the establishment of the Office of the Public Protector.
Okay. Basically, you know, cases that are actually dealt with within the Office of the Public Protector have categories.
No, that's not the question.
Okay.
The question is not about the public protector dealing with cases. The question is a constitutional court certification cases that certified the establishment of the institution of the public protector. So if you follow that, what are the objectives that has led South Africa to establish the institution of the public protector?
Thank you, Chair. Trying to think about those cases, certification cases, but what has actually made the Office of the Public Protector to be part of Chapter 9 institutions in terms of the Constitution? Because the Office of the Public Protector was established according to Section 182 of the Constitution, was to make this office to be part of institutions that are to support democracy because of the constitutional democracy system that we now are operating in, that has got as a foundation the Constitution of South Africa. And of course, this Constitution, for all of us know that it had a lot of influence from the Freedom Charter of the people of South Africa, with the one clause that is famous that says South Africa belongs to all who live in it, black and white, which actually says everybody needs to know that South Africa is their country, they own it. Ownership is very important of everything because then it actually makes it easy for participation and consultation.
Thank you. What is your understanding about the jurisdiction of the Public Protector South Africa?
The jurisdiction of the Public Protector is South Africa, entire country.
Okay.
It is the three spheres of government: national, provincial, local. It also goes beyond to state.
Maybe let me help you. Let me come to your rescue. The jurisdiction in the form of what matters can the public protector investigate and what matters the public protector cannot investigate.
The public protector may investigate improprieties in the public sector and maladministration in public service.
Okay. What is your understanding of the concept fit and proper person? And do you think that you are a fit and proper person?
Yes, fit and proper means you have the necessary ethical background and integrity for you to be fit and proper. And also you have the necessary capacity to be in the office of the Deputy Public Protector.
What is your understanding on the rule of law and the principle of legality? And what is the dialectical relationship between the two concepts?
Observance of the rule of law is something that actually is against impunity. where there is violation of this rule of law, then there must be accountability. And then when it comes to legality of it, is when the manner in which the rule of law is actually applied.
Okay. Do we agree that the remedial actions of the public protector are binding?
We do agree, Chair, that
Okay.
the remedial action of the public protector
Okay.
are binding, and they are based on case law that emanated from the EFF versus the Speaker of Parliament case that was around.
You have
the
already
Nkandla
answered my second question.
recommendation, yes.
You have already answered my second question, because I wanted you to take the committee through the binding effect of the remedial actions. Where did it start? How did it start? And stuff. So you have already mentioned the EFF and the Democratic Alliance versus the Speaker of Parliament, which is the landmark case judgment as well. Oh, I'll ask 3 questions at once. On the issue, fortunately, we're a former CEO of the Gender Commission. So the public protector would have issued out a report which investigated systematic deficiencies. It is systematic investigation into administrative deficiencies relating to GBV within the South African justice system. So, how we agree that GBV is a current problem in the country. How do you think the office and the institution of the public protector can help the country in fighting GBV? 2, how do you think the public protector South Africa can improve access to it, as in receiving complaints? Generally, there are issues relating to case-based backlogs and finalization of matters. So how do you think the public protector South Africa must deal with case backlogs and improve its investigations or its investigative capacity?
All right, maybe we should look at GBV first and how the justice system can actually be improved around GBV. What is good is the kind of approach that we have as a country to GBV. I think we all remember that around COVID, the president labeled it second pandemic, and it was then subsequently followed by a number of activities and events, including the beginning of establishment of a bill on the gender-based violence council. I think it's now in act. I'm not sure. I have to go and find out at what stage this is. But also, there was also through the Ministry for Women, development of the National Strategic Plan for Gender-Based Violence and Femicide. And then it was a report that was adopted by Parliament. And certain undertakings have actually been made at Parliament level that every government department must then begin to look at what their role is in terms of this National Strategic Plan for Gender-Based Violence and Femicide, so that they can then infuse in their own plans these measures to ensure that we intensify the fight against gender-based violence. What I like about the committee is that you dealt with 3 pieces of legislation. That was actually to strengthen the approach of courts in dealing with gender-based violence. And then the other question was access to receiving complaints by the complaints at the Office of the Public Protector. I think awareness programs could actually help people to understand processes of managing to access the Office of the Public Protector, if I understand the question very well. And then also the backlogs. What do we do with the backlogs? It talks to capacity, because when you look at Section 3 of the Public Protector Act, it actually also talks about staff. What type of people we need to have within the Office of the Public Protector, because this talks to capacity, because when you talk about backlog, also backlog talks to capacity. And there's the main figure there, which is the Chief Administrative Officer. They're supposed to actually be appointed by the Public Protector. The Public Protector can actually even get people that are seconded from other government departments if the Public Protector realizes that there's lack of capacity, but otherwise, through the rules of the Office of the Public Protector, they indicate as to the type of personnel, the qualification of personnel, and I'm sure we understand that such rules are actually gazetted and are approved by Parliament.
Thank you very much, Dr. Machake. It's been a nice conversation. We call it a conversation, we're conversing. We thank you for availing yourself. We thank you for coming to the committee. We see your flight time is soon approaching. We thank you for coming. We always appreciate those who are willing to come and assist the state execute its own mandates. The committee will sit in a date set by committee to deliberate on the candidates and their performance and what we are looking for. Then candidates are going to be informed in due course. Thank you very much. We wish you a safe travel back home.
Thank you, Chair, and thanks to honorable members.
Thank you.
Goodbye.
Members will take Advocate Advocate Dube. Then at 2 we'll be going for lunch. Then come back at 2:30. So you can go get a water break whilst the candidate is coming. Let me hear. Advocate Dube,
Good afternoon, Chair. Yes,
how are you?
I'm very well. Thank you very much.
We are
And
well.
how's the chairperson?
No, we're fine, we're fine.
Thank you.
We're going to have a conversation with you. We call it a conversation deliberately. There's water next to you. Relax and feel free to share with us your understanding of the public protector as an institution and the deputy public protector as an office. So I'm going to ask you just 3 questions. Then I'll give members to ask questions. Do you confirm that you are the one who signed the questionnaire we sent, and you confirm the declarations you made in that questionnaire?
Yes, indeed, Chair, confirm.
Is there any other thing you wish to declare?
No, no, Chairperson.
Okay. Now, tell us about yourself for 5 minutes. You tell us about yourself. You will tell us why do you think you are a suitable candidate for the position of the Deputy Public Protector.
Thank you very much, Chairperson. Let me start by thanking the committee for the opportunity to be interviewed. I do believe, Chair, that I am bringing a very unique experience and skill set. Members would have noted in my CV that I have spent about 25 years in the public sector. I've served in a number of constitutional bodies, for example, the Gender Commission, the Human Rights Commission, and of course, the Public Protector. In that 25 years, I've had the opportunity to serve in a number of senior management as well as executive positions, and the exposure I've had is quite diverse. Not only did I deal with matters of complaints, resolution, investigation, which of course we refer to as administrative justice investigation. I've also had the opportunity to work in institutions that provide critical oversight over public affairs. And with this, I would want to highlight the work that I've done at the Public Protector. In 2012, I got appointed as a senior manager in the Office of the Public Protector. And my main role really was to establish a new unit at the time. That was the Intake and Assessment Unit. Within 2 years of having served in that role, the office entrusted me with the responsibility to go to the Provincial Office of the Public Protector in Gauteng, which at the time was inundated with a lot of backlog of cases. And with the team, I was able to, within a year, really turn it around, and we reduced a backlog of cases from 4,000, we halved it to about 2,000. And by the time I left, we had stabilized the organization. And currently, members, I am the Director General for the Public Service Commission, which is another constitutional body, as we know, in terms of Chapter 10. And perhaps to highlight my work at the PSC is that of an accounting officer in terms of the PFMA. And of course, I support the Public Service Commission as the head of administration in terms of Section 14 of that Act. The highlight of my role as the PSC is the fact that together with the team, we have been able to retain the clean audit status, for at least for the 3 years that I've been there. I'm now into my 4th year of serving as the head of administration in the PSC. I also believe that I played an instrumental role in really turning around the way we conduct business by utilizing technology. We've automated a number of our HR systems, which was an area that was causing a lot of operational efficiencies. Today, when you go to the Public Service Commission, you're going to find that we've migrated from utilizing the manual systems of managing our leaves, our performance management system. We've leveraged technology to improve our efficiencies there. I also believe that I have supported the Commission in its repositioning. Members would have noted really the increase in the visibility of the Public Service Commission as part of its repositioning, and my support is to ensure that our communication team is then able to strategically communicate the important work and products of the PSC. I thought I would also indicate, members, that the experience I have gained and the knowledge and skill set has really afforded me somewhat of a 360-degree experience. I believe that it is well-rounded in a sense that from administration perspective, being a manager and a leader of an organization, I have attained that experience. But on the subject matter itself, when it comes to mechanisms for resolving complaints amicably, the approaches that will assist us in investigations to deal with systemic deficiencies that would have identified, I do possess that experience. With that, perhaps I wanted to share the approach that we took at the time when I was heading the Office of the Public Protector in Gauteng. It was inundated with a number of complaints around undue delays to really deal with the applications on RDP. And together with a team, which is what really assisted us to be able to address the backlog that pertained at the time. So together with the team, we came up with a strategy to say, seeing that this is a systemic issue, the response from the public protector should be that of a systemic intervention. And so we work in a collaborative way with the Gauteng Department of Housing, where they would then give us monthly reports on where they are with addressing those matters that have been referred with the public protector. Perhaps I also do want to highlight that in the sector of ombudsing itself, I've also had the opportunity to serve not only as the acting ombud for the city of Joburg, was a director, the adjudicator general at the Committee Schemes Ombud Service. So the public protector is known generally as an ombud. So my experience is not only with working in the public protector office as an ombud itself, but I also do have knowledge on sectorial ombudsman, and as part of my experience. Insofar as my academic qualifications is concerned, members would have noted that my chosen field of study is really a reflection of my area of interest. I have concluded a master's in constitutional law and human rights, as of course I've obtained an LLB, as well as a BA in law, all of that from the University of Witwatersrand. That to me is really an indication of where my interest lies. It is in the area of human rights, it is in the area of public interest law. And perhaps to end of my submission, members, is to then reflect on the approach to leadership that I subscribe to. In terms of my leadership approach, I believe in first and foremost service excellence. I believe in ethical conduct. And in the 25 years that I have been in the public service, I believe that I've conducted myself with integrity and displayed the highest standard of professional ethics. And lastly, of course, the principle of good governance and running clean administration. And how I manage and lead is really centered around the principle of Ubuntu. I do believe that with the experience that I've acquired over the years, it has then enabled me and equipped me to be able to support the public protector as a deputy public protector. And lastly, members, I have the opportunity to serve in the Forum of Institutions Supporting Democracy is a secretariat. That is the forum that all Chapter 9, Chapter 10, as well as Chapter 13 bodies of a constitution have created so that they are able to engage, share ideas, as well as collaborate on areas of mutual interest. And so being a member of the Secretariat then has allowed me to be able to keep abreast as to not only the issues that affect the Public Service Commission, but of course understand the current challenges that face the Public Protector. I do believe that I would be able to contribute in really assisting the current PP realize the vision and ensure that we are building a very strong and resilient organization, particularly in the current time of fiscal constraints. Thank you very much.
Thank you. Honorable Klopper, Honorable Engelbach, Honorable Nomvalo, Honorable Mutawong, Honorable Zotedze, and Honorable Matafa.
Thank you, Chairperson. Good day, Advocate. Advocate, you spoke about municipalities and building their moral fibers. I'm of the opinion that the moral fibers of municipality have absolutely, almost completely eroded. With corruption, jobs for friends, tender manipulation, stealing of public money. You mentioned poverty, inequality, and unemployment as three of the biggest challenges. While they certainly are, would you also agree that the absolute waste of public money, funds, theft and corruption and so forth are some of the major contributions and are affecting the poorest of the poor in particular? It's really creating I wouldn't want to say what I'm thinking, but it's really creating a bad situations for the lives that they live in. Would you agree that the corrupt officials are just actually stealing their money, stealing the service delivery? And what would you do to tackle this head on? I'm going to just pose my second question to you, just keep that. Resolution is pretty simple. You spoke about amicable resolutions, and resolution is simple between communities and poor service delivery. Those who are paid to do a particular job should just be doing it. Those paying rates and taxes should just be getting what they are paying for. In other words, those who are paid should just be held accountable for what they are not doing. Being shady and dodgy is simple, and they are just stealing money through corruption. Do you believe that this will build public trust? Should you be able to tackle these problems and corruptions, systemic problems in government, head on? Should that not be the main focus? We speak in circles about, the job descriptions and so forth, but at the end of the day, it's very simple. Hold those accountable for what they should be doing.
Thank you very much, Honorable Klope. I would agree, and that is why in my questionnaire, I highlighted that the biggest challenge that the public protector faces today is really addressing the industrial scale corruption that we have seen as evidenced by the Zondo Commission. So the magnitude of it is often said is really a tip of the iceberg, because as we know, the Zondo Commission only looked at a select few departments in the national as well as provincial departments, as well as some of those SOE. But the magnitude of it is such that it is starting to really rob of ordinary South Africans of the basic services that government should be providing. So what is it that I would propose we do as the public protector to really contribute to this anti-corruption agenda? The first thing is that we need to deal with the ethical fiber that has eroded in the public service. And of course, in the entire public service sector. How are we going to do that? For me, Section 195 of the Constitution that outlines the values that should really govern the character and the ethical value system of the public servant needs a lot of work to promote, to inculcate a new culture that is informed by professional ethics. So that's where my start will be. The Public Service Commission is entrusted with that responsibility of promoting the values and systems that are in Section 195. The PSC is a strategic partner of the public protector, not only through the signing of the MOU that we have, but of course in the forum of institutions supporting democracy. So there's a huge opportunity for the public protector to really collaborate with institutions that have the common purpose, so that then together we're able to start inculcating a culture and a value system that is informed by ethics in the public sector. So that should be the one intervention. The second one, of course, is, as we've heard members, that the current important public sector reform that is underway is that of professionalization of the public sector. The important thing about it is that it's not only limited to the public service in terms of national as well as government department, it's also going to be focused in municipalities. And so there is a role for the PP to play, collaborate with institutions such as your National School of Government, identify what has been over the years, the systemic deficiencies, particularly when it comes to governance and ethics, and use that as a vehicle to really educate, raise awareness to public servants to say what it means to come and serve in the public sector. So that is another intervention that one would make. And of course, there's an opportunity for the PP to utilize the data that has been produced over the years by institutions such as your Auditor General. So we know that the AG has found over the years that there has been this increase in irregular expenditure, especially in municipalities. We also then utilized the data from Statistics SA to be able to pinpoint which are those municipalities that are currently dysfunctional and what sort of intervention is required to be done in order to empower those. The main issue that has been reported around the problematic areas in the municipalities is, of course, the capacity of chief financial officers. We've seen reports where a number of CFOs are actually not even qualified for the positions that they hold. So that would be, for me, an area that we would recommend that for the PP that we target. Important skill of capacitation, upskilling, but that always should be matched with the awareness around just professional ethics, understanding that as a public servant, you are there to serve, that it should not be to benefit your own personal interest. So that would be my recommended approach, collaboration with institutions that do similar work, use data to be able to identify where are the systemic deficiencies, and of course, what would then be the intervention that would need to be done. Work with institutions that are doing work in this space of course already. As I said, the National School of Government. I believe also the Justice College could also be utilized to be able to, run training programs to empower our investigators to understand issues of ethics as well as misconduct. So the next question, member, you mentioned around the opportunity to resolve complaints in an amicable way and how we would approach that, particularly when it comes to communities and service delivery complaints. So for me, I believe that this is another important intervention that the public protector can make, and that the role of the PP should not always be about taking the stick approach and using your hard power. I believe there should be a balance to utilizing the soft power, which is, of course, collaborating with government institutions, state institutions, working with communities, be the facilitator that then brings government as well as communities together. That, I believe, is the role that we would want to assist the PP with. I would want to, for example, learn the lessons currently with the model that is utilizing the Public Service Commission. There's a project that is called Citizens Forum. This is when the public service commissioners will go to communities, work with the local government as well as the state entities, identifying what are the problems that affect a particular community, and then convene an engagement, recall all the role players, all the stakeholders, to then address the specific community issues that affect that particular community. What is important about that approach is that it allows institutions to actually go to the ground, even to the remotest areas of our country, to then address the specific community problems that pertain in that community. So that would be my proposed approach, Honourable Member.
Honourable Engelberg.
Thank you, Mr. Chair. Good afternoon, Advocate Dube.
Good afternoon.
Well, you have very extensive, high-level experience in the public service, and currently you are the Director General of the Public Service Commission. So I only want to know why would you want to become the Deputy Public Protector, and what do you think it is that you can add and do differently in that position than, because your current position is also, it's very important in terms of governance in South Africa. It's crucial that we do things on that level correct. So why do you want to move to the public protector side of things in the state?
Yes, thank you very much, Honorable. Members, if you have noted that this is not the first time that I am, trying for the role of the Deputy Public Protector. Of course, this is the first time that one is then able to be afforded the opportunity to be interviewed. So it has always been an area of interest for me. Having had these diverse experiences you have noted, I'm at a point where I'm able to identify where I can be able to serve this country better. The role that I'm currently playing in the PSC is indeed a critical one, because as the accounting officer, we need to ensure that we run and manage operations in a way that is in line with the PFMA. However, what you do find is because you are entrusted with the day-to-day management of the organization, I hardly find an opportunity to actually be involved in the subject matter issues themselves. My experience has always been around dealing with complaints, interacting with ordinary members of the public. But if you look at the role of the Deputy Public Protector, it will then afford me that opportunity to really be involved in the case work itself, which I believe is my strongest area. I've done very well in my current position. I'm in my 4th year now as the DG of the PSC, and I believe that that too has enabled me to be able to support the Public Protector as the executive authority of the DPP. As to what are the areas I believe I could be able to contribute and what I would recommend for the PP to consider, it has become evident that dealing with matters arising from the contravention of the Executive Members Ethics Act, the EMIA matters in the PP, has really not been possible to have those matters resolved within the 30-day turnaround time that is legislated. So for me, that should be the first issue that I would recommend to the PP to say, perhaps we should use the historical data that tells us that the complexity of these cases are such that they require a lot of investment in terms of time, in terms of resources, so that then the PP is able to deliver quality reports after having investigated EMIA members. And so we would then need to recommend a review of those turnaround times so that we have very realistic turnaround times. So that would be the first. The second one, members, for me is we need to have a much more rigorous outreach campaign. The Constitution says that the public protector must be accessible to all persons and communities. If you look at the number of complaints that the PP has dealt with, out of a population of 60 million, it's a lot, 40,000 or so. But that, in my view, is not sufficient if you compare the potential client base of the public protector vis-a-vis those that end up on the shores. So we need then to understand that are they not reaching the public protector because they don't have service delivery related complaints? Are they happy with the quality of services that are being delivered? Or could it be that perhaps they are not aware of the PP's existence, and if they are aware, perhaps they are not able to reach the offices of the public protector. So in addition to utilizing technology, which I know the PP has actually done a lot with that, making the office accessible by being able to lodge complaint through, the SMS, I do believe that you should still be able to go to communities directly. So a very focused, rigorous community outreach campaign, that would be one will contribute. Of course, I will use the experience I've had while I was still at the public protector, because at the time it was the former PP advocate Madonsela would then on an annual basis have focused stakeholder engagements. We go to communities, we ensure that we address the community problems that pertain at the time. Secondly, member, I do believe that with regards to the limited resources that the public protector has reported about, there now needs to be a need to really think innovatively, how do we optimize the limited resources we have in order to still to stretch the budget, because as we know, there's been across the board budget cuts that have impacted many of the organizations. So we then need to have optimal utilization of the current limited resources we have, and using technology, for me, has demonstrated that it is an opportune way of doing that. For example, as I said, in the Public Service Commission, just by automating our systems and using less paper, we have saved quite a bit on our operational budget. We can also learn a lesson from the period during COVID-19 and how really, government was able to deliver, services. Look at the example of SASSA by utilizing technology, and certainly institutions such as the public protector would benefit a lot from that. Lastly, just taking cue from my character and how I have conducted myself through all the years, members would have seen in my disclosure that of all the 25 years, I have never had been subjected through any disciplinary process. I believe that I'm an ethical leader, and institutions such as the public protector requires individuals of the highest standard of professional ethics and caliber. And so I do believe that with all that diverse experience, I'll probably contribute more better at the public protector and not the PSC. Not that I'm not doing well in the PSC. I believe we are doing the best we can to support the organization. Thank you.
Yeah. Do you know the saying that says you cannot be a judge in your own case? Honorable Nomvalo.
Good day, Advocate Dube.
Good day, Honorable
How are you
Member.
today?
I'm very well, thank you.
I'm well as well. The question that I have, I've got a couple of questions. But the first one is, for me, according to my observation, the most undesirable challenges which are currently facing the public protector's offices are twofold. The public protector's office are twofold. Firstly, the first one is the inability to complete the investigations on time, in terms of the time frames, the prescribed time frame. And then the second one is the lack of accessibility by the members of the public to the public office, to the public protector's office. Do we share the same sentiment?
Yes, I would agree with that, Honorable Member. Through my research, I've been able to identify that the biggest challenge facing the PP is the funding. And that then has a rippling effect on the quality and the time that it takes the institution to complete the investigations. And so while I agree that indeed the inability to conclude matters within the set timeline is a challenge for the office, it's important for us to really look at what is the underlying root cause of that. As I said, according to my research, I was then able to pick up that the funding is inadequate. So much so that in the previous financial year, the public protector has had to approach the Criminal Asset and Recovery Fund, the CARA fund, in order to augment the capacity that it has. So that is the one aspect around the inability. Secondly, having heard the presentation that the Public Protector Advocate Galega made to the committee when they were filing their annual report, is that they need to really upskill, continuous training and retraining of the investigators is also another area of focus, which I believe that will then, of course, empower them to be able to, in future, not only handle the volume of work that comes through, but also be strategic about what cases are we going to investigate and utilizing the formal way of investigating, what others are we going to utilize the alternative dispute resolution mechanism so that we're able to resolve them amicably. On the lack of accessibility, I could not agree with you more, Honorable Member, and that is why, for me, I believe that this project that the Public Service Commission is doing around Citizens Forum is a model that perhaps, can be shared and utilized by the Public Protector. But in addition to that, there's a huge opportunity to run continuous education awareness campaign in community radio, various media platforms. The Public Protector is fortunate in a sense that it has footprint in the entire country in terms of presence of official offices. So utilize the provincial offices to really talk to community radio station. I know a member having done some work many years ago at Soweto Television because, I had created this program around, consumer education. I know that community media are constantly looking for information, particularly that information that is meant to educate and empower community members. So that would be another area that I would propose we focus on as a Public Protector.
Okay.
Thank you.
Yeah, no, the second one, I'm sorry for cutting you, it's because I want to ask you two more questions, so I'm trying to save time. Then the second one relates to the review applications, which are constantly taken to court against the Public Protector's reports. It's very undesirable when such applications are successful because as a consequence of that, the Public Protector's office sometimes is instructed to pay party-to-party cost, whereas it is operating under a limited budget. To avoid that, what would you do when you do your investigations to ensure that even when the matter is taken on review, there are no prospects of success? What measures will you put in place?
Thank you. To answer that question, one has to then go through some of those judgments and understand what the courts are saying about the failures that have been identified in the Office of the Public Protector. And in this case, I want to refer to this important landmark case of Public Protector versus Mail and Guardian, because in that case, it was made quite clear that the approach that the Public Protector takes in terms of investigation, you've got to really be thorough, and that in order for the outcome to be able to withstand scrutiny, we must conduct a very thorough investigation, of course, going through the methodologies of ensuring that you have the evidence, as well as the necessary witnesses that needed to be interviewed and produce a report, findings that really talk to the evidence that is before you. The second case, for me, case law really assists us already to say to the public protector, these are the areas that would need to be addressed in order to ensure that we limit the number of review cases. The other area, for example, is when the public protector is faced with a case where she would need to exercise the discretion. Let's say it's a complaint that has been lodged for more than 2 years, right? So in terms of the Public Protector Act, the PP will then need to exercise discretion to determine whether or not to accept that case. Now, the courts have been clear in this instance to say the principle of legality and the PP must be rational as well as reasonable, and ensure that you don't take arbitrary decision when you are exercising the discretionary power, whether to accept or not. And I believe that case is that of Gordon.
I think we have said, you've said it all. Except the fact that I was expecting maybe you to briefly also talk about the OD alteram principle to ensure that the report has no loopholes. You know, all the relevant aspects have been, listened to, all the relevant parties who are affected. Because in most cases, reports are taken to court on those bases that have not been given an opportunity to present my case, by the public protector. Then the last question relates to I think I've asked this one of time frames. Can the public protector investigate a matter which has already been investigated? Say, for instance, the SIU investigates issues of corruption in eThekwini municipality, and then the community or whoever complained in the SIU does not get satisfied with the SIU report, and it goes to the public protector with the same allegations. Can the public protector pursue that investigation?
Thank you, Honorable Member. The answer to that would be yes or no. Yes, in a sense that the mandate of the public protector in terms of, Section 182 of the Constitution, 182 of the Constitution is quite wide, and that the PP can investigate any matters that relate to improper conduct in state affairs. So the first step really when that matter reaches the shores of the public protector is to determine whether we have jurisdiction. So that is the yes part. The second part will then to say, we then look at what has been done before the person has approached the public protector. There's a principle that is often followed about exhausting internal remedies if, of course, where the person comes from, they have mechanisms to resolve complaint. We expect them to have done that. And if they have not, we will then refer them back. But in this instance, what the Office of the Public Protector would do, and that is when the discretion comes in, is then to say, we want to avoid forum shopping. That's what we normally say, because the state has limited resources. You don't want to duplicate work that's already been done by another institution that shares a similar area of competence. So in this case, it might very well be that the public protector may opt to utilizing the discretion not to investigate the matter because it has already been dealt with by another entity that shares a similar jurisdiction.
Thank you. No further questions.
Thank you, Honorable Nomvalo.
Thanks, Chair, for the opportunity. Good afternoon, Advocate.
Good afternoon, Honorable Member.
Advocate, if you can be given an opportunity to be a DPP, will you inspire confidence internally and externally in the institution? My second question will be, in a situation where different state of organ ignores or refuses to implement remedial actions, what will you do as a new DPP?
Okay. Thank you. On the first question, Honorable Member, I will try as best to answer because the chair has already said you can't blow your own horn. But perhaps in my answering that question, it's important that I refer to the experience. As I said, I have been working in the public sector for 25 years. I've been a senior manager since 2005. And wherever I've worked and wherever I've served, to this day, colleagues, still call. So one is then able to build a very strong team. So I have not been in situations where there's a conflict. If anything, my training as a mediator at the Singapore Mediation Center really serves me in a sense that one is able to approach leadership in a way that builds, that creates harmony in the organizations that we serve. So I do believe that I would be able to contribute to the Office of the Public Protector, support Advocate Galega in her vision, and of course inspire confidence. I'm saying that because if one looks at just my track record and what I've been able to achieve in many of the organizations that I've worked for, I've joined other been given the opportunity to start anew, start afresh, set up systems, streamline processes, create functional organizations, or I've been entrusted with the responsibility to really turn it around. And I must say that the feedback that one gets as a leader is that we've been able to do well there. So I do believe that from that perspective, I would certainly be able to inspire confidence, especially because if you consider where the public protector has been in recent years and taking cue from what the PP says is really the priority area is to deal with the morale of the team. I would, for example, go to the Office of the Public Protector, use the lessons that one has learned in my current capacity as the HOD to really have a much more focused employee wellness program. We'll start by first thing doing a climate survey, really just to understand what is the state of health, how is it that we can empower employees, and of course then build programs that are dedicated at addressing the employee morale. And I believe that, and of course team building exercises, that's how you build confidence. The last question, member, around what are we going to do to follow up on the non-implementation of the recommendations of the public protector. As I said, for me, the approach of the PP must always be a collaborative one. Work with these departments. Let's identify which are the ones that are repeat offenders. Those that are recalcitrant, repeat offenders, perhaps we may need to use a bit of a hard stick. But the others, you work with departments, have a mechanism that you monitor on a monthly basis, track how far are they in implementing those recommendations, and of course utilize important structures like the Auditor General. I find that they are using, for example, the current mechanism that exists within government where they engage with cabinet to identify, to pinpoint where the areas of concern are. I believe that is also an opportunity for the PP to do. Let's start really engaging with HODs in the forum of Director Generals. PP can utilize that as a platform, and of course utilize cabinet as a mechanism to ensure that there is a compliance in the implementation of the public protector. Say, as the last resort, PP reports to Parliament. Of course, we would have to those departments that continuously are repeat offenders will use this platform when we report on an annual basis to us to request members' intervention in terms of ensuring compliance. Thank you.
Okay. A bulk of Public Protector South Africa's interventions and investigations relates to service delivery failures, which affects people of South Africa mostly. Do you believe that the PP South Africa could do more to address recurring service delivery weaknesses within organs of state?
Thank you. Yes, Honorable Member, I do believe that there is a lot more to be done, but how we do it, we really need to be strategic about it. We have to be able to identify those that we see will assist us address the biggest service delivery problems to have an impact. And I mean, we've seen a number of such interventions that the PP has done. One really as DPP will be to support and strengthen that. For example, if you take the report of the public protector during COVID around how the health, facilities were really dealing with, COVID cases and the healthcare practitioners as well, the level of protection that they were receiving. So for me, doing systemic intervention or systemic investigation in addressing service delivery matters is the one that will help us have the highest impact.
The last one, just a second,
Okay,
Chair.
proceed.
DG, we have few female DGs in our department. I heard your explanation when Honorable Member was asking you if are you sure you want to leave the DG position to come to be a DPP. Your age, your experience, your qualification, your CV is good. I think we are looking for more female DGs in the department, as much as we want other institutions like Public Protector to be led by females and deputized by females. It's just a comment. Yes, your CV is beautiful. Thank you.
Thank you, Honourable Member. Can I maybe reflect on the comment?
Yes, you can.
Yes, that is an important observation to make. It is indeed true that, currently the country really is not doing well in getting women in these higher positions, especially in government as DGs. But I think it's a problem that's not only limited in government per se, it's a countrywide problem. And so what I would request the committee to do in reflecting about whether or not to appoint another woman in the office of the public protector, to really look at what that will do in the demographics of the country at large, getting more women in leadership, getting more young people in position of power. No, I'm not young anymore. I think I'm out of that bracket. But, we are a relatively younger, country, and I think there is the opportunity to do that, especially in important institutions such as the public protector.
Thank you. Honorable Zodedze.
No, thank you, Advocate. Thank you, Chair. Good afternoon. Look, just taking it from where Honorable Mutaung would have left it, the Chair would have asked you when you came in to tell us about yourself. Everything that you have said about yourself, they're all positive, they're good. They paint a very beautiful picture of yourself. I mean, you are here for that. I'm sure you are here for that. But would you enlighten us now? What are the areas that people often critique you for? And why do you think they critique you in those areas? Now, this is you laying bare to us, telling us, and this must be areas related to the work and so forth. So, yeah.
Thank you, Honourable Member. I have heard that I tend to be very pedantic at times and focus on the small things, which in my view are not small things. I'll give an example. The quality of a document, even a 2-page letter submission, if it is riddled with spelling errors or grammatic errors, I often tell my team that it actually doesn't attract me to read the document more. So I will send it back and I say, fix the I there, fix. Then the feedback would be, but you haven't even gotten into the content of the document. So that is often what is referred to as perhaps a weakness, or so to speak. And of course, I tend to be passionate about the work that others might see it as, micromanaging, especially if you're dealing with cases that have turnaround time. So I will call you more to say, how far are you with this case? I've been doing that as well with colleagues in the Public Service Commission, where sometimes you even ignore the hierarchy, you go straight down to the investigator. I don't know if that qualifies as an area of concern, but that is what the feedback one has received.
No, thanks. Now what is my observation? My observation is that you expand more when you speak about your positive and just go a bit when you speak about your weaknesses. But like I said, that is what you are here for. That is what you are here for. Now, can you assist us in terms of, you would understand that institutions such as the Public Protector operate mainly on the grounds of what we call independence. They are expected to be independent. What, in your understanding, constitute this independence of these institutions?
Thank you, Honorable Member. The importance really around the concept of independence of the Public Protector. Firstly, it is centered around the Constitution, that these institutions that were established to support constitutional democracy must operate in an independent and impartial way, and that organs of state must support and not obstruct the work of the Public Protector. What it also means for the persons that are serving there is that in making the decisions, they've got to make decisions without fear, favor, or prejudice. And I believe the PP's office has demonstrated that when you look at the kind of cases that they have investigated, because it does not matter a person standing in society, whether you are a senior ranking government official or a junior official, we have to then be able to investigate without fear, favor, or prejudice. And of course, we must remain neutral and non-partisan, and that will then allow the PP to make decisions that are fair and just, that then meets the constitutional threshold of just administrative action. So that would be my response with regards to independence. There is, of course, the talk around the financial independence of institutions supporting democracy, and whether the current model of having, for example, the budget of the Public Protector come through the Department of Justice, whether or not that does not, in fact, affect the true independence of the PP, and I believe that the Forum of Institutions Supporting Democracy are looking at another model. So, for example, the budget of these constitutional bodies is appropriated directly from Parliament, so that then you safeguard the institutional independence of the Public Protector. Thank you.
Do you have an ambition of being a Public Protector one day?
I would say yes, but not now. I want to qualify it, Honorable
I will tell
Member.
you why I'm asking that.
Yes.
Because the Deputy Public Protector obviously operates under the rule responsibilities delegated by the Public Protector. You come across as an individual with a dominant character. I wonder what it is that, I wonder if you will be able to work under delegated responsibilities and not being the one that is of the executive authority in that particular institution.
Thank you, Honorable Member. Just the role of the PP and that of the DPP, for me, is quite clear. The Public Protector is a constitutional office. It's established by the Constitution, which is the supreme law of the country. The Deputy Public Protector is a creature of statute, which is subordinate to the Constitution, so the Public Protector Act. And Section 3 of the Public Protector Act is clear that as the PP, as a Deputy Public Protector, you are there to assist and support the PP. So for me, that would be my fundamental point of departure, that let us be clear, the Public Protector and why I am there. The second part is, I believe it would really be unnatural of me to have worked 25 years and suddenly I start creating conflict, I start having difficulties with leadership. If you look at the position that I'm holding right now, we have a very strong commission. We are led by a strong leader, Prof. Fikeni. And in the commission, we have very robust debates in terms of the direction where we are going. But I must say, I'm 3 years into it. There has not been any conflict. There has not been any challenge of authority. And also, member, perhaps I should mention that my training as a mediator really helps me to navigate relationships, because in the end, for me, what motivates me is all of us working towards a common purpose. That really is what would guide me in terms of this relationship. Thank you.
Thank you very much, Advocate Dube. I have about 12 questions, but unfortunately our time has run out. I would have asked you about issues relating to the jurisdiction of Public Protector South Africa, the certification cases, fit and proper, the principle of legality, the rule of law, the budget. But I think my colleagues have covered a lot of ground in terms of our interviews, and so this is the end of the conversation that the committee has with you. We wish you a safe travel back home. We thank you for volunteering to come and help government better its execution of its mandate. Sometimes it becomes difficult to find officers of the court and legally trained people coming to volunteer to help better the public service, because some will just go to the practice and just don't care about what's happening in the public service. So we really thank you for that voluntary availing of yourself to help us. The committee will have a day of deliberations, then that's where the committee will resolve on what it makes of the interviews. Then all candidates will duly be informed of what would have been an agreement in the committee. So thank you very much. We are now excusing you.
Thank you very much, Chair, and committee members for the opportunity.
Thank you very much. Members, let's take a lunch break. It's now 2. Let's take a lunch break. Let's be back here at 2:30. So it's a 30 minutes break. We're going to the same restaurant. And the candidates, Advocate Dube, if you still have time, you can all go to the restaurant. What time is the flight?
She can join us for lunch. We change the flight.
They change your flight, so you can join the lunch. Sure.
the whole year.
Nomvalo is still going to members, can we settle? Good afternoon, Advocate Molesha.
Afternoon, Chair.
How are you?
I'm good, thank you. I hope you are also well, thank you.
We are good. We'll have a conversation with you. Just relax and do the best in your ability. There is water next to you there. It's meant to quench your thirst when that need arises. So I'm going to ask you 3 questions. Then members are going to come. So the first question is, do you confirm that you are the one who did the declarations in the questionnaire we sent you?
Yes, I confirm, Chair.
Is there anything else you want to declare?
I have none, thank you.
Can you just pull the mic close to you? Yeah. Well, I'm going to give you 5 minutes to explain who you are and why do you think you're a suitable candidate for the position of the Deputy Public Protector. You can start now.
Thank you very much, Chair, for the opportunity. My name is Advocate Sipokazi Molesha, and I work for the PCETA as a corporate executive. I have over 22 years of experience working in the...
Sorry, Robert Molesha.
I request that advocate can put the mic a little bit closer to her.
Can
It
you
is like
take the
this.
mic closer to you?
Yeah, better.
Like this?
No, do it in a way you are comfortable, but at
I
least
think
we
it's-
must
yeah.
be audible.
All right, maybe like this.
Yeah, we can hear you now. Can hear you. You can proceed.
So, do I start from scratch? Okay, I've introduced myself. I'm Advocate Sipokazi Molesha, and I am an admitted advocate of the High Court, and I work for the Public Services SETA as a corporate executive. I've got more than 22 years of experience working in the legal field, working in the administration of justice, as well as in the investigative space. I consider myself to have the requisite expertise, experience, and the correct attributes of the candidate of a Deputy Public Protector. I would like to maybe share with the committee my experience. I have, besides being where I am now at PCETA, I've been a head of corporate services departments in Gauteng, where in the main my job was the administration of justice. And it entailed also the component of legal services. I've also been the head of the IPID, which is the Independent Police Investigative Directorate in Gauteng. I've been head of legal services in the police services. I have been in the NPA as a prosecutor over the years. So in terms of my experience, I believe that I am a suitable candidate for this position, and I am looking forward to serve as the next Deputy Public Protector. I have expertise of investigating complex matters. I've dealt with a number of high-profile cases in my career, and I've conducted myself in a way that is beyond reproach. I am able to be impartial and take decisions. I'm accountable. I am able to, I have the highest ethical standards, if I may blow my own horn. And so in the main, when you're looking at the Constitution as well as the Public Protector Act requirements for a person who's fit and proper for this office, I do have the correct experience, expertise, and attribute to be able to do the work that is required of this office. Thank you, Chair.
Thank you. Honorable Dana.
Sorry, Chair, I just want to say that that's most of that experience is also contained in my CV and my written submissions. Thank you.
Yes.
Thank you.
Honorable Dana.
Thank you, Chair. Good afternoon, ma'am. How are you?
I'm very well, Honorable Member. Thank you.
That's good. I will start with two questions. The first one is, you mentioned that you worked on a number of high-profile cases. Were any of them very controversial, very contentious? Can you give us a bit of background? I'm thinking along the lines of difficult investigations that the Public Protector's Office, for instance, did, like the Pala Pala matter. So can you give us a bit of background around that, and how would you handle a difficult situation or case like the Pala Pala matter? That's my first question. I'll leave it for an answer and then I'll continue.
Thank you very much, Honorable Member. Indeed, I've been directly involved, firstly in instituting the investigation against the former head of intelligence, which is General Mdluli, when I was the head of IPID. So the whistleblower contacted me, and the whistleblower said, we believe that this is a cold case, and it being a cold case, I have evidence around this. So we initiated and it was quite contentious because of, firstly, the level of the general in the police, but also the fact that it was an old case, trying to track the witnesses and putting it together. To an extent that there were death threats against my life. However, I was steadfast to serve and ensure that the decision that I've taken, that there is a case to pursue, stands. I've also been involved and appointed to be part of the investigative team that was dealing with the rendition to Zimbabwe, where it involved the Hawks, the head of the Hawks, and basically some of the heads of the Hawks in Gauteng province at the time. It was also a contentious matter because you basically, shaking the feathers of people that do not want to be touched. But I believe that I am fair, I am firm in the decisions that I take, as long as they are within the confines of the law, and the fact that the rule of law must always prevail. Thank you, ma'am.
Thank you. There is a perception amongst the general public that government is, in many instances, not very ethical, not very honest. How will you go about ensuring that the Public Protector as an institution can assist in turning that perception around?
Thank you very much. Indeed, the Public Protector has had bad publicity in the past, and so there's a need for them to restore their integrity as the office. But in the main, what is important is the fact that you must change. If you are a leader in an organization, you have a responsibility to change the culture. And that culture needs to be defined. Those that which do not align with the culture will obviously not stay with that organization. So in the main, the values that must prevail there is for people who are beyond reproach in terms of integrity, people who have empathy for the people that they are serving, people who are accountable and transparent in the work that they do. Thank you.
Can I just ask a follow-up? Thank you. I like your answer regarding the institution of the public protector itself. But what can be done via the public protector's institution to ensure that government is perceived as being an ethical institution?
Okay, thank you very much. The Office of the Public Protector has a very huge role, which is embedded in the Constitution. And that role is for the justice to be done, not just seen to be done to the people of South Africa. And as such, one would have, in my view, if I am in the Office of the Public Protector, one of the things that the Office of the Public Protector would have to focus itself on is to ensure that class issues that affects a number of multiple citizens in the country are dealt with out of the initiation of the office, because the Public Protector Act allows for the Public Protector to initiate investigations. I can think of, for example, the cases of maladministration. There are a lot of them. And most of the time, the focus is on the specific case. And maybe if one set out upfront the rules, that this will not be tolerated. So one have to take a stance that there will be consequences, because many a times government entities do not comply with what they are supposed to do. So there needs to be accountability to those that are in government. And once they know that there's that stance that says that you need to be accountable and deliver on your mandate, then the people will start also to have confidence to the government institutions. Thank you.
Thank you, Honorable Engelberg.
Thank you, Mr. Chair. Good afternoon,
afternoon.
Advocate. So when I went through your CV, I saw that you did a lot of work at IPID before, and there was a few cases that were very much in the media, and as you just indicated, there was it was difficult in terms of threats that were made and all of these things. Now, in terms of work in the Public Protector's Office, obviously there's things that are being investigated that also have dubious things going on, and there's a lot of vested interests, or people with vested interests that will or that has the potential to intimidate or even threaten. How do you, given your specific background in this type of thing, how do you think from the Office of the Public Protector this can be mitigated and addressed, and even going further, people making themselves guilty of such actions, that they are held accountable for those things, seeing that the Public Protector can make recommendations to specific organs of state, but there's criminal activities involved in some of these things. How would you handle cases like that, where people in the Office of the Public Protector are put under these types of stresses and intimidation? How would you prevent such a thing, and how would you handle cases like that in an investigation, should you be appointed?
Thank you, Honorable Member. Firstly, I think the issue of the value of a whistleblower should be entrenched, because even staff members might not be in a position to be able to tell that this is what I'm being subjected to. So you need to create a culture that the staff members can trust the leadership of an organization. And that can be emanate from the ethical values that the organization adopt, which is why earlier on I indicated that there is a need to play everything by the book in terms of the rule of law, ensure that we understand the mandate that comes from the Constitution, and you allow the staff members, therefore, to be able to stand up even in the midst of adversity. And one of those things that you can do is to ensure that you have collaborations with other government entities, for example, law enforcement. You should have a safe space to say that if the members of the Office of the Public Protector or the investigators are being threatened, you open a case and you follow through it. Because most of the time is that people do not follow through. They just open a case and then they say the police didn't do anything. So again, the issue of accountability becomes critical in the way that you conduct yourself and you run the office. Thank you.
Thank you, Honorable Motau.
Thanks, Chair. Good afternoon, Advocate.
Afternoon.
Advocate, if you can be given an opportunity to be appointed as the Deputy Public Protector, how will you inspire confidence internally and externally in the institution?
Thank you so much. The first thing I think one needs to do, looking at the Office of the Public Protector as it stands at the moment, is to strengthen I'm going to first talk to the internal part, the capacity internally. So you should be able to have processes that supports the investigators or everybody else that works in the office. I'm saying this one, so you must have to ensure that there is the capacity is there to be able to respond to the cases that goes to that office. Secondly, issues of efficiencies. So if you look at for example, the rules of investigation, they're quite old, one. Two, they're not necessarily compatible to some of the legislation that is there. In that you have timelines that you've set in the way that you will investigate a matter. Yet there's a legislation that says otherwise. That on itself compromises you and compromises the integrity of the office, because, for example, if you look at EMEA, it says that you have to finalize your investigation within 30 days. We all know a complex matter that is brought will never be able to be concluded within 30 days, and they are therefore almost forced all the time to request for an extension. Now, externally looking, I think it's important to strengthen stakeholder relations, as well as to strengthen on outreach programs, so that there is the issue of accessibility is addressed, but more importantly, the collaborations. I mean, the Section 3 is very clear that even organs of state must support the Office of the Public Protector. And I think that's where they're not tapping much in terms of getting the necessary support that can lead to better relations. Thanks.
Okay, thank you. Looking at the mandate of the Public Protector, is there a possibility of overlapping of functions to other institutions, such as Public Service Commission and the SIU? If so, how can you try to avoid that?
There is definitely an overlap in that there are other legislations that would give the other organs of state a mandate to deal with the matters. So what would work is to have a memorandum of understanding. And I think also where this relates to where the public protector has a discretion on the matters. They need to be detailed down to say, this is how I will exercise my discretion. Firstly, you might want to have, like in the memorandum of understanding, if it's a complex matter, that you also know that you do not have the capacity in terms of the people that can do the investigations, then you allow the office of the, either obviously the SIU would have had a proclamation, but you would then look at what the scope of the proclamation did not cover, and then immerse yourself to what you can do in the Office of the Public Protector. Thank you.
Thank you.
Thank you. Honorable Nomvalo.
Good afternoon, Advocate Moleshe.
Afternoon, Honorable Member.
The name Public Protector is self-explanatory. Before you even go further to the Constitution or to the provisions that give birth to the Public Protector's Office and which gives powers, you already have a clue by reading at the name Public Protector that it's an office that is meant to protect the public. You agree with me, right?
Yes, I agree. Thank you.
To protect the public against what? In your own understanding.
To protect the public against maladministration, against corruption, against inefficiencies in government, and also to just ensure that there is justice in the way that government organs are conducting themselves.
As a legal person, you'd understand better than most of us the principle of odi alteram partem. How does it help the investigation methodology in ensuring that when the investigation is completed and ipso facto is taken on review by an affected person, and then it doesn't get thrown out or it doesn't lose a court battle?
Okay. Thank you very much, Honorable Member. So the audit rule is, in layman terms, it's giving another party an opportunity to respond to whatever the matter is being, whether if it's an allegation against themselves. And that allows you as an investigator an opportunity to have a full view of the facts and the evidence that you need to consider when you are conducting an investigation. To that extent, you then also the fact that you allow a person an opportunity to respond to the allegations against them might be directing you to the full scope of what really needs to be investigated, because sometimes you will be limited. As you would know, the Mail and Guardian case was very specific to say that the public protector is not a bystander. The public protector needs to dig deeper, needs to respond to all the issues that are in play. And to that extent, it becomes therefore important that you allow, as a methodology, you allow always hearing the other side of the story so that you have a full understanding and evidence in front of you before you can make a determination. In that way, you would not have a review.
Okay, in your own observation, has it been applied extensively, that principle?
In terms of the rules of investigation of the Office of the Public Protector, it is there in writing. What people do on the ground is a total different game altogether. However, when you read certain reports that come from the Office of the Public Protector, you get a sense that they do apply that rule. The issue is whether they canvass it beyond what the person has said and be able to take decision. So there had been in the past cases that clearly show that even though a person was given an opportunity to respond, but certain things were not canvassed, and which is why you would have matters that were taken on review, and on review they did not stand the test of time. Thank you.
Yeah, no, but it's a fact that some matters have not seen the light in court because the alteram principle have not been complied with. And the court will give a direction that on the basis that you have not complied with this principle, then the report is set aside. Then, do you agree with me when I say, like judges, the public protector / the deputy can be politically influenced?
I do not agree. It depends on the values and the level of whether that person is a fit and proper person. If you're not fit and proper, you will find yourself to be in that position. So it's about, the person that holds the office. This is what is important in the office of the
No, but the question is, I'm talking about a possibility here.
Okay.
Do you agree with me when I say they can be influenced politically? They can.
There could be attempts, yes, and there could be those that would adhere to, that would succumb to that pressure. But again, I'm saying the important thing is the ethical values that you ascribe to as the person that holds the office. So it is important that in a selection process, you get a person with higher standards of integrity. Thank you.
Now, in terms of the constitutional order, in the context of the appointment of the public protector or the deputy, is there no loophole in the context of the appointment? Is there no loophole which opens or which attracts that possibility of an undue influence? If my question is vague, I can illustrate through a practical example.
Okay.
Should
no,
I?
No, don't. Thank you. So I think this, first of all, the appointment of the public protector or the deputy is fully legislated. And in my view, it is a public process where here, as I am here today, the entire South Africa can have access to what I'm saying. And on top of that, one goes through a vetting process, one goes through elaborating in terms of their skills and in terms of their expertise and the attributes that they have. And I cannot see how it gets manipulated because first of all, even as we are seated here, this is a multi-party panel that will have a view on who I am, what expertise do I have, what experience do I have, and I want to believe that members of parliament are honorable members and they should be able to do the right thing. Thank you.
Okay. The time frames for the completion of the reports now, do you know which legislation, if there is any legislation, or which legal framework regulates them?
Time frames for investigations?
For the completion of investigations.
Okay. So if you look at firstly, the public protector, the Office of the Public Protector themselves, they have the rules of investigations which set out the timelines. They also have the standard operating procedures that set out the timeline for investigation. Then you have other pieces of legislation who would, and I think I did touch on it earlier on, I think the EMIR, which says 30 days, and I did also indicate that sometimes it's impractical. If you look at the complexity of the case, for example, of Palapala, you would not have, there's no way that you would have concluded an investigation of that magnitude within 30 days. And so, yes, there are time frames.
Yeah, and what regulates those time frames?
Which one? On the Act or on the...
No, I'm saying the time frames. You won't find it in the Constitution.
Yes,
you won't find it
it's
in
the standard operating procedures and the rules of investigation.
Yeah, but what regulates them? Like there are time frames for corruption, for corruption investigations, there are time frames for maladministration,
okay.
and so on. So what regulates them?
It is the Office of the Public Protector that decided on those things, because remember, there are the rules and the standard operating procedure. Looking at the amount of evidence that you need to consider. I know currently with the maladministration, they take about 12 months. And with the corruption and other complex matters, which they call governance matters, they take about 24 months to 36 months. So it depends on the complexity. And having been an investigator before, it is not straightforward to do an investigation. And I think, given the judgment also on the mail and guardian that says that you cannot be a passive person as a public protector, you then have to dig in deeper. And so it's always problematic to have specific timelines. Thank you.
Are they not regulated by the project plan?
Nomvalo, that was your last question.
You mean the one that I'm asking now?
No, the one of what regulates the time frames was your last question.
What happened
Honorable
to my
Glover?
time?
I know it's tempting to have this conversation. Honorable Glover?
Thank you,
It's
Chairperson.
15.
Good afternoon, Advocate Malaysia. Hope you are doing well.
I'm doing well, thank you.
Advocate Malaysia, you spoke about collaboration with the government's agencies and so forth. I would like to know what is your opinion on why these collaborations haven't actually been fostered and nurtured and taken care of up until now. Because we, as it currently stands, we see a total disregard of service delivery in many municipalities. I'd just like to know your opinion on that and what would you do to bolster it, and I'll come in with a second question.
Thank you very much. I think they have not been formalized. That's the first part. So, for example, if you look at the, I'm thinking if you look at the, so I'm saying they have not been. So if you look at the, for example, if let's say if you're looking at a matter of corruption or fraud, and it involves paper trail regarding the movement of money or, organized crime act provisions, you might not necessarily have the competences internally within the Office of the Public Protector that can be able to analyze and outline issues of finances. And so you find that the office either do not leverage on the Auditor General's office, for example, for support. And I'm of the view that if they can have sealed collaborations in terms of the memorandum of understandings, in terms of, because even the ombudsmen that are there in the various municipalities, they're not necessarily impactful because they're dealing with issues in silos. Yet, if there can be a proper collaboration with the Office of the Public Protector and there are guidelines in terms of what is the expectation, then it can be more impactful, because that's a person, firstly, that's appointed by the council, that's a person who can advise on the council versus via an outsider. So I think the biggest challenge is that collaborations are done on an ad hoc basis. I do think there's a need to projectize some of the work in the Office of the Public Protector. I mean, if it's common things, of lack of water, for example. It cannot be that the Office of the Public Protector only investigate Amaskral when there's a pronouncement that there could be shortage of water across the country. The question is, how do you then hold accountable the Department of Water and Sanitation by ensuring that you have discussions up front? So it's not always about having findings which are binding in law, but it's also about how do you foster people to see the necessary things that will protect the people of South Africa in the way that they get services from government. Thank you.
Thank you, Advocate. I hear what you're saying. I just think that there is definitely a lack of will within municipalities to implement basic service delivery to the residents of South Africa and the constituencies, obviously, which they're in. And I hear that you say, speak to the Department of Water and Sanitation and so forth, but municipalities are not looking after infrastructure. Municipalities are not picking up the rubbish and the litter in the streets. The municipalities are not safeguarding the residents within the municipalities. So you said, if it's a common thing such as water, but when you don't have it, it becomes a very, very important thing. And I just think that, you know, we know of these problems, and my question was more, why isn't the public protector currently forming those relationships? Because there is already a breakdown.
Okay.
I would just like to then just add my last question, and you can maybe answer it together. You know, you also spoke about wasteful and fruitless irregular expenditures. With corruption being a major challenge and stealing the spotlight, and I don't mean that as a pun, what is your opinion on that, the causes and the inability for people and officials to function and comply with the perimeter set out? What do you think the inability is to actually just perform the duties as set out? We can see this in almost every department, that there's major issues. What would you do to hold the people responsible for the shortcomings?
I think, Honorable Member, what is important is that every public representative needs to understand what is their mandate, and this must adhere to that mandate. Now, I think what some of the challenges that are there is that maybe they have not been held to be accountable, and I think that is the different stance that the Office of the Public Protector should be taking. I like the report that they've issued recently on GBV, because they have held various departments on the role that they play in resolving the issues around GBV, which is this Department of Justice, Social Development, the police themselves, and I think they left out the IPID, because IPID has an oversight responsibility in terms of their act to oversee the implementation of Domestic Violence Act. But I think what is important is that now the Office of the Public Protector should continue in the way they are doing now to look at systematic things, because these things, they start small. Whether it's corruption, it becomes systematic because there's no consequence. And where the public protector can find that there are issues that need to be referred to law enforcement, they should be referred. And they must also hold law enforcement accountable to provide a report, because one of the reasons is that even those referrals are not followed through. You just refer, I've referred you to the department, I've referred you to this. But there needs to be a follow through, because this was a complaint that was meant to provide justice and fairness to the people of the country. And as such, you would need to then hold accountable whoever you are referring a matter to come back and report to the public protector that this is how we have dispensed of the matter, this is how we have addressed our systemic challenges in the Office of the Public Protector. Thank you.
Thank you. Honorable Sotetsu. Oh, you're covered. Thank you. Thank you very much. It's rare that Honorable Sotetsu is covered. I think that's why everyone is shocked. The Public Protector Act has a language use of the jurisdiction of the Public Protector, South Africa. What do you understand as a jurisdiction of the Public Protector, South Africa?
The jurisdiction of the Public Protector is to protect the ordinary citizens of South Africa against what is contained also in Section 3 of the Public Protector Act, issues of maladministration. Basically, the jurisdiction is over government entities. And, and where also in terms of the members of the executive, then they have a jurisdiction there to investigate matters that relates to ethical issues. Thank you.
What do you understand about the rule of law and the principle of legality? And what is the dialectical relationship between the two?
So the rule of law is the fact that no one is above the law. The law applies to everybody else. And the principle of legality relates to the fact that any action that you take must be within the confines of the law. So the interrelation is that if you are, let's say, a public administrator, you have to do and take your decision according to the confines of the law. I always hear people saying that, but no, the person is charged because they did not conform to the PFMA. But it's the law. So the aspect of legality has not been taken care of. And it not being taken care of, it therefore raises issues that you have to act as an authority that, against that person, irrespective of who they are. Thank you.
Are you fit and proper?
Thank you.
I'm asking. It's a question.
I
Are
am.
you fit?
Yes, I am, definitely.
What is a
I'm
fit
fit
and
and proper, one, because of my ethical values that I ascribed to. Secondly, because I am accountable. I'm able to take decisions, even in the adverse of fear. For as long as whatever I am doing is within the confines of the law. I like the fact that you asked about legality, because that's the important part of what a deputy public prosecutor should be doing. Look at whether the actions are legal, and if they are not legal, you act in terms of the powers that you have in line with the Constitution and the Public Service Act. Two, I've held myself with the highest standards of integrity. Three, I have a vast experience in investigations, Chair, and therefore I'm fit and proper because I can, from a perspective of being an expert in investigations, be able to run. Two, in terms of my attributes, which I've alluded to, I'm not going to repeat them. Three, in terms of my experience. I believe that the biggest challenge currently, or rather in the office of the public prosecutor, would always be to have people that do not have the correct expertise and understanding of what it takes to investigate a matter, and also the lack of empathy to the people. Thank you, Chair.
Thank you. When did the binding effect of the Public Protector South Africa remedial actions got strengthened?
It got strengthened when there was the Nkandla case matter, which is the EFAF matter.
No.
Sorry?
We are done. It's fine. We are done.
Okay.
We are done answering the question.
All right, thank you, Chair.
How do you think the Public Protector South Africa must improve access, deal with complaints and case backlogs, and improve and strengthen investigations?
Thank you, Chair. I think the first thing is the fact that the issue of capacity, and I don't mean capacity in the form of employing people, but the correct capacity to conduct the investigations, and which is why I talked about collaborations with state entities that can assist them to achieve what they are set out to do. The second part relates to the issue of accessibility, relates to the importance of having stakeholder engagements, as well as outreach programs, so that people can have that. But more importantly, I think one of it's very interesting actually, because when I was reading the report on GBV, I was asking myself, isn't that also the process in the Office of the Public Protector not as simple as everybody would like, and maybe they should look internally as well to say how do they strengthen, because they've made very good recommendations in terms of that. And I know that previously they talked about an app, and I was thinking to myself, an app might not necessarily, because the main people that do not have access to the Office of the Public Protector is the poorest of the poor in the most rural areas of South Africa, and which is again the issue of collaborations come to play. I think in my written submissions I did indicate that partnering, even in terms of having sharing office spaces, they can, at least you have, and the other day I was thinking that there's a lot of South African South African Post Office Services infrastructure that is not utilized. And I'm asking myself, why can't we have government presence in those areas, and so that people can tap into that space and have access? And one of the things I'm thinking, because a lot of people, yes, have smartphones, but the app might not necessarily be for everyone. They might have an ordinary phone, and maybe we should have something like, what's that, call me back. And I know it's controversial between Vodacom and the owner of the thing, but something that will allow people that even if I don't have airtime, I can still get help and assisted. Thank you.
Thank you very
I
much.
think the last one is also that their service delivery model should not only be decentralized to big cities, but in such a way that you can have access to them. Some of the things I can think of is that if you have an office in the Eastern Cape, then you can have staff members rotating to go to the most rural areas, maybe once a day. Some of these bases have the service centers, and then they can ask for a 2-hour sitting to go and take cases of the people. And in that way, they can be more effective. But more importantly also is to be able to attend to those cases and give the necessary feedback and have the necessary impact that is required.
Thank you very much, Advocate Moleshe. That marks the end of our conversation. You look relieved now.
Yes, I am.
The committee will have a committee meeting where it will deliberate on the candidates and the interviews. Then candidates will be made aware of what the committee would have agreed upon. We wish you well, and we wish you a safe travel back home. Is there anything you want to raise with us?
There's nothing, Chair, safe to say that. Thank you very much for the opportunity.
Thank
I
you.
am willing to serve South Africa. Thank you.
Thank you. You are excused. You want a 2 minutes what? What? Yeah. Wow. I told you we were going to recover. Good afternoon, Ms. Revelation Mokhaladi. On your mic.
Good afternoon, Chairperson and honorable members.
How are you?
I am good, and you, Chairperson?
We are okay. Well, there is water next to you, but consider this as a conversation between ourselves and you, so that you relax and answer to the best of your ability. I'm going to ask you just few basic questions. The first is that, do you confirm that you are the one who answered and declared to the questionnaire that we sent to you?
I confirm, Chairperson.
Is there any other thing you want to declare?
Nothing that I can think of at the moment. I believe that I disclosed the information based on the questionnaire. I can't think of anything at the moment that.
Okay then. In 5 minutes, can you explain to us who you are and why do you think you are the suitable candidate to be a Deputy Public Protector?
Okay, thank you, Chair and honorable members. Bonatego Mokhaladi, on a personal level, I was born in a small village in the northwest. It lies at the border of South Africa and Botswana, Gopane. I started my schooling in the village, in the area, and later on I acquired my qualifications, Bachelor of Law and Bachelor of Laws degree, as well as various other courses around corporate governance, strategic management. I am also an admitted attorney of the High Court of South Africa. I started my career at the Office of the State Attorney in Mahikeng, where I did my articles. I was admitted, and post-admission, I joined the South African Local Government Association as a labor relations officer, responsible for labor relations cases for all 53 municipalities in the Northwest. My stint in Salga, it brought me closer to local government, particularly, even though I was not involved really in service delivery, but it exposed me to the functioning of the municipalities as I traveled throughout the Northwest as part of dealing with the labor relations cases. From Salga, I joined the Office of the Public Protector. I started in 2000 then it was the lowest level in the organization, being the position of senior investigator. I was responsible for investigating cases in terms of the mandate of the Public Protector. And I grew through the ranks in the Office of the Public Protector. I was appointed as a chief investigator and was responsible for managing the team of investigators that are investigating cases in terms of the mandate of the Public Protector. As I was in the organization, I developed further interest on the strategic aspect of the organization, and I furthered my study and studied strategic management as well as corporate governance, and I moved into the Office of the CEO. In the Office of the CEO, I was responsible for supporting the CEO in strategic development, as well as overseeing and facilitating audit, as well as assisting with drafting the annual report. I was also performing some of the functions that were delegated by the CEO, the delegated function of the accounting officer. From there, I moved back to investigations and was appointed executive manager, investigations. Initially, I started as investigator, executive manager responsible for early resolution cases. At the time, the organization was split into the more complex cases as well as the the simpler cases being the early resolution and the administrative. So my responsibilities at the time was on the administrative part. It forms a greater component of the Office of the Public Protector. Almost 90 cases of the complaints that are received in the office relate to service delivery and administrative failure. So that was the area that I was responsible for. Later on, the two positions were merged, and I also became responsible for the other cases that relates to conduct failure, as well as investigation of complaints in terms of the Executive Members Ethics Act. I believe that I have over 23 years experience in the Office of the Public Protector through the different roles. To be precise, on the 1st of December, it will be 24 years in the Office of the Public Protector. In the different roles, I have gained experience in conducting investigations as well as managing investigations, as well as the administrative side and the leadership side of the organization. Furthermore, part of my responsibility entails collaborating with other stakeholders, as well as engaging with other institutions to ensure speedy resolution of complaints. The Public Protector Act provides that the Public Protector must resolve case through mediation. I have equipped myself and I have gained skills in mediation. I believe that I'm a seasoned and a trained mediator, and I am capable of ensuring that we reduce the backlog of cases through alternative dispute resolution in the form of mediation. But what is also key and important is that during the tenure of the former Deputy Public Protector, Advocate Malunga, I reported closely to him. I was working with him. I was not only responsible for head office cases, I was also responsible for assisting him in providing oversight over provincial offices. So I believe that with the experience that I have gained over the years, I am now in a position to step in as Deputy Public Protector.
Thank you. Honorable Tsotetsi.
Thank you, Chair, and ke solofela o siame Mme Mokgaladi.
Ke siame, honorable member.
Mme Mokgaladi, can you give us your understanding of what is a whistleblower, but also in the context of the work of the Public Protector?
Okay, thank you. A whistleblower is a person who has information and is willing to report information. It might be in the form of maladministration, or it might be related to corruption, but they are willing to report that as a whistleblower because they wish to remain anonymous. If I take it to the work of the Public Protector, the Public Protector Act allows for a complaint to be reported anonymously. And once a complaint is reported anonymously, we have the responsibility as the Office of the Public Protector to protect the identity of the whistleblower. And there is also a piece of legislation that falls within the mandate, the key mandate areas of the Public Protector, being the Protected Disclosures Act. It aims to protect people who are willing to step forward and report the malfeasance without having to face the consequences that might follow emanating from having reported. It is a critical area in our law because there is a lot of malfeasance, there is a lot of corruption that is ongoing. So it is important, and for us as the Public Protector, it is a key area that is very important for the Office of the Public Protector. More importantly, that the Public Protector Act protects the work of the whistleblowers, and we are compelled to keep them anonymous.
Thank you for that. Now, do you think that enough has been done to protect these whistleblowers? And if not, what do you think, what else do you think should be done in order to protect the whistleblowers? Of course, flowing from your response, when you are highlighting the importance of these whistleblowers in the work of the public protector, what else do you think should be done if they are not thoroughly or adequately protected at the current state?
Okay, thank you. One of the key points that we have raised as the Office of the Public Protector through various interactions and in various platforms is the need to review the legislation that protects whistleblowers, being the Protected Disclosure Act. I believe that the Protectors Disclosures Act doesn't provide adequate protection to whistleblowers. If we take the examples of the state capture, the state capture emanates from the work of whistleblowers, but if we look at back, even though there is a piece of legislation that is supposed to be protecting them, it doesn't provide adequate measures because some of them end up losing their jobs. And in some instances, depending on the position of the person, it is easy for the perpetrators to discern who is actually the whistleblower. So my view is that much as the Office of the Public Protector can, within our powers, can try to protect the whistleblowers, it is important that government steps in and amend the Protected Disclosures Act to provide adequate protection to whistleblowers. There has been also discussion, which I believe that is very critical and important, that there needs to be a fund that is set aside to make sure that there is adequate protection of whistleblowers. In the event that the person loses their jobs or their positions, there is some form of funding that can cushion them, because most of the people, they are afraid of whistleblowing for fear of reprisals or losing their jobs.
Thank you for that. Now, since the reports and the word of mouth suggest that since the inception of Prof. Thuli Madonsela as an advocate, as a public protector, the people have began to know about the existence of the office. Do you think that the work of the office currently is satisfactory and is able to reach or protect the ordinary people, the poorest people who otherwise cannot access justice or struggle to access justice?
Okay.
And if not, what else do you think is missing?
Okay, thank you. A lot has been done and achieved through the work of the public protector, but there is still a lot that we need to do. And it is based on the number of complaints that we receive, especially if you take into consideration some of the service delivery challenges. What we still need to do as the Office of the Public Protector, we need to still reach out to the marginalized and the poor, particularly in the rural areas. We do have programs in place where we try to reach out, but I believe that we can do more. Funding and resources have been a challenge for us to try and adequately reach out to all persons. The Constitution says the public protector must be accessible to all persons and communities, but geographically, if you look at how the office is located, we are mainly in the main cities, and in some, maybe in one province or two, we might have regional offices, but it is not adequate to reach out the 60 million population of South Africa. Yes, we do have outreach programs, but with adequate resources, we need to intensify and be in a position to reach out to the far-flung areas and make sure that people know of their rights, they know that they are able to complain in the event that they don't get satisfactory service. It is our responsibility as a public protector to educate them and reach out.
Well, now you have been with the institution for some time.
Yes.
How do you think being elevated to Deputy Public Protector will assist the institution with more energy, with ensuring that it does attend to the areas which you are saying it must be able to attend to, how do you think that will begin to shift the attitude of the institution on issues such as reaching poor people and so forth?
Okay. For the advantage for the organization, if I were to be appointed, is that I have been in the organization, like Honorable Member says, for almost 24 years. I have moved through the various positions in the organization. I am familiar with the mandate and the operations of the public protector. So if I am appointed, I would be in a position, I am familiar with the challenges and the gaps and the areas where we are not able to fully reach out and make sure that we fulfill our mandate adequately as stated. So if I were to be appointed, I would be able to immediately run in and be in a position to start assisting the public protector, because the responsibility of the deputy is to provide support to the public protector. We would be able to share that responsibility. I am familiar and I'm aware of the challenges, where the office is coming from, and the direction and the vision that we are currently that is currently being developed moving forward for the organization. So that knowledge, the skills that I have gained over the years would help the organization.
No, Memo Kgaladi, ke lebogile, o buile go ka tlala seatla, ke lebogile modulasetulo.
Thank you, Honorable Nomvalo. If you are covered.
Thank you very much, Chair. Yeah. Good morning, good day, good afternoon. Good afternoon.
Good afternoon, Honorable Nomvalo.
Look, my great feeling of unease in terms of the effectiveness of the Public Protector's Office lies in its inability, in its protracted and continued inability to complete investigations expeditiously and timeously. Do you agree with me when I say there is a demise to that effect in the Public Protector's Office?
Okay, I think it's important that maybe I put proper context into my answer. We do have different categories of investigations, and we have put turnaround times relating to the investigations. They are what we call early resolution matters. They are cases where what we call service delivery. They are matters that are complex.
Yes, no, I understand that. I understand that you put turnaround times, and they differ from one matter to another. I understand that there is no standard turnaround time or framework. I agree, and I understand. But the question is, within those turnaround times that we have outlined or that you have set for yourselves, still you do not comply with in terms of completing the investigations.
Okay, I was still going to come to the point to try and clarify the type of cases that we have not been in a position to finalize within those turnaround times. It's mainly cases that as the investigation progresses, the cases either hardens, maybe based on the fact that initially, normally when we assess the complaint, we look at the complaint based on what we receive. But as soon as we step in and we start investigating those cases, we realize that the matter is more complex, mainly due to the technical nature of the subject matter of the investigation. Historically in the organization, our investigators are mainly have legal background. It's only now that we are starting to step in and appoint others. So the cases, it's not the majority of the cases, it's a few of those cases that are taking longer, that are being prolonged, that are taking long to complete. And it's mainly cases that are complex due to the nature, either based on the subject matter or based on the voluminous evidence that we received during the investigation.
Maybe to help both of us, let's just go to these cases so that I can see the complexity that you are claiming. You remember the PEU investigation?
The PEU, the
Yes,
City of Tshwane.
which took 4 years.
Okay, the
What,
case,
what is the time frame that you had targeted for that investigation?
the PEU investigation is categorized into what we call the complex, the good governance and integrity complex. And the turnaround time for investigating that matter is about 36 months. But if you look at that
Is
particular,
about?
36 months, 3 years. But if you look at the content of that particular investigation, it happened to be one of the investigations that I was supervising, so I'm familiar with the matter. The case was pending in court, and there were various legs to the investigation. Initially, when it started as if it was just relating to the procurement of the smart meters. But as soon as we started stepping in as the public protector,
Yeah, no. But
case
the,
became
the
complex.
fact of the matter is that it was never concluded on time.
okay, I was still going to get to
Yeah,
the-
I want you to be short because I'm still
Okay.
going to other questions and
Okay,
my time is very limited.
Okay, just to clarify what happened in the PEU. In the middle of that investigations, there was a court decision. The matter was pending in court, but we couldn't proceed with the investigations whilst the same issues were being dealt with. There was just a court order which provided order, but we didn't have the reasons for the decision. So we couldn't take the risk of proceeding with the investigation and run the risk of investigating issues, same issues that had already been discussed in court. There was the delay in that matter because at some stage the investigation had to be held in abeyance, awaiting the reasons of the judge in the matter that was pending in court.
Yeah, do you remember the court order that was obtained by Mr. Vigil Rapi? A court order which was saying that you must pursue an investigation against ESCOM in relation to his complaint. Do you still remember that?
No, I remember that.
Yeah, and
It was a review of the report that was closed previously by the former public protector.
yeah. So, how much time did it give you to
Okay.
conduct that investigation?
Okay, let me just clarify the case of Vigil Rabi because it's a specific case. The case of Vigil Rabi was closed 8 years before he approached the High Court to request a review, that the court should review and set it aside. And the basis for closing the matter, it was closed during Advocate Madonsela by a late colleague, on the basis that the same issues that Mr. Rabi was complaining about related to labor issues, and they were pending, and there was a settlement between him and the ESCOM. Then when he went to court, the legal services did not defend the matter that was pending in court. As a result, because the matter was not properly defended in court, the court order said the matter must be investigated, and the investigation must be, they must be investigated within a month, and the report must be issued on the 3rd month. If you look at the public protector rules, it is not possible to do that because when you investigate, you are supposed to give the other side an opportunity. So because of the fact that the matter was never defended in court, we found ourselves sitting in a court order that it was difficult to comply with. As the office of the public protector.
So you decided to violate the court order?
It was not a violation of the court order per se, honorable member. I was explaining the circumstances as to what really
No,
happened.
because if you don't violate, then you go through a legal recourse.
Honorable Nomvalo.
That's the only way you cannot violate.
Honorable Nomvalo. Honorable Nomvalo. It's fine. Let the candidate answer in a way she is comfortable. It's fine.
No,
I
Chair,
will wait.
No,
I will
but
allow
the-
you
the
to
problem-
finish.
Wait, Chair.
Wait.
The problem
Wait,
is that,
Honorable Nomvalo.
we've got the
Wait.
problem of time here. And
Wait, I am
the
saying
more I
to
allow the
Honorable
candidate
Nomvalo,
to be
I'm saying-
peripheral, my
I'm
time goes
helping
to
you.
waste.
I'm helping
And
you.
I still have many questions to
I'm
ask.
helping you. Wait. I am saying allow the candidate to answer in the way she's comfortable. Don't cut her off. I will allow you to conclude your questions.
No, if you make that offer, then I'm okay.
Yeah.
Yeah, you can go on, ma'am.
Okay. Should I still explain on the visual Rabi?
Remember, we're still on the time frame that was, directed by the court. That the investigation, you were given an order to start the investigation. To complete it within a certain time, and it never happened. So we were still on that.
Okay, I was saying the issue of the 3 months that was given by the court. Firstly, the challenge with that was that from the side of legal services and non-organization, the decision was taken that the matter was not going to be defended. As a result, the office found itself in a position where there is an order that we cannot really comply. We cannot comply with as an organization, because when you take, for instance, our turnaround times, the rules of the public protector says when you investigate a case, you must give an institution sufficient time to investigate. And if we were to take that as an indication, that court order was in 2019. That case of Mr. Vijay Rabi is still pending in court even to date, between him and other institutions. The public protector was not defending that matter. So it points towards some of the issues and the complexities. And if you look at the nature of the issues that were being discussed, it would not have been possible and it would not have been proper for the public protector to try and rush that investigation and finalize it within the 30 days that was given by court. And it was because we did not give our side as the Office of the Public Protector in terms of defending that matter. It was an undefended order.
Yeah, no, so when you say you never defended it, it means it was a default judgment. Was
Yes,
it a
the High Court order, which was reviewing the earlier report, it was not defended, the review of the initial report.
So you had no legal recourse to challenge that court order?
Okay, in terms of the processes in the organization, where I am sitting as the investigator, the decision is normally taken by legal services and in consultation with the public protector. At the time, in terms of the litigation strategy, the decision was taken that firstly, there are no prospects of Mr. Rabi succeeding in his review because he applied for a review of for review of the report. He was almost 8 years late. So in terms of deciding whether or not the matter should be taken on review, it didn't fall within my purview as an investigator, but what I could do is there was to make that input that it is not possible for us to try and finalize that matter within that time period. But in terms of reviewing and applying for to further challenge that matter and appeal that order, it fell within the purview of the legal services. But there was a clear legal strategy that related to that matter. And like I said, the decision that was approved by the former public protector then was that the matter is not going to be defended because there are no prospects of Mr. Rabi succeeding in his review.
No. I'm asking you these questions because you've been with this institution. And my observation, like I told you earlier, is that we've got a problem of investigations which are not completed on time. And you want to be appointed. While you were there, you were given an opportunity to correct that. But I'm listing all these events so that you can see that I'm not unfair to you when I say you have done absolutely nothing to cure that situation. Instead, you've been part of it. You have contributed by failing to implement the court orders, by failing to complete some of the investigations on time. Then the last question is, what would you do if you are appointed to assist the institution in ensuring that the members of the public have access to it as it is required by the Constitution? Because my observation is that the public protector is not as expected and as it is supposed to be reachable to members of the public. People do not know what kind of assistance and what kind of interventions can be made by the Office of the Public Protector to their day-to-day problems. What can you do differently? Having been there already, now let's say in the worst case scenario, you are given another opportunity, then what would you do?
Okay, can I, through you, Chairperson, if I can comment on the earlier statement, part of the measures that we have put in place, because there are two cases that is being used by the honorable members, it's situations where, as the office, we found ourselves that the complainant the complaint would be lodged with us, whilst at the same time, the same issues are pending in court. So what we have done to avoid the situation where we find ourselves in that is that we have put stringent measures in place as part of our assessment processes, where if it comes to our attention during the initial stages of the case that the same issues are pending in court, we normally write to the complainant and request the complainant to make that election to avoid a situation where we are dealing with the same issues that are pending in court, or we find ourselves in the similar situation as in the Rabi and the PEU case, where there is just an order, but you are still waiting for the full reason so that you can determine whether it's exactly the same issues that the court has ruled on. Because once the court had ruled, the section 182(3) of the Constitution kicks in. So we have improved our assessment processes. With regards to reaching out to members, we do acknowledge as the organization that we still need a lot to do. And part of what needs to be done, if I were to be appointed as the Deputy Public Protector, the first thing is for us to review our outreach strategy and make sure that we partner with, previously we had that partnership with Amakosi, but however, it did not really yield the desired results. Is to make sure that we go back, we go and collaborate, we go back and have collaboration and memorandum of understanding with other existing stakeholders so that we can use the existing resources of government to make sure that we utilize them as visiting point. Previously, we had tried the strategy of using the boxes, but it was not fully efficient. But I think what is important is that if we identify areas that we can regularly visit and make sure that we fully publicize the days that we reach out to those particular areas, it will improve and ensure that we reach out to the far-flung areas. And previously, we couldn't fully implement the outreach strategy because we had financial resources challenges. But however, there are additional resources that can be reprioritized and make sure that we fully resource our outreach program to make sure that we reach out to the far-flung areas.
Thank you. Thank you, Honorable Klopper.
Thank you, Chairperson. Good day, Ms.
I like how I always keep you focused. No one knows when is going to speak, so you must always be ready anytime. It can be you.
No problem. Mrs. Mkhaladi, I hope you're doing well. You've been employed in the public protector since 2004, and it's very little that we see that someone's been in an institution that long. So I'd refer to you as an old hand, but I'm referring to your knowledge that you've accumulated over the years. I'd just like to find out what is the biggest single challenge within the department of the public protector, and how would you rectify it once you become a deputy public protector? I'll come in with more.
Okay, thank you. The greatest single challenge with the public protector is the implementation of the remedial action of the public protector. There is a lot of work that is put into investigating cases. We issue reports, but however, implementation of the remedial action is a challenge. About a year ago, implementation, when we took some of those cases, it was currently sitting at about 22%. It has slightly improved, currently sitting at 29%. If I were to be appointed as Deputy Public Protector, the first thing that I would be doing is to make sure that there is engagement at the level of the leadership of the organization. There is that focus, attention, and engagement with the head of the respective institution. We do have data, we have collated that information, so we just need to reach out to the head of the respective institutions. The challenge with that is that if remedial action is not implemented, you find that there are repeat instances where the same thing is being repeated, even though we have already issued a report and taken appropriate remedial action. So as a start, that would be the priority that I would take over as the Deputy Public Protector.
You mentioned that there's an environment of impunity and a lack of accountability. I appreciate that you mentioned that you would follow up on the state capture and so forth. Why do you think up until now it's been dragging at a snail's pace? Who's to blame? And, you know, while we're waiting for this to take place, it's at the expense and the detriment of the taxpayer.
Okay. I think for me, the reason why it is taking longer, it's because generally there is that culture of impunity in government, and also the challenge is that there is that rotation, especially rather than people being held accountable, they are being moved from one institution and they go and start new maladministration. But I think also importantly, I think for me, in my view, is I think from the side where, for instance, I think for us to make sure that there is that fully support and fully implementation, I think we do need the support of the political heads and parliament, just to make sure there is that support, there is that proper follow-up, and those who are being implicated are being held accountable. Yes, we do see that there are some cases where prosecutions are happening, but like you said, it's moving at a slow pace. But for me, I think there isn't proper consequence management.
Can I just follow up on just that same point? If you're suggesting that you're saying that you would follow up if you went and became the Deputy Public Protector, are you suggesting that the people that are currently are not actually doing their work? Are they not leading the charge against the state capture? If you are able to go there and make a difference, why are they currently not doing it, in your opinion?
Can you repeat the question?
You said if you become the Deputy Public Protector, you would follow up on this and, you know, get it moving. So what I'm asking is, are you suggesting that the people that are currently in the Office of the Public Protector are not doing their job? As if you are there, you would be able to make a difference. Why are they currently not making a difference?
Okay. The reason why I'm saying that I would take that over is that, like I said, there has been an improvement of about 27% in the last 18 months. And it was mainly because there was intervention at the level of the head of the institution. But the public protector alone, she cannot do that because there are other areas that require the attention of the public protector. So if I were to be appointed as Deputy Public Protector, I would take it as a project, because what we have been doing to make sure that there is that implementation would be to engage with the various political heads of the respective institution, where we reach out to the minister and say, this is the remedial action that has been issued against your institution, and this is the level of implementation. So it would help in the sense that there is intervention at a higher level. So not necessarily that is happening, but there need to be that focus. It has improved because there has been that leadership that was focused on that. But I'm saying I would step in just to make sure that is to complement the efforts, and it is at that level and that attention, it's receiving the attention of someone who's the executive, the head, part of the senior leadership of the organization.
Thank you for that clarification. Thank you, Chair.
Honorable Engelberg.
Thank you, Chair, and good afternoon, Advocate. I have only two questions. Firstly, touching on the previous question, but I like to rather refer to the specifics. What was your involvement in the recent NSFAS investigation? I think it was, the report was released beginning of August or late in July. NSFAS, there was the public protector referred a cabinet minister to the SIU.
Okay, thank you. It was a complaint against the Minister of Higher Education. I was involved in that matter. What we are doing as a public protector is that when we get, because the reports in the media were that the SIU was looking at some aspect, and we were also aware that there was a proclamation that was issued by the SIU. So what we do is to avoid duplication of resources. We normally engage with the other institutions such as the SIU just to determine the extent to which they are with the investigation. So on that particular matter, we engaged with the SIU upon receipt of the complaint. We looked at their proclamation and we confirmed their investigation. Their investigation was already at an advanced stage. And it was exactly on the same issues that were part of the complaint that was lodged with the public protector. So based on that, a decision was taken that we should rather let the SIU look into their investigation, because there were about 5 issues that were raised in that complaint, and we verified and we confirmed that there was indeed a proclamation. And even when we wrote back in the letter, we indicated that there was the engagement with the head of the SIU forensic investigation. So the decision was taken based on the fact that the SIU was already advanced. Actually, when we engaged with them, they said they were almost at the level of where they were drafting their reports on the matter.
So if I understand it correctly now, the public protector will then not handle that matter, or will they await the conclusion of the SIU investigation, look at that report, and then, because you need to reply to whoever laid the complaint, I think it was someone from the ATM.
Yes. What we did is that we indicated that based on that, the public protector will allow the SIU to complete the investigation that was already at an advanced stage. And we wrote back to the member of the ATM to indicate, and we even provided the member with the contact details of the person who was leading the investigation. And there was also confirmation in the letter, including the issues that we had discussed with the SIU on that matter.
Okay, no, that's clear. Thank you. Then I want to move to the labor dispute that existed between yourself and the now impeached former public protector. Just for clarity's sake, you were absolved and reinstated in your position. So, can you maybe tell us why did she dismiss you? How did this affect you as a person, and how did it influence your work upon your return to the office?
Okay, thank you, Honorable Member. What happened in that matter was that there was an independent chairperson that was appointed by the office. And in terms of the disciplinary policy of the public protector, an independent chairperson of the hearing makes a decision and submit that decision to the public protector for implementation. So when the chairperson issued the decision, we received a letter, it was myself and a colleague, from the public protector saying we should give reasons why the decision of the chairperson should not be changed into a dismissal. And based on that, my view was that that was not in line with the policy. It was unfair, given the fact that we had only 5 days within which we were supposed to respond, and the fact that it was a threat to my employment. I approached the Labour Court for an interdict, and the Labour Court ruled in our favor, having interpreted the public protector disciplinary policy, saying the policy states that the chairperson makes the final decision and it is submitted to the public protector for implementation. In the event that the public protector was unhappy with the decision of the chairperson, the correct avenue was to take the decision of the chairperson on review in the Labour Court. As to the impact of that, and I think when I went back to work, because there was litigation that ensued following that, there was also a decision of the public protector to now challenge the decision of the chairperson and take it on review. I went back to work. For me, I saw that as that second chance. It gave me that renewed energy to focus on my work and give it my all when I went back to work. I wouldn't say at the time it had not affected me. It did affect me, but it is part of life. It's one of those challenges that one encounters in life. But what is important is that it's important to move on past some of those challenges and the experience. And I took steps to make sure that I move on, as well as to deal with the trauma that emanates and flows from that.
Thank you, Honorable Dana. Honorable Mutawong, you are covered. Thank you very much, members. Ms. Mukhaladi, are you a fit and proper person?
Chairperson, I am a fit and proper person if I look at the definition of the fit and proper person, which talks to the attributes that the person has, that one should be a person with integrity, one must be honest. So I believe that I am a fit and proper person based on the definition of fit and proper person has also been considered in several court judgments. So I believe that I am fit and proper.
What is your understanding of the rule of law, the principle of legality,
Okay.
and the dialectical relationship between the two?
Okay. Okay. The principle of the rule of law means that no one is above the law, including government. And there are some key principles that are related to the principle of the rule of law, meaning equality before the law, that everyone must be equal before the law. It doesn't matter who you are and at what level, everyone is equal before the law. Also, inherent within that principle is that there must be an independent and impartial judiciary that is able to adjudicate in the event of disputes between the state and the individual members. The principle of legality, the principle of legality requires that an administrator in making their decision must make sure that the decision that they are making are lawful, they are reasonable, and they are also procedurally fair. And reasons are provided in the event that an adverse decision is taken. As to the relationship between the two, because the principle of the rule of law entails that no one is above the law. If I take it and bring it closer to the mandate of the public protector, what it means is that the government is not above the law. They must make sure, the decision makers and the administrators must make sure that in making decisions in dealing with the citizens, they act within the confines of the law. And in the event that a decision has to be made, there must be compliance with the principle of legality, which requires that firstly that the decision must be lawful, meaning that the decision must be taken either in terms of policy or an applicable law, and it must also be be reasonable and procedurally fair in the event that there are processes that need to be followed. The principle of audi alteram partem rule must be followed. And lastly, in appropriate cases where there are adverse decisions, citizens must be afforded with reasons for that decision.
Thank you. What do you think must be done to improve access to the Office of the Public Protector or to the institution of Public Protector South Africa? How do you think that complaints backlogs and late finalization of matters must be resolved, and what do you think must be done to improve on investigation?
Okay, with regards to the office being accessible, what needs to be done is that there needs to be adequate resources that has been put into ensuring that the office is accessible to all communities. Part of the challenges was that the office, historically from its inception, has never been adequately resourced. Hence, we couldn't really reach out and have offices. But however, in the event that we do not have those offices, we need to have an outreach program that is fully effective and fully efficient, and make sure that we do have a very clear strategy in terms of how do we reach out. But I think what is also important is that it's important that we also improve on the messages that we communicate to members of the public. Next year will be 30 years since the inception of the office, but we still do get complaints that do not fall within the mandate of the public protector. So it might be that our messages are not really clear enough. Whilst we might be reaching some of those areas, those that we are reaching out, we might not be effectively communicating with them. So in my view, very clear roadmap in terms of how we reach out, and we also need to have a clear plan of how are we going to measure the outputs from that. And also our communication, we need to make sure that we communicate in ways that are easier. Mostly we were communicating through brochures. I think it would be important that we start looking at alternative means, such as there are those books that you can start communicating in the language that are being used in the areas. We tried the radios, but I think with the changes that are happening in some areas, the radio is no longer that means of communication. But if you give something that can be handed out and can communicate and express the mandate and of the public protector and explain it in language of the area, it can be more efficient. The last part with regard to improving the investigations, the quality of our investigations. Training is critical to make sure that our staff are adequately equipped. Yes, we have been conducting training, but we need to make sure that our training are efficient and they are effective to make sure that we do improve on the quality of our investigations. The other area that is important is to start treating our investigations as projects, as well as dealing with some of those investigations in teams to make sure that there is that support. The project, we make sure that we comply with the project timelines to make sure that we complete our investigations timeously.
Thank you very much, Ms. Mukhalati. I think you'll be pleased to know that this marks the end of our conversation. It was quite interesting. So we thank you for availing yourself. We thank you for coming to the interview. Some of the people still some of the people do not really want to contribute to the public service, but you volunteered to help us strengthen the office, so we thank you very much. The committee will have its meeting on a date set to deliberate on the interviews and the candidates. Then you are all going to be communicated to on what would have been a decision of the committee. So we thank you very much and we wish you a safe travel back home. Is there anything you wish to tell us? You wish to say to us?
Okay. Firstly, let me thank the committee for this opportunity to come and present myself. I think in closing, I think from me, there are those specific cases that were mentioned, and I felt that probably I should have been maybe given that proper opportunity to make sure that I fully explain and elaborate and put things into proper perspective, because with the limited time that we had, it did not clarify and properly explain those two specific cases that were mentioned. But I believe that I have presented the committee with sufficient information, and I am available if it's really necessary to provide sufficient and adequate information relating to those matters. The good thing about those two matters is that there are court judgments on those two matters. They are out in the open, and they can present the committee with that opportunity to look at the two matters and the issues that were at stake in the two matters, to make sure that
Okay.
a decision is reached on those.
Okay. Now we believe that you have given us this comprehensive information with regard to the specific cases, and one of Nomvalo was panicking about his time, so that's why we had to intervene, so that you are allowed to at least explain in thorough detail, of course with him not compromising his time as well. So that's why we allowed him to take longer, because we saw that there is a pressed conversation between the two of you, but at least we tried to help the situation. Thank you very much, Ms. Mukhaladi. Maybe we'll see you again.
Thank you very much, Chairperson and honorable members.
Thank you. Can we get another candidate? Good afternoon, Advocate Tipanyane.
Fine.
How are you? Finally. No, we're good. Yeah. Welcome back.
Oh, thank you.
We're going to have a conversation and treat it as a conversation. So you must relax and have your water there. We're just going to have a brief conversation with you.
Thank you.
Do you confirm that you are the one who declared and answered the questionnaire we sent you?
Yes, sir. I did.
Is there anything else you would like to declare?
Not that I'm aware, Chair.
Okay. Tell us who you are and why do you think that you are a suitable candidate for the position of the Deputy Public Protector?
Thank you, Chair. I'm a human rights lawyer and very committed to our democracy and human rights. And the reason why I'm here, Chair, is that I think I can add value to the role being played by the Public Protector in terms of the mandate. And I believe I have sufficient experience as well as academic background for this job. I've got more than 15 years in the Human Rights Commission, where I was the CEO for over 9 years, as well as being head of research. I'm currently at the Office of the Chief Justice as the head of legal services. I'm also a board member of the SAPC since last year. And the reason really why I'm here, apart from what I've said, is that I really believe that the Public Protector can play a very important role in our country in strengthening constitutional democracy, in addressing issues of abuse of power and resources. And really, as the Constitutional Court said in the EFF case, that the Public Protector is indeed one of the champions against corruption, maladministration, but it also gives a voice to the poor and the voiceless in our country in order to address issues of impropriety and challenges in government. And with the current challenges we're facing as a country now, as far as corruption, poor service delivery, and inequalities in our country, clearly the Public Protector can play that role because, as you are aware, Chair, corruption really undermines human rights, it undermines our democracy, it makes our people to lose confidence in the Constitution. But in view of the challenges which the Public Protector has had in the past, there's definitely a need to regain the trust the Public Protector has and really be the true champion of our people. And I think with my experience, I can really, be the wingman or the assistant to the Public Protector in a mandate to try and restore the integrity and the dignity of the institution.
Thank you. Now, Dana.
Thank you, Chair. Good afternoon, Advocate Tipanyane. I have only two questions for you. The first is, you have quite extensive experience in management as well, and I'm sure that you've been following the doings of the Public Protector's Office. So if there was one thing that you would want to change at the Public Protector, what would that be, and how would you go about doing that if you were to be appointed Deputy Public Protector?
Well, I think what is really important is to restore the public confidence in the Public Protector by making sure it's much more effective in dealing with its mandate, fighting corruption. I mean, if you look at the report of the Public Protector, there has been a decline, loss of confidence. There have been lots of, court challenges, which basically, made people not to really have much faith in it. The numbers have gone down, even though now they're peaking. But also, if you look at the compliance rate of the remedial action taken by Public Protector by the state is quite low. I mean, the report talks about
2%, going up to 29%, with the hope that it will go up to 50%. Now, for a body like this, which is really meant to be the champion in the fight against corruption, in the fight against abuse of public power and resources, that really doesn't spell good for us. So that is one of the major focus which has to be done. And of course, we also have to sharpen our investigative mandate, and I think the many court cases which the public protector has gone through now make it very clear as the do's and don'ts as far as investigations are concerned. But also, you know, to partner with all relevant agencies which are there to address issues of corruption, the SIU, the AG's office, Human Rights Commission, and many other bodies. You know, in view of the limited resources which Public Protector has currently due to budget cuts, there's definitely a need to work much more smarter. But I still believe that, you know, if we manage to restore public confidence, then a lot of change. But lastly, we also have to do a lot more to support and protect whistleblowers, because those are really our engine. You know, when they come to us with the complaints, then we're able to do our work much more effectively.
The advocate answered my second question already, so I'm done. Thank you, Chair.
Thank you.
Sorry.
Honorable Motau.
Thanks, Chair. Good afternoon, Advocate. Good afternoon, Advocate.
Good afternoon, ma'am. Honorable member.
Advocate, a bulk of public protector South Africa investigations and interventions relate to service delivery failures, which significantly impact the lives of people in South Africa. Do you believe that the public protector could do more to address recurring service delivery weaknesses? If so, how do you think, if you can be given an opportunity, you can assist in that regard?
Yes, definitely it is a concern, and the investigation mandate is basically the core work of the public protector, and that core work really deals with issues of service delivery. If you look at the mission statement of the public protector, issues of service delivery is actually quite central, and we can therefore address that in many ways. But as I was saying, one is to really enhance public confidence in us. Two is to improve how we deal with investigations and how we work with other stakeholders. But lastly, how we also collaborate with other relevant bodies which can help, who also have a similar mandate as far as investigations are concerned, especially around issues of corruption. And of course, the public protector has also raised an issue that there's also a need to improve the current legislation to make it even much more sharper, but also to ensure that there is respect for the work of the public protector. I mean, Section 181 is very clear that organs of state need to support the public protector to ensure that it's effective and efficient. And now, if there's such a low response rate by government departments, it is a concern. And if you look at the report, the bulk of the complaints come from national departments for public protector with a very low response rate. So a lot has to be done. But also, I think we need to change the mindset of colleagues in government to say, listen, it's our country, we need to commit ourselves to better support of the Constitution and better service delivery, because it affects our people at the end of the day. So multiple roles have to be done by the office.
Okay. In a situation where organs of states ignores or refuses to implement remedial actions, what will you do as a deputy public protector?
Well, one, as the Constitutional Court has made it very clear, those remedial actions are binding unless they are challenged in review, under review. So we also need to, come to Parliament, go to Cabinet to say, colleagues, please carry out your mandate. That is very, very crucial. But also, the public support is also important. I think if the public really, support the institution, it will be very difficult for public servants and politicians just to ignore the public protector willy-nilly. There will be political consequences down the line.
Looking at the mandate of the public protector, there is a possibility for overlapping of other functions with other state institutions, such as Public Service Commission and the SIU. If so, how can you try to avoid the mandates that are overlapping at some stage? Thank you.
Yeah. Well, the public protector has signed a couple of MOUs, but what is really important, I think, if you look at the National Development Plan, that there's supposed to be a collective of state agencies which are there to fight corruption. And therefore, there's a need really for us to sit down and work together and see how best we can do this. I mean, when I was at the Human Rights Commission, we were quite aware that we have a very broad mandate, and we cannot do it on our own without partnerships. We partner with Public Protector, we partner with everybody else. So partnership, collaborations are very, very crucial for us to be able to be more effective in doing our work. But lastly, the Public Protector has also raised the need really for amendments of the Act to make it even much more sharper to deal with, government departments or government officials which ignore the remedial action of the Public Protector. So if you look at the Human Rights Commission already, the Act was actually far more advanced because it was only amended in 2013, actually redone in 2013. Public Protectors Act is still very, very old. So there's definitely a need to review it and sharpen it, so that at least we can bite much more than we are doing currently.
Thank you. Honorable Sotet.
Thank you, Chair. Good afternoon, Advocate.
Afternoon, Honorable Member.
Now, Advocate, do you have any recollection of an instance wherein you challenged the authority, even if that was done at the risk of your own interest?
I advise my principals, and I don't do anything which is wrong. And when they disagree, I tell them this is the position. And but I've not defied anybody, if that's what you mean. But I believe that we're independent and we must do our work without fear, favor, and impartiality, and without being partial. So, and the Constitution is very clear. There's no superior orders as a defense. So if you do things which are wrong, you face the music. So I have no problems in telling my principals where I think they're wrong, as politely and as respectful as possible.
So you have never held any position which you advance and then encounter any form of a pushback from the authorities or anyone that would be involved in that position that you advanced? Say, for instance, the violation of human rights that you advance, and then has there not be experience where in this pushback?
Well,
what I'm trying to gauge here is the character of a person that we're dealing with.
Yes.
Yes.
Well, I mean, I'm the legal advisor currently now in the Office of the Chief Justice. And when there are requests for us to do certain things, and we think that they are not appropriate, we tell our principals that it cannot happen. This is my job. It's what I do. Maybe people might dislike me on the side, but it will be difficult to go against the advice of an accounting officer. I'll give you an example many, many years ago. When I was at the Human Rights Commission, I was told to pay a commissioner who had not worked. And I refused to pay the commissioner. I was ordered, I said, fine, PFM is very clear. We then go to Treasury and AG. And then I called the president and said, listen, here's the situation. They said, no, don't do it. And I told them, I cannot do it. That is done. So what I'm trying to say is that I have never, and I will not, I give in to things which I think are unconstitutional and are wrong. People might dislike me, but I've not been fired or being charged for standing my ground on things which are correct.
No, it's fine. You know, there's a lot of criticism, firstly to this parliament, secondly to the executive. I see that it's beginning to creep to the Chapter 9 institutions there's a decry on the recycling of individuals within these entities. What is your view with that complaint?
Well, you know, we have to have a balance. You know, you need fresh blood and fresh ideas, but you also need experience. And we need to find an appropriate balance in that. So we can't just throw everything out of the water just because we want experience, because what is important is really the objective. What we want is to do the best for our people, to strengthen our democracy and promote human rights. So we have to, you know, be smart in how we do it. We can't just keep old people forever or just have young people without experience. And we've seen now, I mean, if you look at how local government collapsed, it was largely due to the fact that there were a lot of people there who were inexperienced and did not do the job properly. Now, 30 years later, I say, wow, what happened? So you do need a mixture of young and old, you know, but, you know, in view of the challenge in a country where we have high levels of youth employment, which can become a threat to democracy at some point in time, we need to be very mindful of that, you know, we need to open the spaces for young people. Otherwise, you know, we saw what happened in North Africa about the what do you call that thing now? Forgotten now. The uprising in North Africa, when, you know, young people were educated, but there were no jobs. So already here we're sitting with a high levels of youth unemployment. I'm told sometimes it goes up to 60%. So that has to be addressed.
Yeah, let me deal with the last one. In another platform, not today, I will have to seek more clarity on that response that you made about local government. If you are apportioning the blame to young people on the collapse of local government, but not today. Today, I want to ask you whether one of the criticism also of the public protector is that the advocacy on the program, on its program, has not really reached the marginalized communities. The marginalized communities are still not conversant thoroughly with what the mandate of the public protector is. And they need its services the most, or they are also in need of the services. What do you think should be done by the public protector to ensure that the marginalized communities are also aware of its mandate, they are also aware of how to use the services, and they are also able to access the services?
Yeah, that is correct and very important. I mean, as I was saying earlier on, the court itself says, you know, the public protector should be the voice of the poor and the voice of the voiceless. And therefore, it would mean that, you know, when we do our work, we need to bear that in mind, that, you know, who are our target markets vis-a-vis everything else. And we know that, you know, those who are wealthier have access to other modes of justice. But for people who are poor in rural areas are not having those means. So we do have to prioritize those communities in many ways, you know, through media, but also through actual engagements. We can use, you know, police stations, we can use municipalities to be able to to be accessible to those people. I know we're now in the age of technology, but the same issue applies that, you know, Many of these people might not even have the means to be able to buy data for a month to be able to use our services. So we do need to set aside a certain percentage of our resources to target those people. Otherwise, we'll be failing in our mandate, as reflected by the Public Protector, the Constitutional Court, that we are the voice of the voiceless, we are the voice of the poor, and we have to give access to justice. So if you look at the mission itself, it's already saying that we have to ensure there's administrative justice to our people. It can't just be for the rich only. And this has been the challenge and the criticism really about Chapter 9, the Human Rights Commission and Public Protector, that, we tend to focus a lot in urban areas and not go around. So we should actually have a map. We should tell us, over every period, have we been there? And if not there, how do we get there? And maybe we should actually, in our report, come and tell this committee that, we've now reached so much of the poor and the rural areas.
Just the last one. You have served on a number of capacities on various entities, and do you think that the Public Protector Office needs you?
I think so. I tried with all the modesty I can muster in my very short response. I didn't want to go into detail. But, if you look at my experience, being at the Human Rights Commission, being a researcher, an academic, Columbia, being a lawyer, I've got 2 master's degrees, I've done pupillage. I'm now, for the last 1.5 years, the head of legal services at the OCJ, basically looking into this issue. So I think, and of course, my own involvement in civil society, my passion for whistleblowers, I think with all the humility I can muster, there'll be very few people with the kind of skill sets I have before you.
Thank you, Honorable Nomvalo.
Good afternoon, Advocate Tipanyane.
Good afternoon, Honorable Member.
The first question is, do you believe that in a working environment, the environment must be conducive for productivity to prevail?
I really believe in that. And I did say, I think, in my statement that happy workers make productive workers. It's very important because, me and the Public Protector, we cannot run the organization. So you need those foot soldiers, so to speak. And for them to be able to do their work, they really have to feel valued and they have to believe in the work they're doing. So if you look at the value positions of Public Protector, which I like really, the Pula, that we do our work with passion, Ubuntu, leadership, and efficiency. So we need to appreciate that, without a committed and passionate work staff, will not do it.
Okay.
And we have to spend a lot of effort in making sure that,
All right.
they're
No,
there.
you've made your point. There was a story which was making rounds that in the Human Rights Commission, the attentions which involved some commissioners. Have you ever encountered a situation of that nature while you were working for the Human Rights Commission?
Many times. Yeah.
And did you make any progressive intervention to resolve that problem? Please try to keep your responses very short because I've got a couple of questions.
Yes, we had problems in the 90s, early 2000. And then I was then appointed to act as a CEO to try and turn things around. And I always use the model of a three-legged pot, that an African three-legged pot needs 3 legs to stand. And if one leg is short, the leg will not stand. So if you were to look at my track record in the Human Rights Commission, every time I became the CEO, I would lift up the performance of the organization. Even the last time when I joined the commission in 2017, everything went well until COVID came. And then, of course, things collapsed. So there are always problems. Wherever there are human beings, there are problems. It's all about leadership. You know, it's all about respect for corporate governance. It's all about doing the right things.
Okay. Is the current public public protector's office an ideal Chapter 9 institution, which is a paragon of virtue, or which rises to the occasion in terms of implementing its Chapter 9, its constitutional mandate? If not, what are the shortcomings? And if you are given an opportunity, how would you address those shortcomings?
Yes, you know, in my life at the Human Rights Commission, the public protector were always our friends. We worked together. We had joint hearings, investigations together. So it's actually a bit of a sad thing to see what happened recently. And that really needs to be addressed, you know, that we need to you know, heal the wounded and really make staff members believe that, you know, there is care for them. So a lot of work has to be done. And I was looking at the report of the public protector. The new public protector is really trying to try and change that morale. Now, I'm in the SABC board. When I got there last year, things were really hectic. We had a loss of over R1 billion, and we've been trying, you know, to say, guys, we need to, let's work together. And I think the proof is there for anyone to see, despite the many challenges. So it's really about, you know, respect for the dignity of the other people and appreciate, you know, their value and contribution. And I think once people feel valued, then things can turn around. Look at Bafana now. I mean, we used to hate Bafana now. They are our #1 hero simply because of the change of leadership and management and attitude. You know, in soccer, if you take the soccer scenario, when people are not, when they feel they're not respected by the coach, sometimes they even lose just to get the coach fired. So these are some of the dynamics which we have to deal with and understand that the people we work with are not robots. They're human beings with feelings.
So the shortcomings to you, the only solution to them is showing respect and appreciation. That's the only solution you can give.
No. I mean, with the public protector, you know, we have to analyze what went wrong and how that could be addressed. We have to speak to staff members to see exactly, you know, how they feel. I mean, a few years ago, I was asked by the previous public protector to do an inquiry in public protector because of unhappiness in the organization. I spent a week there speaking to staff members about their concerns, and I wrote the report to public protector. I said, listen, yeah, there is an element of bullying in the organization. And if you don't address this, then it will destroy the morale of the organization. So having worked in so many institutions, you know, that is quite key. Now, of course, there are also issues of salaries, issues of upward mobility, job security. But I think for me, from my own experience, what really makes people to go away from institutions, it's not necessarily the payment, it's how they feel and how they're treated in the organization.
Okay. My observation is that to a certain extent, the complaint lodgement mechanism is a bit conservative. Now, if you are given an opportunity, how would you apply a new modernization and digitalization strategy or mechanism to ensure that the complaint lodgement process, one, is efficiently, two, it reaches the relevant authorities on time, within a second? What strategies, what modernization and digitalization strategies would you put in place to ensure that you improve in that regard?
I have a BSc, my first degree, and at the commission, actually, I organized the first conference on industrial revolution and human rights. And then at the OCJ, we're busy working with the court online to try and use that system to make, you know, the courts more accessible. And I think it's working, where it's being implemented. So really, it's about studying the systems and see where the weaknesses are and how it can be improved, you know, getting people who know how to do it. So, you know, and there's no perfect system, but, you know, as long as you are clear with your objectives, there are lots of skills around to help you to design a system or improve what you have to be able to achieve what you have. So I'm actually glad now that the public protector is moving in that direction with their complaints management system, which is now electronic, as well as, their self-service where people can just track their complaints. But again, systems always have to be changed. Technology changes very fast, and we have to keep a track on that. So we have to have a very strong unit which really focus on these issues to see how best can we use technology, how best can we adapt to recent technological developments to improve our service, because our biggest challenge, as you were saying earlier on, is how then do we access the people out there.
Okay,
And
lastly. Now, in the event where findings to which you do not agree in terms of your legal understanding and in terms of your legal perspective, where you disagree with the public protector on how she has made findings in a particular matter, what would you do in the event where you've tried to reach out to her and share your perspective, but still she remains adamant and she is not accommodative of your views? Then what would you do? That was the last question. Thank you.
Okay. The Deputy Public Protector carries out work at the instructions of the Public Protector. However, having said so, we don't carry out illegal orders. And even where I work now with judges, we do advise judges, sometimes even against their wishes, and we say, here is a law. And one hopes that, one will not have to come to Parliament to express a concern that the Public Protector is now being belligerent. But it's also about preservation, because if we share the same vision, same mission, and same commitment, those problems should not really be difficult if, we talk. But of course, if there's no talk, then the committee is here. We're all accountable to the committee, and the Public Protector will be asked, and then you'll have to disclose that, Tipangene said this, but I did this, and then, because ultimately we're accountable to this committee.
Honorable Engelberg.
Thank you, Chairperson. Good afternoon, sir.
Good afternoon, Honorable Member.
I would like to go back to your time that you presided as CEO of the South African Human Rights Commission from June 2017 until May 2022. So the Human Rights Commission reported to the forerunner of this committee in the 6th administration, when it was Justice and Correctional Services together. So if we can go back there, in terms of the annual reports presented annually to the committee, while you were CEO, did the Commission achieve a clean audit during the 5 years?
No, but with the first term, we got 2 clean audits after getting an unqualified audit, which I inherited. But in the last 5 years, there were problems with our audit for a number of reasons, which I can explain.
Yes, I know, I'm aware of that. How efficient did the Commission function while you were there, as per the reports presented to the portfolio, in terms of percentage of targets achieved and the like, how these things work?
Yeah. In the first term, the Commission was rated the best commission in the world. I was in Harvard, and we appeared before the Kara Asmal Committee. The report is there as to what we did. And then I left for a number of reasons. When I came back to the commission in 2017, after staff members have actually complained to the committee about the commissioners and say they don't want to see them back. So I was called in again. It was actually quite painful to see the organization which we helped to build in 1996 being where it was. And even to check the records properly, when I got there, our performance rate was 60-something. It went up to 80% just before COVID. And then after COVID, unfortunately, there were other problems. It went down to 60. When I left the commission with 60% performance rate, there were other problems there, and which you want me, I can explain. But every time I've run the commission, we always improve our performance. Now I'm at the OCJ. We've had the last 2 clean audits, so you know, things do happen.
Yeah, so your 5-year fixed term contract was not renewed by the commission.
Unfortunately so.
And then you went to the CCMA
Yes,
to dispute that.
yes.
Can you explain to us why did you go to the CCMA and what was the outcome in the end, and how did that, what impact did that have on from 2022 going forward, where you now work for the Chief Justice?
After I left the commission, over 25 staff members resigned. Most of the senior managers resigned out of protest because I went to the CMA for 2 reasons. One was that it took me 3 years to be confirmed, not 6 months. And I raised this thing with my principals, and they were not doing anything. 2, in 5 years, I only signed 1 performance contract for my probation. I never signed a performance contract. I was never set for 5 years. And then when the contract ends, I'm just told, just a month before, that the contract is not being renewed. I asked for reasons. I said, no, I'm not entitled to any reasons, even though I knew there was a legal opinion. Then I went to CCMA. The reason why I lost in CCMA was very unfortunate. They said, well, why did I take 3 years? I mean, I could not sue my principal for 3 years probation. You know, I was trying to see, you know, things could say change. So even in my last year, I actually asked the commissioners to really get down and assess me. And we got someone from outside to sort out these issues. I left even before that report came out. And when I went to CCMA, I was actually supported by Commissioner Nissen, the current chairperson of the commission, who testified against me. But the commission actually refused to disclose the reasons. They refused to give a legal opinion. And I was told I must go to High Court. I could not afford High Court. I was paying 18 grand a day. Unfortunately, my friend said, you know what, we'll waive the fee. So there was no way I could go on. It's actually quite sad for me as to what happened. And I never really told the story to protect the commission. I never went to the media. I never said anything about this thing. This is the first time I'm talking about this in public.
Honorable Glover.
Thank you, Chairperson. And can I proceed?
Yes, proceed.
Good day, advocates. Hope you're well. Yeah, the last
Good day, sir.
account that you've given actually is very worrying, extremely worrying. But I just want to get you into response to Honorable Tsotetsi that he asked you a few questions earlier about challenging authority and so forth, and you spoke about a commissioner who asked for money that wasn't paid, and you refused, correct?
Yes.
Was
Not
that
to be
commissioner,
paid.
was that money for a job that he didn't do, if I understood
No, a
you correctly?
commissioner was appointed, but then did not work for that month. And then I was told to pay the commissioner. I
Who
said,
told you?
Pardon?
Who told you to
The
pay?
chairperson of the commission.
All right.
And I said, I cannot pay the person. And PFM does not even allow me to do so. So basically to alleviate the situation, instead of going to Treasury and Auditor General, I wrote to Parliament. And then I said to Chair, look, this is what Parliament is saying. They agree with me. And also, I refused to pay another commissioner for the whole year. And, I told my chair, I cannot pay a commissioner who's not working. And it was quite painful for me, but it had to be done.
Thank you. Advocate, can you give me more details? You said you were assaulted by Black First Land First.
Yes, I did.
What brought it on? And I just don't understand how you were implicated in bringing the Human Rights Commission into disrepute after being assaulted.
Well, there was a complaint brought by a lady against Black Land First on racism. And then my guys then, when there was a meeting between Black Land First and the commission, I was called to come and help the colleagues. And when we got there, the guys already had cameras, they were filming us, And I'd always told my chair that we should do everything possible to avoid a confrontation with BLA, because that's what they wanted. Anyway, then we told them, listen, unfortunately, you don't have a leg to stand on. And if you don't withdraw, apologize, we'll definitely make a finding or go to court. Then they began insulting us, saying we are serial stooges and stuff like that. Then we asked them to leave. Then we called security, said, security, please take these guys out. As soon as security came, then they sent 2 ladies who hit me. And I put my hands behind my back because we're very clear, we'll never get into confrontation with them. They insulted us with our mother's private parts and whatever. Sadly, some staff members who didn't know what was happening took a video camera. So what happens is that one of the security guys, when I was assaulted, and they took my spectacles actually and threw them away, then tried to intervene, and I was pulled into the door. So if you don't know what was happening, that would look like a scuffle. And then it was then lodged to the commission to say, listen, the CEO brought the organization to disrepute, he fought with the BLF, you know. So we showed the commissioners the footages and explained, and the staff members were in the meeting, issued an affidavit, went to the police station and laid a charge. By the way, it took us forever to get there. Nothing actually happened out of that. I personally went to the police station and laid a charge, but it was never followed up. And then they went to the media saying that we are bad people. I was even called a wife abuser. I don't know where they got that from. And then after a month of investigation, I was cleared by the commission. There was no story there.
Right, did I hear you clearly? You said nothing came of that case.
Nothing.
And you're applying for the Deputy Public Protector. Would you not be dealing with harsher cases than that?
We have been dealing with harsher cases. We've been going to court, we subpoena people. But remember, I was an employee, and all I could do is to lay a charge. We laid charges before, and we followed up. I did ask the police, by the way, a year later, when they were saying that we were not supporting them. I said, fine, if you say so, explain my case. That's when they brought in a case number after a year, and I said, guys, you can't be serious about this thing, really. I mean, it was not a really serious offense. I mean, I was just hit on the shoulders here. You know, and then, of course, we did take action against BLF.
Assault is a very serious case, Advocate. But moving on, corruption by the state and service delivery by municipalities, something that you hold close to heart, impacts citizens of South Africa greatly. What would you do in relation to municipalities that simply do not provide services that are actually paid for?
Yeah.
Things like water, basic constitutional rights, as you know. And I don't want to hear about writing letters and reports.
Yeah.
These people that are paid know that they have to offer these services.
Look, it is a concern. When I was the commission, we did a couple of hearings on local government. We did one at Mfuleni in Free State, where they were dumping sewage into the river. And our interventions got the minister to send an army there to try and clean up that. We did a hearing in Alexander, the renewal project, together with the public protector. So we are quite concerned about this issue. So in my last term at the commission, actually, I you know, as a CEO, we proposed a hearing by the Commission on Local Government that, you know, local government is definitely going to be a challenge going forward for this country. You know, you used to send some reports here to Parliament on PAEA. You will see that out of 200 and something municipalities, very few even comply with PAEA to the Human Rights Commission. So it was an issue which really has to be addressed. And I think really, if I was a public protector, that's something which we must take a little bit more seriously than we've been doing before. That, you know, people must be held to account and they must take responsibility. I think talk is done. We've been talking, we've been doing hearings, making recommendations which go nowhere. And I think those people, and I'm glad now the court recently made a finding, the Supreme Court, I think Supreme Court recently, that the municipal managers, even if they leave, will still be held responsible for the mess they've caused there in terms of financial losses. So I think that's a great development, but they could be assisted by bodies like us and Human Rights Commission really saying, this is the core faith of human rights, advancement, service delivery. Most of our challenges of service delivery actually come from the local government, with due respect.
And I have one last question, we'll be very quick, and you can just answer with a yes or no. If I would use my mother as an example, if she went to a municipality and an official hit her on her shoulder, would you as the Deputy Public Protector take it as a serious case? Or would you dismiss it?
It is in terms of the Public Protector Act that, you know, how you treat people out of courtesy is also something which the Public Protector can deal with, apart from it being a criminal offense.
Okay, thank you. I'm just asking in relation to your previous comments. Thank you very much.
Thank you. Honorable Totes, you said you wanted clarity.
Yes, I wanted clarity. I think I would have heard Mr. Tipinyan mention that at some point, whether it was a labor court or CMA, I'm not sure, there was an instance where the current chair of the Human Rights Commission was testifying against you
No,
Or
on my behalf.
On your behalf.
Yes, because he agreed that I was fairly untreated.
Oh, okay.
Yeah,
okay.
but we lost the case on technicality because the CCMA said, why do I take 3 years to complain about not being confirmed for 3 years? And I said, do you seriously expect me to take my principals to court in the first 6 months? I spoke to them, I wrote to them, and after 3 years, I told my chair, I said, Chair, it's very simple here. The law is very clear, I'm now confirmed. Full stop. Give me the letter and we move on.
Okay. No, that's fine. Are you a fit and proper person?
I think I'm a very fit and proper person, Chair. I'm a committed South African. I really care about this country, and I'm driven by, ethical conduct. I guess that's why I would not have been at the Office of the Chief Justice if I was unethical, or been at the board of SABC. But I also come from a long tradition of ministers of religion. My grandfather was a minister of the AME, my father also. So I come from that background, Chair. But also, I think the love for my country is very important. That's why I said in my letter that I think one of the assets I bring here is the tremendous respect which I hold in this country because of my integrity and leadership. I have not been linked with any funny things that I know of.
What is the budget of the Public Protector South Africa in the financial year 2024-2025?
I hope I'll get these numbers right. It's quite difficult. I have 400 for the previous financial year, and then 384 for now, for 2023-24. And then 24-25, it's 357. And then with time, it might go up to 400.
Okay. What is your understanding of the rule of law?
Role of?
The rule of law.
Yeah.
The principle of legality.
I think it's
and the dialectical relationship between the two. Between the rule of law and the principle of legality.
I can refer you to the judgment of Judge Ngobo in the case of Billy Masetla, where he actually disagreed with the Constitutional Court in the sense that the court looked at the principle of rationality, that the decision of the president in getting rid of Billy Masetla was based on law. It must be lawful and it must be rational. But now they did not look at the issue of the rule of law. And Judge Ngobo was saying the rule of law gives birth to the principle of legality. And the rule of law talks about everybody being equal before the law, laws being implemented, laws being fair, independence of judiciary. So he was arguing that it's not fair to simply cancel the contract of Billy Masetla simply because of the president. And I think for me that case spells a clear distinction. And I think that's one mistake which sometimes the courts have made, that you can't just look at the principle of legality without looking at issues of the rule of law. It's about fairness, it's about giving people another hearing, giving people a hearing. So the rule of law is a bigger scheme than principle of legality. It's a child, it's a grandparent. The legality is a child.
Okay, thank you. When and how did the remedial actions of the public protector?
Sorry, I missed that, Chair.
When and how did the remedial actions of the public protector become binding?
The case of the Nkandla judgment, that's where Judge Mogoeng made it very clear.
You are done.
But,
No, you are done.
I was going to say, but there were other developments before
No.
that. Okay.
You are done.
Okay.
It was the binding effect started with the Nkandla judgment.
Yeah.
So if you said the Nkandla judgment, then you are done with answering the question. Mr. Advocate Tipanya, thank you very much for coming. Unfortunately, or fortunately, this marks the end of our conversation. We wish you well and wish you a safe travel back home. The committee is going to meet and deliberate on the interviews, and candidates are going to be duly informed. We appreciate and thank you for coming to the interviews and for voluntarily availing yourself to be part and help the service and strengthen the capacity of the public protector South Africa as an institution. Thank you very much.
Thank you, Chair. And thank
Anything you want to say?
Pardon?
Anything you want to say?
No, Chair, I think it's been a fair
Conversation. Okay, thank you very much. Let's get the last candidate. Thank you very much, Advocate Tipanyane.
Thank you.
Safe travel back home. Good afternoon, Advocate Pungozana. Is it still the afternoon now? When does the evening start? 6? Still afternoon, eh? Okay. How are you? You can pull the mic towards you.
Good evening, Chairperson and the members of the committee. I'm fine, thank you. And how are you?
We're fine. It's been a long week for us.
Yeah.
We've been doing interviews from the commission to the protector, so it's a long week.
Okay.
Take this as a conversation between ourselves and you. Relax and make use of that water when you need it.
Yes.
I'm going to ask you 3 basic questions. Then the committee is going to interact with you. Do you confirm that you are the one who signed and declared the questionnaire?
Yes, I do.
Is there anything else you wish to declare?
Nothing.
Tell us who you are and why do you reckon that you are a suitable candidate for the position of the Deputy Public Protector?
I'm an admitted advocate with 31 years of legal experience. Currently, I hold the position of Deputy Director of Public Prosecutions in the National Prosecuting Authority, the NPA, in this division, or in Cape Town. Before I joined the NPA, I have practiced as an attorney for a period of 9 years, where I gained civil and criminal litigation experience. And during my span as an attorney, I have fought for human rights, I uphold human rights, I have defended indigent litigants, particularly the people that were evicted from the farms. I worked closely with the PAL Advice Office that referred those people to me. After I closed my practice, I joined the NPA, particularly the Directorate of Special Operations, which was known then, or fondly known as the Scorpions. And that is where I led complex commercial investigations and prosecuted some of the matters arising from those investigations. After the demise of the Directorate of Special Operations, I then got absolved in the National Prosecuting Services, where the methodology was prosecutor-guided investigations, as opposed to the GSO prosecutor-led investigations. So I have kind of an experience in leading teams and investigations in both those capacities. Then, with my experience, managerial experience and prosecutorial experience, I have currently, in fact, in my current position, I take decisions that are quite serious, that impacts on the lives of people, and not only that, but the impact on the integrity of the state and the confidence in our criminal justice system. And that duty demands a level-headed person, a person who is objective, who has integrity and honesty. I submit that I am able to disabuse my mind from all irrelevant personal preferences or predispositions, and I'm able to dispassionately deal with the facts before me. In this regard, I submit I am a fit and proper person for the position that I've applied for. I do hold integrity, objectivity, scrupulous honesty. And these qualities I possess not only by virtue of being a professional, a legal practitioner, but these are the values that are intrinsic in me. I grew up with these values. They are part of my being. Further, I state the obvious. I am an African. I hold the African values of Ubuntu, which, amongst other things, demand empathy, courtesy, and respect for a human being. So if I'm able to respect a human being, it becomes easy to serve the nation with humility and uphold human rights. Having said that, I once more repeat that I am fit and proper person. The qualifications, my personal convictions of honesty, reliability, place me in a position that I become a perfect fit in the office of the Public Protector. And that is my submission. Thank you, Chair.
Thank you very much, Honorable Klopper.
Thank you, Chairperson, and good afternoon, Advocate.
Good afternoon.
Advocate, we obviously press for time, so I'll just ask that you keep your answer short to me so that we don't waste too much time. Advocate, would you say you've added value to the NPA in your tenure? And do you believe that being part of the NPA, you've done enough against corruption in particular? And I say it with respect to your position in the NPA, how do you plan to do more as the Deputy Public Protector than what you are able to do within the NPA? And then second question I would just pose now, if I should need more I will. How do you believe that corruption has hindered implementations to promote black entrepreneurship?
May I ask you to repeat the last part of the corruption?
Apologies. How do you believe that corruption has hindered the implementation to promote black entrepreneurship?
I have added value in the NPA, and that I have led investigations, I have prosecuted some of the cases. I lead teams, I attend to the staff morale, I improve their morale. So as a manager, is to ensure that the needs of the people are met, and also the skills are sharpened. That becomes my duty. And in that way, that's how I would add value in the organization. With regards to corruption and hindrance of the black people, corruption generally, without being specific to a particular group or sector of people, is a terrible phenomenon. It's like a cancer that eats away the fiber of the community, of the society. But what is more, and this is where the danger or the bad part of corruption comes, that the services that are destined for certain people, service delivery in particular, those services do not reach the designated people. And in that way, that hinders the growth, the economic growth. Nobody has confidence in the system. So that is how it affects the group of people that you've referred to, but the society in general. Thank you.
Advocate, thank you so much.
Sorry.
Apologies.
Honorable Nomvalo, can you switch off that mic?
Thank you, Advocate. I can deduce from your answer that you care deeply about service delivery, and it's something that I've mentioned a few times today. I feel like a broken recorder, but in municipalities we can see that services aren't being delivered. We have failures of reticulation systems, we have failure of sanitation systems. We have either no water at many municipalities, and if they do have water, it's filthy. On top of that, we see that officials that are appointed to do a certain job just can't seem to get it right. It's either fruitless and wasteful expenditure, irregular expenditure, and just a total disregard for the people that actually pay for these services. Is this something that you would champion should you become Deputy Public Protector? And what in specific would your starting point be to start rectifying these municipalities and officials that are not providing the services? And I ask this particularly because I say they do know what they mean to do. So we've already covered the part that they know what they're meant to do. How do we force them?
Indeed, I do care for service delivery. It is when I watch non-service delivery, it boggles the mind where the government would put in place systems, provide finances, and employ people to carry out those duties. And the services just do not reach people. And one asks, why is it so? I should think there are basically three reasons that I could think of. One, it's either they don't know what to do. But you have said they do know. If they do know and they don't render services, then they are lazy. They just don't belong there. 3, it's just being selfish in that one would go to work and say, you wake up every day and say you are going to work. But when you get there, you play cards on the computer and you don't deliver what you're supposed to do. And in that way, you steal government's money. But what I would do, I would empower, as the Deputy Public Protector or a member of that office, empower the people and the community in so much that they know their rights. And with that knowledge, they are able to hold public officers to account. And that's one way. Otherwise, you report to the relevant authorities. If it is in the public protector, one way that the public protector can assist in service delivery is to get stakeholders together, find a common ground. And the other way is to come up with an effective remedial action. And in that way, the public service or the municipalities or the officials are held to account. That is my answer.
Thank you. Honorable Engelbach.
Thank you, Mr. Chair. Good afternoon, Advocate. My questions will be very short. I'm going to ask all of them because it's very easy. For how many years were you a prosecutor? In how many cases while at the NPA were you the lead prosecutor? Of those cases, how many were prosecuted successfully? That's all from my side.
I joined the NPA. In fact, I've been in the NPA I joined the NPA in 2002. And I joined as a senior state advocate. After 3 years, I was promoted to become a deputy director of public prosecutions. In the NPA, I led 3 complex commercial investigations. I prosecuted all those 3. I had 2 successes. And as a deputy director of public prosecutions, if a case is serious, then it is, before I could get it, normally I decide to whom to allocate the matter. Depending on the complexity, we do go to court as deputy directors. So for that period, that's my duration of prosecution. The matters that I have prosecuted, I recall one that was complex that the decision didn't go our way. Otherwise, I've led some few. I'm talking about only complex matters, not petty or not complicated matters. I haven't accounted them. Thanks, sir.
Thank you, Honorable Nomvalo.
Thank you very much, Chair. Good afternoon, Advocate.
Good afternoon, Mr. Honorable Nomvalo.
Yeah, my first question relates to the public protector versus the deputy public protector in terms of where they draw their existence. Is there a distinction in terms of where they draw their existence?
There is a slight difference in that the public protector draws existence from the Constitution. So it is a constitutional organization. So the public protector it's in terms of section 101 of the Constitution, and it is both an individual and an institution. Suppose you get that distinction. And then the deputy public protector is or derives existence in terms of the Public Protector Act. And the powers are delegated to the deputy public protector by the public protector.
Okay, so you spent most of your time as a prosecutor, right, in the NPA?
That is correct.
Which area of law were you focusing on?
Commercial.
Commercial law.
That's correct.
Have you done criminal law?
I did criminal law.
Okay. Now, my concern, I just want you to allay my fears and my concern is that in terms of the scope of the Public Protector's Office, it touches many branches of law, the local government, provincial government, to which you do not have experience. How will you manage that?
All right. I'm not sure when you say I don't have experience in those branches of law. But what I can say, when I joined the GSO, or the Scorpions, we dealt both with local government transgressions, any criminality, anything that comes. Remember, we had organized crime and commercial matters. But at times there is an overlap. So I have actually dealt with matters that involved local government and the transgressions of the relevant legislation there. So I actually do have some experience.
Can you outline the investigation methodology to which the public protector adhere when they conduct investigations?
If you recall, I mentioned prosecutor-led investigations and prosecutor-guided investigation, or that is the methodology we followed. But in the Office of the Public Protector, there is no such definition that this is the methodology of the Public Protector. But from what I have read, the process or the methodology that is followed, firstly, it is an informal engagement where the complaint is received and the public protector would solicit a response from the person or the institution that is the subject of the complaint or the investigation. Working on that, exchange where there is no cooperation, then the public protector can resort to intrinsic powers, including subpoenas or search warrants. But those are the things that come only if there's no cooperation. That is the methodology that is followed.
Do you know how the public protector regulates the time frame or the time frames for completing their investigations? The time frames to which they must comply. Do you know how they regulate them?
How they regulate that, okay, let me answer your question in this way. The source of my answer lies in the annual performance plan of the public protector. That is where the timeframes are stipulated. The regulation thereof, I haven't seen, but I do know the times are per categories of the investigations. That varies from 6 months, that would be for ER, or matters that can be resolved by referrals or through mediation. And then it would be 6, 12, and 24, I guess. And if it is more complex, then it's 36 months.
Now, are you not worried by the fact that to a greater extent they set time frames for their investigations to which they do not comply? And if you are worried, what would you do to improve the situation?
Compliance with timeframes in investigations depends mostly on the complexities of the investigations. You always, let me just, a practical example is the report, if the report needs to be submitted in 30 days, and you are unable to meet that deadline, there's always scope for an extension. So the timeframes that are allocated into investigations, I think they are reasonable because they did the scoping, and I'm not privy to that information that they used to arrive at those timeframes.
Okay, no. My worry is that you are not different from the ones who are actually involved in these delays, because the easy way out is this complexity thing, that is complexity, which I do not understand, because when you have experience, you know that you have dealt with similar investigations, and you would know that this one is complex. And here you are at liberty to set your own time frame. Now, with that experience and with that liberty, still you set a time frame to which that we are not going to comply. I mean, we've investigated these matters before, but still you set a time frame to which you are not going to comply. It means, yeah, we are bringing the same problem if we appoint you, because the same terminology has been used, this complexity thing. And this thing is a threat because you know you have investigated. You know that a delay of an investigation is a threat to a successful investigation, because during the process of a delay, there are many events which intervene. The evidence gets disrupted, some people die, some witnesses. And in many instances, you do not achieve the goal for which you conduct an investigation. So I'm very worried with that response. Very, very, very worried.
It is an objective and a true response. I do not agree with due respect that I would bring or being part of the problem. I am saying It depends on the nature of investigations. That's a reality. We cannot run away from it. You cannot finalize a complex investigation in a day or two. There's no way.
Lastly, can you disagree with the public protector if you are of the view, in terms of your legal knowledge and expertise, that she is determined at making wrong findings? Can you disagree? And if she's adamant, she doesn't take your advice, because the first thing you do, I assume, if you are an objective person, you would go to her and put across your perspective to say, no, you have got it wrong here. And then she gets adamant, she continues with what she wants to do, with what she wants to pursue. What would you do? Thank you very much, Chair, for being patient. Thank you. That was your last
That was your
question.
last question, yeah.
Well, the legal duty on me is to raise my objection or say this is what the law provides. And if the public protector is adamant in doing the wrong thing, then I cannot conceive really of a situation where deliberately you would do something that is illegal. Not in that office. It cannot be.
Thank you, Honorable Tena. You are covered. Honorable Mutao.
Thanks, Chair, for the opportunity. Good afternoon, Advocate.
Good evening.
Advocate, how can the Public Protector South Africa work more proactively to ensure good governance principles are enforced throughout the public service? And then my second question will be, if you can be given an opportunity to be appointed as the Deputy Public Protector, how will you inspire confidence internally and externally in the institution?
Okay. Maybe let me start with the one that is still fresh in my mind, to inspire confidence. The first thing that would need to be done is to come up with a report that will stand the test of time. A report that no one would dare to take to court for a review. That means the report needs to be thoroughly researched, the law correctly interpreted and applied. And that is one way of inspiring confidence in that office. 2 is to engage the stakeholders. You work closely with the relevant stakeholders, find a common ground before even finalizing the report, so that there's a buy-in. And that's one way I would also consider. And of course, is the empowerment of the public, or the members of the public, so that they know their rights and can hold all to account. How would I ensure good governance? Am I capturing your question correctly, Madam?
Mike.
Proactive.
My apology, Chair. How can the Public Protector work more proactively to ensure good governance principles are enforced through the public service?
I think part of your question I have covered in the proactivity in engaging the stakeholders, so that we know you would have memorandum of understanding. You enter into memorandum of understanding with the stakeholders. if you know or there's a remedial action that needs to be taken. That gets discussed with the relevant stakeholder or the party that is being investigated. Make them understand that remedial action is not punitive, but it is corrective in nature. And therefore, it's something that we need to do.
Advocate, in a situation where other state of organs ignores or refuses to implement remedial actions that are given by public protector, what are you going to do?
There is one way to enforce compliance with the remedial action. There's wealth of cases that have confirmed that it is final, it is actually binding. And if it is not set aside, normally there are time frames within which a person has to comply. If that State Department does not comply, notwithstanding due reminders, then the only option that I would have is to go to court, get a court order, and that's how you enforce it. If one does not comply with the court order, you are in contempt of court, you're likely to get a criminal sanction.
How much is the budget of Public Protector's Office in this current year?
It's a lot of money. It's 357,261,000 rand.
When you say it's a lot of money, you mean it's enough resources to execute the mandate of the institution?
Not really. I should have said it's a lot of money that it has never hit my bank account.
Okay. Honorable Zodedzi.
Thanks. By the way, the public protector and the team feel that that's not a lot of money. That's how they feel. If you are appointed, you'll be arriving at an institution and believing that's a lot of money.
No. Let me correct this. I shouldn't have said that. But what I say, it's a lot of money in the sense that it has never hit my bank account. Yeah. But not enough for the public protector.
We were discussing your bank account. So how much has hit your bank account?
That remains confidential.
Okay, thanks. Now, you said, that was on a lighter note, you said that you were representing people who have been evicted from the farms.
Yes.
Was that on the pro bono basis?
Yes, it was.
Okay.
There was a need that arose. Remember, there was an introduction of the Extension of Security of Tenure Act. And shortly, I think it was 1995. And at that time, the people on the farms were evicted in droves. And you would imagine poor people facing a farmer who is able to employ lawyers and against undefended accused or undefended people. Then it was my responsibility to ensure that their rights are protected. And that's how I got involved.
I think that's fine. That's fair. Now, of course, the deputy public protector operates on the basis of the powers that are delegated by the public protector. Which functions would you be comfortable to be delegated by the public protector?
My attitude, honorable member, is I will be joining the public protector to serve the nation to the best of my abilities. I really do not have any preference. Anything that is given to me that needs to be done, I'm there to do it. That's my approach.
So you're basically saying that everything will be fine?
That's anything, let it come. I'll deal with it.
That's fine. Now, the people that we have mentioned, which are poor, that we have been able to represent pro bono, fast forward in 30 years down the line, they are still struggling to access the services of the public protector's office. The sense that is that we are getting in the country is that the focus of this office is more into urban areas. And what kind of intervention do you think that in your inception in office you'll be able to do in order to ensure that these people are also getting their fair share of the services that they need so much from the public protector?
By law, the public protector must be accessible to all. When it comes to the outskirts, the far-flung areas, one way of reaching out to them, there's quite a variety of things that can be done, but is to work through the community-based organizations, make the public protector know, have similar things like Imbizo, I don't know what they would call it in the public protector, but engagements that would make the public protector known and accessible. In some areas, they rely mostly on radios more than televisions. So it's to ensure that you reach those, the radios or systems of communication that will get to them. That is my answer.
Thank you. Advocate Bunguzana, what is your understanding of the jurisdiction of the public protector?
When we talk of jurisdiction, I'm not going to strictly look at the legal definition of jurisdiction, but I take it your answer, your question is about the mandate. That would be the jurisdiction of the public protector, that it investigates at any sphere of government impropriety, the conduct of the organ of state at any level, to investigate and report in that report and that conduct and take a remedial action. That would be the jurisdiction of the public protector.
What is your understanding of the concept, the rule of law, and the concept, the principle of legality? And what is the dialectical relationship between the two?
Let me start with the dialectical relationship between the two. Is that they both, it's about being subject to the law. Any conduct, there must be legal basis for it. So the rule of law, in simple terms, is that everyone is equal before the law, or there's no one who's above the law. That's the rule of law. And it has some elements to it, like that the equality before the law must be accessible, the law must be clear, it must be promulgated through a clear process by the institutions designed to promulgate law. Then the principle of legality is that the action that is taken must be based on law. And the principle of legality is better expressed in Latin terms, the nullum crimen sine lege, which means there can be no crime without law. Another principle is nulla puna sine lege. There can be no punishment without law. So in other words, any legal action you take and the punishment you take must be based on the law. That's the principle of legality.
Advocate Bunguzana, that marks the end of our conversation. We thank you for coming to the interview when called upon. We also thank you for availing yourself to help strengthen the Office of the Public Protector and be part of the public service. We wish you a safe travel back home. Is there anything you want to raise?
No, there's nothing this time.
Okay. Thank you very much. You are excused now. Thank you.
Thank you. Bye-bye.
Members, that then is the end of today's program. It's been quite a long 2 days. Tomorrow we at least have 2 candidates. So it's going to be boo. Then we're done. So we'll meet here tomorrow at 9 for these 2 candidates. Yeah, what else? You want to take forever? Thank you very much, members. The meeting is adjourned.